interim order. Subsequently, it was modified. I filed an application for modification of interim order. My lord had given a date. Matter was come up on matter. My lord had given it as suggested.
Give it. No date. Give it. Bharat.
My lord.
Fresh. My lords, is a
Give the memo.
my lords, fresh
Are you a
matter.
left-hander?
Sorry, my lords.
Hold it in your right hand. Yes.
My lords, it's a fresh matter, my lords.
When?
Last month, my lords. In the
Last
month of
month.
October, my lords.
Monday.
In the month of October, my lords.
Monday.
Light urgency, my lords. Will be
No,
posted for
Monday,
this
give
week,
it.
please, my lords.
Monday, sir.
Lordship, one matter for hearing on IA also. I have filed IA application for seeking interim order.
What interim order?
Stay of the further proceedings before the trial.
ಯಾಕೆ stay ಆಗಿಲ್ವಾ?
On that day, it is not, IA was not filed, that's why.
Give it. ನಾಳೆಗೆ ತಗೊಳ್ಳಿ ಅದು.
Please,
ಅಯ್ಯ ಹಾಕಿರೋದು ನಾಳೆಗೆ ತಗೊಳ್ಳಿ.
please.
Give it.
My lord.
Date.
Investigation, not an abuse.
When was it frozen, madam? It can wait till Monday, right? Give it, yes. No difficulty. Give it, yes. Now immediately after Diwali vacation, it will come. Kodi. Friday, sir. For parted matters, move madbidi. 27th, 7 ಎಲ್ಲ 27th ಕೊಡಿ. ಕೊಡಿ, give it. ಇನ್ನೊಂದು ಯಾವ್ದೋ ಕವರ್ಡ್ ಅಂತ ಒಂದು ಲೇಡಿ ಮೂವ್ ಮಾಡಿದ್ರಲ್ಲ ಅದೇ ತಗೊಳ್ಳಿ. Give it, sir. Give ಅದು ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಹಾಕಿ ಕವರ್ಡ್ ಮಾಡಿ.
Lord, the wife's petition, my lord. The father has
ಅಯ್ಯೋ ಸರ್ ಮಂಡೇ ಕೊಡಿ. ಎಸ್ ಮಂಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅಲ್ವಾ ನಿಮ್ದಲ್ಲ ನಿಮ್ದು ಮಂಡೇ ಯಾವ ಹೋಲ್ಡರ್ ಆದ್ರೆ ಮಂಡೇ ಕೊಡಿ. ಎಸ್ ಗಿವ್ ಇಟ್ ಸರ್. Why you should have moved the other court? If there was so much urgency, you should have moved the other court. Urgency is only here, is it? Then why? That court, have you moved that court? Did you move the other court for 2 days? Illa tane Monday. Give it. Give it, sir.
Wife's petition.
So what if it's wife's petition?
Lord, already habeas corpus was filed by a father.
Give it.
That was
Monday.
disposed of.
Yes.
Thereafter, they filed this particular.
No problem. Monday.
My lord, next week.
Give it.
Compromise petition we have filed.
ಅದು ತಗೊಳ್ಳಿ ಯಾವತ್ ಬೇಕು.
For next week, my lord.
ಸೆಟಲ್ಮೆಂಟ್ ಯಾವತ್ ಬೇಕು ಅಂತ ಬರ್ದ್ ಕೊಡ್ರಿ.
My lord. There is an imminent.
We have written 11th.
Matter pertaining to Dharwad bench. I filed memo.
ಧಾರವಾಡ ಎಲ್ಲ 23rd. Give it.
My lord, there is an
All
imminent.
ಧಾರವಾಡ bench matters on 23rd. Urgency ಇದೆ ಅಷ್ಟರಲ್ಲಿ ಏನಿದೆ?
I filed memo for withdrawal and the respondent.
ವಿಡ್ರಾ ಇಲ್ಲ ನಾಳೆನೆ ತಗೊಳ್ಳಿ. Yes.
My lord, there is an imminent threat of arrest, my lord, in the FIR number.
Why?
For the offenses punishable under 115, 118 of BNS. So as such, there is an urgency in the matter.
ಯಾವತ್ತು FIR ರಿಜಿಸ್ಟರ್ ಆಗಿರೋದು?
FIR it is 99, my lord.
ಬೇಲ್ ತಗೊಂಡಿಲ್ಲ.
September
ತಗೊಂಡಿಲ್ವಾ?
ಅಪ್ಲೈ
ಯಾಕೆ?
ಮಾಡಿದೀವಿ, my lord.
2 months ಏನ್ ಮಾಡ್ತಾ
ಹಾಕಿದೀವಿ,
ಇದ್ದೀರಾ?
petition ಹಾಕಿದೀವಿ.
2 months ಇಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಹಾಕಿದೀವಿ, my lord.
ಬೇಲ್ ತಗೊಂಬನ್ನಿ ಆಮೇಲೆ ತಗೊಂತೇನೆ.
Lord, ನಾಳೆ
ಕೊಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಬಟ್ ನಾಳೆನೂ ಅದೇ ಆರ್ಡರ್. ಬೇಲ್ ತಗೊಂಬನ್ನಿ ಆಮೇಲೆ ತಗೊಂತ.
ನಾಳೆ
Fresh matter.
Give it.
My lord, I'm a senior citizen. 1 crore rupees cash was seized from me. It's in the police station. It's rotting.
Monday.
Lordship, it's a connected matter.
Again, all of you again, what is this? 11 o'clock ವರ್ಗು ಇದೇ ಆಗುತ್ತೆ. No urgency. Please give it, sir. Yeah. What is the problem now? False ಕೇಸ್ಗೂ ಸರ್ಜರಿಗೂ ಏನ್ ಸಂಬಂಧ? ಸರ್, ಫಾಲ್ಸ್ ಕೇಸ್ಗೂ ಸರ್ಜರಿಗೂ ಏನ್ ಸಂಬಂಧ? ಮದರ್ ಇಸ್ ಇನ್ ಕಸ್ಟಡಿ.
Support my lord, my mother.
ಯಾಕೆ ಯಾರು ಇಲ್ವಾ? Who are the accused?
Only one singular accused. The son is the accused. Now, my lord, the company is, my lord, initiating.
So you are trying to shoot on the shoulders of the mother. We'll see. Give it. Monday.
Action, my lord, to remove me, my lord.
Tomorrow. ಅದು ಹೇಳಿ. Tell that. Don't project your mother's illness here. Tomorrow. Tomorrow, sir. Give it.
302, my discharge application is rejected for 302.
Monday.
The charge sheet is filed only for.
No problem. Monday. Yes. All Monday. Give it.
My lord, one,
ಏನಾರ 7 27th. Yes, Monday, next.
my lord, one
Will you
submission,
leave
my
me to
lord.
start? There are 300 matters or just going on like this? Parvaila kodi, yes.
My lord, one submission, my lord.
No submission, yes. No problem, sir. No issues, no tomorrow. Give it, give it. I'd seek adjournment before the trial court. Call the cases. Kodi, ನಾಳೆಗೆ ಹಾಕಿ. Pending matter where there is a stay, then what is the urgency?
Madam.
Have you filed an application for that? File an application, serve on Shanti Bhushan and come. Who has to issue travel permission? You have to travel to the UK. Why are you not allowed to travel? No, if you want quick relief, regional passport office ಮಾಡಿ ಅಥವಾ immigration bureau of immigration ಮಾಡಿ application ಹಾಕಿ. ಇಲ್ಲರ ತಗೊಂಡ್ರು ಉಪಯೋಗ ಇಲ್ಲ. ಅದ್ ಮಾಡ್ಬಿಟ್ಟು ಮೂವ್ ಮಾಡಿ. Doctor's promotion, stay ilva? Stay ilva? Stay ilva? You will get retrospective promotion with all benefits, no urgency. No, nothing. Yes,
My lord, serial number 94, my lord.
no adjournments.
No,
Trying to push me out of the matter.
No adjournments in the morning, yes.
Has been filed, my.
Parvailla,
They are
you don't
trying to
trespass here, sir, saku, next.
Please, tomorrow, my lord.
No, Monday. Next, call the case.
Till number 1.
Petitioner, my lord.
The petitioner is before this court calling in question. Stay application ilva?
It is, I filed the stay application.
Petitioner is before this court calling in question proceedings in so and so as nodkuli. The offences inter-alia are the ones punishable under section 353, 279 read with 34 of the IPC. For the offence to become punishable under section 353, the primary ingredient as held by the apex court in the case of K. Dhananjay versus Cabinet Secretary so and so is that there should be assault. There is no assault or usage of criminal force that is projected in the complaint or in the charge sheet so filed. Therefore, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing. Learned additional SPP accepts notice for both the respondents, posts the matter in admission in his usual course. Next.
Number 2.
A1.
Husband.
Yes.
Correct. Yes. One additional SPP, 2 emergent notice.
Number 3.
Who is in possession?
Lords, survey
Huh?
number 31, we are in possession of the property. my lord.
ಈಗ
RTC has
problem
been,
ಇರೋದು
RTC has been produced.
ಪ್ರಾಬ್ಲಮ್ ಇರೋದು ಸರ್ವೆ ನಂಬರ್ 31 ಅಲ್ವಾ?
Please,
You are in
Part of-
possession of 31.
part of
Learned
the land.
counsel for the petitioner taking this court through the documents appended to the petition seeks to demonstrate that he is in possession of survey number 31, which is the subject matter of the present petition. In the light of the petitioner being in possession, an offence of criminal trespass into his own property cannot be laid. Therefore, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing.
Another case on the similar set of facts has been compromised.
ಪರವಾಗಿಲ್ಲ, ಇದು ಮಾಡ್ತಾರೆ.
Please.
4.
Yes.
Connected matter.
Yeah.
let us stay in this.
ಅದು ಬರಿಬೇಕು. Petitioner is before this court ಅಂತ ಮಾಡಿ ಆಮೇಲೆ.
The complete civil dispute, my lords, the petition.
Connected matter is stay.
Connected matter?
Stay.
There is a stay in a connected matter and the petitioner herein is an agreement holder of a property, my lords. The complainant
Which
claims.
is the connected matter?
12205 of.
0.
You should read the file and come, madam. You are the petitioner. Connected matter is, which is the connected matter ಅಂತ ಗೊತ್ತಿಲ್ವಾ? They heard the learned counsel so and so appearing for the petitioner. The learned counsel submits that in the companion petition and ಮೇಲ್ಗಡೆ tag this petition ಅಂತ ಮಾಡ್ಬಿಡಿ. ಮಾಡಿ, the learned counsel for the petitioner submits that in the companion petition, there is an interim order of stay operating. Even otherwise, the issue in the list stands completely covered by the judgment of the apex court in the case of 2024 SSC online SC page 268. Naresh Kumar versus State of Uttar Pradesh. And the judgment of the apex court in the case of AM Mohan versus so and so 2024 SSC online SC page 339. Therefore, there shall be an interim order of stay of further proceedings by the petitioners till the next date of hearing. Tag aitala mele. And so post the matter in admission in its usual course. Next.
Fine.
Heard the learned counsel appearing for the petitioner. The crime is said to be, the criminal law is said to be, is set into motion on the score of the partnership agreement between the complainant and the petitioners going wrong. For such breach of terms of partnership or otherwise, criminal law cannot be set into motion. Therefore, there shall be post for admission in usual course.
6.
Stay ಕೊಟ್ಟಿದ್ದೀನಿ. ಇನ್ನೇನು ಬೇಕಾ?
I'm for petitioner here. Instead of going for the staying the processing, you are already. It may
Staying
kind
the processing.
staying the proceedings of the trial court, you long. It
You
may
don't
can be
want.
posted for admission.
ಬೇಡವಾ?
It can ill stay in bed or something. I would like to dispose it of at the earliest.
No,
So it may kind of
that earliest will never come.
ಇಲ್ಲ admission post ಮಾಡಿದ್ರೆ
ಮಾಡ್ತೀನಿ.
please.
Stay ಬೇಡವಾ?
ಬೇಡ ಸ್ವಾಮಿ stay ಬೇಡ. I wanted to dispose of at the earliest. ಅಷ್ಟೇ ಅಲ್ಲಿ trial court.
January first week.
Right.
ಓ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಜಲ್ದಿ ಕಾಲ ಮುಗಿಸ್ಬೇಕು ಅಂತನಾ?
ಅಷ್ಟೇ.
HBC.
But 2021 complaint.
ಹೌದು.
It's a clear case for stay. What is this? 2013 incident, 2018
ಬೇಗ
complaint.
ಮುಗಿಸ್ಕೊಳ್ಳೋಣ ಅನ್ನೋದು ನಮ್ಮ ಅಭಿಪ್ರಾಯ.
ಅಭಿಪ್ರಾಯ. ನಿಮ್ಮ ಅಭಿಪ್ರಾಯಕ್ಕೆ ನಾವು ಏನು ಅಡ್ಡ ಬರುವುದಿಲ್ಲ.
ಅಲ್ಲ ಅದಕ್ಕೆ ತಮ್ಮ ಮುಂದೆ ನಮ್ದೊಂದು ರಿಕ್ವೆಸ್ಟ್ ಅಷ್ಟೇ.
ಆಯ್ತು. The petitioner has preferred the subject petition calling in question proceedings in CC 31042 of 2022. Though the prayer that is made is for quashment of the entire proceedings in CC so and so, the learned counsel would restrict her prayer to a direction to the concerned court for an expeditious disposal of the case. The issue in the list relates to the year 2013. The crime is registered after 5 years in the year so the incident comes to light in the year 2018. Crime is registered on 21/12/2021. The 2021. Therefore, there is gross delay in registering the crime. These factors also shall be borne in mind by the concerned court while concluding the proceedings. In that light, the proceedings shall conclude before the concerned court. The concerned court shall endeavor to conclude the proceedings with an outer limit of 6 months, if not earlier. Yes, ordered accordingly.
Much obliged.
Yes, ma'am.
7.
Civil dispute between the parties is given a criminal cover.
Howda? Which color?
Criminal cover by lodging.
Criminal color. In the meantime.
Connected, it has to be connected with this.
Tag the
Another one
petition.
petition is there.
Number kodi.
Criminal petition number 3259 of 23.
So and
And
so.
WP 1791921 of 21.
Yes, tag the petition along with so and so. Additional SPP is ready than what you are. ನೀವು ready ಇರ್ಬೇಕಲ್ಲ.
8.
Release of cows. ಯಾವ ಸ್ಟೇಟ್ ಅಲ್ಲಿ ಇದೆ?
ಮಹಾರಾಷ್ಟ್ರ ಇಲ್ಲಿ ಬಟ್ ಇಲ್ಲಿ ತುಮಕೂರು ಹತ್ರ ಸೀಸ್ ಮಾಡಿರೋದು. They are the farmers. I have produced the.
ಫಾರ್ಮರ್ಸ್ ಗೊತ್ತಾಯ್ತು. ಈಗ ಹಸು ಕರೆಕ್ಟ್ ಪಿಂಜರಪೋಲ್ ಇಟ್ಟಿದ್ದೀರಾ ಅಥವಾ ಹಂಗೆ ಇಟ್ಬಿಟ್ಟಿದ್ದೀರಾ?
Verify.
The learned additional SPP is directed to accept notice for the respondent, secure instructions with regard to the cows that were seized in the vehicle being kept in Pinjarapole or have been left high and dry. List this matter on next Monday. List this matter on 11th in the fresh matters list. Avat bidu. Yes. Next.
9.
For the petitioner. In fact, for the secretary of this club.
Huh?
Is it some disciplinary inquiry?
Mike, please.
Due to the disciplinary inquiry, this complainant was suspended from the club committee. As a contrast, she filed a case.
354, sir.
No, only allegation in the complaint is that when she went into the secretary's office to complain her grievance,
Go
he
to page 19, sir.
she has been pushed out. In fact,
Pushed out.
of the secretary's chamber, she went to
Why
make
did you
a
push her out?
grievance. He made a grievance.
Why did you push her out?
No, it's not correct. It's an open place. In
No,
fact,
that's
not a
the-
closed chamber.
That's after investigations.
or this stage, in fact, they were supposed
One
to
additional
compromise.
SPP, two emergent notice.
Kindly till then,
No, sir.
in fact, even in the complaint or the statements made by the other persons present, they have not said, they said, without considering she is a woman, she was asked to go out of the room and held her shoulders and.
Very go out and there.
Alla,
You have held her shoulders, pushed her.
that is a
Touched
bare.
inappropriate.
And
That's
she is coming to the chambers of the secretary. He is not.
She should not come.
No, she had expressed her grievance
Ah.
and dispute is only regarding the suspension. Now he is also ceased to be a secretary. She also ceased to contest the elections.
No, Burley will see.
They wanted to compromise the matter in between. They are not. She is not appeared before the trial court.
If she doesn't come,
Kindly till then.
next date, if she doesn't come, we will grant.
In fact, the matter is listed for charge. So
No problems.
kindly till then.
Is the charge.
Kindly till
You
then.
can't push a woman touching her inappropriately, never.
No, it is. In fact, it's a complaint. In fact, after 21 days
Not
of
the
the
complaint,
incident.
sir. Charge sheet.
No, 30th is the suspension. Second, she says the incident happened. On 23rd, after 21 days, the complaint. There's an inordinate delay.
Not fatal. It is not inordinate.
I
It
would
is
not
just
say
delay.
fatal, whether it was a
It is
true
just
incident. Immediately, 21 days delay is there.
Sir, stay ಕೊಡೋದು ನಾನೇ ಕೊಡ್ತೀನಿ.
Kindly till then.
No,
The matter would be.
not in cases where women are treated badly. Yes.
No, it is. In fact, she says she's been told she's a Tamilian and so on and so forth. That is the
Okay.
allegation. This is not true, in fact.
No.
And they have been at the. It is an official thing.
ಇಷ್ಟೊಂದು ಹೇಳೋ ಅವಶ್ಯಕತೆನೇ ಇಲ್ಲ, sir. I have not
I
disputed.
would not consume much of the time. Court is
Even I would not
heavily on
let
the
you
list.
consume so much time if it was a case.
Kindly till the next date. I would only request that.
One additional SPP to emergent notice returnable by the 27th of November. In the event that she doesn't appear on that day, we'll grant.
Correct.
Yes. Why freezing? Nimdala, next.
Literally, they allowed the defreezing of pension account. Only fixed amount has been
I have allowed it.
allowed.
Who has allowed?
Revision court allowed the.
One at the additional SPP is directed to accept notice for the respondent. Next.
11.
It's also 457.
451, 457 rejected. Learned additional SPP is directed to accept notice for the respondent. Yeah, ಇಷ್ಟೊಂದು respondents ಇದಾರ. For respondent, one emergent notice to the remaining respondents.
12.
Petition. In the meantime, next.
The A1 man.
So, yes.
13.
13. 420. 424, not 6, 506.
Yes.
Civil matter.
Civil matter.
Civil
A
matter.
civil matter. Yes, Jagdish. Delay of 3 years.
Yes, sir.
Meantime.
14.
14, my lord, charge sheet has been filed.
Liberty. JY. Order bottle. Yes.
15.
Split charge, huh?
15, my lord. Yes,
15 Latif.
Filing withdrawal memo.
Abated.
Acquitted.
Petition
Abated.
Abated. In terms of the memo, disposed as having been abated. Next.
16.
For the petition, 14, my lord, B report.
2, 3, huh?
B report.
B report. B report format.
17.
The petitioner is before this court calling in question so and so. The learned counsel for the petitioner taking this court through the documents appended to the petition would seek to demonstrate that the petitioner is not involved in the day-to-day affairs of the company and therefore the proceedings under section 138 of the Negotiable Instruments Act could not have been initiated against the petitioner. A perusal at the documents would vindicate his submission. Therefore, there shall be an interim order of stay of further proceedings by the petitioner before the concerned court till the next date of hearing. Yes, post the matter in admission in the usual course. Emergent notice to the respondent.
18.
39 application is filed and pending before trial.
Even otherwise, BDA documents forged, no case for interference. No representation behalf the petitioner list after 4 weeks. Registry is directed not to list the matter prior to the expiry of 4 weeks. Next.
19.
Police allowed.
17.
Allowed. 155 non-compliant.
Madam,
155
19.
is not compliant.
19.
19. The heard the learned counsel appearing for the petitioner and the learned additional SPP. The petitioners are accused 4, 12, 18 and 19 in CC 564 of 2023. The crime is registered against these petitioners along with others for offences punishable under section 79 and 80 of the Karnataka Police Act. The learned counsel for the petitioner submits that the offences under section 79 and 80 are non-cognizable. And for a non-cognizable offence, prior to the registration of the crime, nod of the magistrate was imperative. The learned additional SPP on verification of the records would admit that no permission was even sought at the hands of the learned magistrate prior to registration of the crime. The issue in the list stands answered by the judgment of the coordinate bench in the case of Vagepa so-and-so 2020, ILR 2020 Karnataka page 630. The court in the light of the issue standing completely answered by the coordinate bench in the aforesaid judgment dealing with an identical fact circumstance, the petition deserves to succeed and for the aforesaid reasons allowed quashed. Next.
I am for the petitioner, madam.
This is with regard. Charge sheet ಹಾಕಿದ್ದಾರೆ ಚಾಲೆಂಜ್ ಮಾಡ್ಬಿಡಿ ಚಾಲೆಂಜ್ ಮಾಡಿ ಮೂವ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ವಿಡ್ರಾ ಮಾಡಿದೆ ಅಂತ ಹೇಳಿ
Please,
2:30 I will take it. This is a matter to be stayed.
please,
Yes. Only to complete the formality of challenging the charge sheet.
please.
Yes, format.
21.
Charges were framed on 12/8/2024.
Even otherwise, all offences found. 307. List after, no representation, list after 4 weeks, registry is directed. Both of you.
22.
Driver,
May be granted.
Huh?
1 week time.
1 week, 4 weeks ಕೊಡ್ತೀನಿ ಬಿಡಿ. Driver,
Driver.
driver.
ಇದರಲ್ಲಿ I am the accused number 2, madam. Petitioner is the accused number 2. ಲಾರಿ ನಮ್ದು ಲಾರಿ ಇದೆ.
ಅಲ್ಲ ನಿಮ್ದು ಲಾರಿ ಡ್ರೈವರ್ ಯಾರು?
ಅಲ್ಲ ಡ್ರೈವರ್ ಕಮ್ ಓನರ್ ನಾ. ಇದರಲ್ಲಿ ಕಾರ್ ಡೋರ್ ಓಪನ್ ಮಾಡ್ತಾರೆ ಕೇಕ್ ಮನೆ ಹತ್ರ ನಿಲ್ಸಕ್ಕೆ. ಡಿಸೀಸ್ಡ್ ಕಾರ್ ಡೋರ್ ಡಿಕ್ಕಿ ಹೊಡ್ಕೊಂಡು ನನ್ನ ಟೈರ್
ಮ್ಯಾಟರ್ ಆಫ್ ಎವಿಡೆನ್ಸ್ 482 ಬರಲ್ಲ ಅದ. ಎಸ್ ಟೈಮ್ ಬೇಕಾ?
ಇಂಟ್ರೀಮ್ ಸ್ಟೇಕ್
ಫಸ್ಟ್ ಟೈಮ್ ಕೇಳ್ಬಿಟ್ಟು ಆಮೇಲೆ ಇಂಟ್ರೀಮ್ ಸ್ಟೇಕ್. Yes, list after 4 weeks at the request of the counsel appearing for the petitioner. Next.
23.
No representation. Adu one round it. No representation, 4 weeks, not 2. Next.
24.
KV Narasimhan. KV Narasimhan. Vishnumurthy. ನಿಮ್ಮ ಹೆಸರು ಗೊತ್ತು, ನೀವು ಯಾವ KV Narasimhan ಆದ್ರೆ ಅವ್ರು ಬಂದಿಲ್ಲ. Yes. Same 4 weeks.
25.
Charges were framed on 6/2/6/2024.
Even otherwise, horrible case.
Page
No
8.
representation, 4 weeks.
26.
Heard the learned counsel appearing for the petitioner. The petitioner is before this court calling in questions also.
Submission, my lord.
Ah.
You're for the respondent number 2 in this case, my lord. They have not been served the petition copy.
ನಾನು ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ ಇನ್ನು. ಅಡ್ವಾನ್ಸ್ ಕಾಪಿ ಕೊಡಕ್ಕೆ ಎಲ್ಲಿದೆ ಪ್ರಾವಿಷನ್? ಕೇವಿಟ್ ಹಾಕಿದ್ದೀರಾ?
Filed our wakalat, my lords.
ವಕಾಲತ್ತ
Avinash.
ಬಂದಿದ್ದು ಫಸ್ಟ್ ಟೈಮ್
Coming up for the first time, they have filed it.
Why did you file wakalat? Bank asked you to file wakalat.
Not date by next week, please.
No problem. Petitioner is before this court calling in question proceedings in CC so and so registered for offences punishable under section 406, 420 and 465 of the IPC. The complainant is bank ala.
Please.
The complainant is the bank. After having initiated proceedings under the Surface C and section 138 of the Negotiable Instruments Act for the dishonor of the check comes the impugned crime for the very same offences and on the very same set of facts. Therefore, there shall be an interim order of stay of further proceedings qua the petitioners.
130 it has not been filed, madam.
Agli check ಕೊಟ್ಟಿಲ್ವಾ ನೀವು?
Their allegation is that I have not paid check to my
That's all
my
right. So
vendor.
and so. Surface initiate ಮಾಡಿಲ್ವಾ?
surface ಮಾಡಿದ.
Surface ಮಾತ್ರ ಮಾಡಿ. Till the next date of hearing. List the matter on, when do you want, madam? What's the matter on 28th November? Yes. Please. Next.
27.
Charge sheet has been filed.
338 fracture. Charge sheet format, Liberty.
28.
For the petitioners.
Heard the learned counsel Shanti Bhushan appearing for the petitioner. The petitioners are accused so and so. The 1 and 2, the husband and the mother-in-law. A perusal at the summary of the charge sheet as obtaining under column number 17 would indicate minor skirmishes that happen between the husband and the wife is sought to be projected to become a crime under section 498A of the IPC inter-alia. Against the mother-in-law, there is not even a speck of ingredient of the offense. Even against the husband, it would not meet the ingredients of section 498A. Permitting further proceedings against these two would run foul of the judgment of the apex court in the case of Kailas Ben so-and-so, 2024 SSC online SC page 2621 and Chin Gupta, 2024 SSC online SC page 759. Therefore, there shall be an interim order of stay of further proceedings by the petitioners till the next date of hearing. One additional SPP 2 emergent notice post for admission in the usual course.
Great.
Next.
Charge sheet has been filed.
Charge sheet ಹಾಕಿದೆ.
Petitioner.
ITP sir.
Owner.
ITP owner ಚಾನ್ಸ್ ಇಲ್ಲ.
Done by the accused number 2, my lord, license is in his name, her name.
Trade license in his whose name sir? ಯಾರ ಹೆಸರಲ್ಲಿದೆ ಸರ್?
A2.
ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಚಾಲೆಂಜ್ ಮಾಡಿ. ಚಾಲೆಂಜ್ ಮಾಡಿ.
Challenge ಮಾಡಿದ್ವಿ.
FIR ಚಾಲೆಂಜ್ ಮಾಡ್ರಿ ಸರ್. ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿ. ಫಾರ್ಮ್ಯಾಟ್ ಕೇಸ್.
Taxi council kindly next week, my lord.
ಅವ್ರಿಗೆ ಹೇಳಿ ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಕ್ಕೆ ಲಿಬರ್ಟಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಚಾಲೆಂಜ್ ಮಾಡ್ಲಿ, ವಿಲ್ ಕನ್ಸಿಡರ್. ಕುಮಾರ್ ಗಲ್ವಾ? ಹಾ ಹೇಳಿ ಕುಮಾರ್. Yes.
30.
I beg to appear for the petitioner. What is the
499.
company is not made a party, my lords, and I am nobody in the company.
ಯಾವ್ದು ಕಂಪನಿ ಸರ್?
Company, my lords, will find.
499 500 ಅಲ್ಲಿ ಯಾವ ಕಂಪನಿ ಸರ್?
My lords, the allegation
It's
is
defamation and where is the company coming?
My lords, they say that a particular channel by the name of Praja TV has published certain material. So what he does is he makes Praja TV as a party, but does not attack the company, the owner being Samparka Infomedia Private Limited, my lord, at page 55. And even, my lords, otherwise in the master data, I'm nobody. He says I'm the administrator. He
Who's the
claims I'm the
administrator?
administrator. Well, he claims I'm the administrator of Praja TV, which is not even a juristic entity. The owner, my lord, will find at page 55 annexure D, I have placed all the documents on record.
Yes. Where is my judgment? There is no vicarious liability even in these cases.
My lord's judgments are there, in fact, in 3-4
Judgments
matters.
are there, but one could illa dismiss it now. You take this judgment. Huh? Judgments are there and you can't keep it on your table, sir.
My lords, I bow down, my lords.
Yes.
I'm sorry, I'm not there
Heard
physically,
the
my
learned
lords.
counsel appearing for the petitioner. The offence is the one punishable under section 499 500 of the IPC. The petitioner is accused number 3. The learned counsel for the petitioner seeks to project that the petitioner is made an accused while the company which runs Praja TV is not made an accused. The issue in the list stands answered by the judgment of the apex court in the case of what? ಎಲ್ಲ ಇದೆ ಅಂದ್ರಲ್ಲ, ಒಂದಾದ್ರೂ ಹೇಳಿ. ಏನು ನೋಡಿಲ್ಲ. In the case of Ivaco so 2024 2 SEC page 86. Yes. Next. Therefore there shall be an interim order of stay so till the next date of hearing.
Much obliged, my lords. Thank you.
Where for the petitions.
Husband ಇಲ್ಲ madam. A2 and A3 I will grant. Heard the learned counsel Srimati Shweta Anand appearing for the petitioner. The petitioners are accused 1, 2 and 3 are charged of offences punishable under section 498A inter-alia. A perusal at the summary of the charge sheet as obtaining in column number 17. One నిమిషం. in column number 17 of CC 416 of 2024 would not indicate even a speck of ingredient of offences punishable under 498A, where accused 2 and 3, permitting further trial against accused 2 and 3 would run foul of the judgment of the apex court in the case of Kailas Ben so-and-so, 2024 SSC online SC page 2621. Insofar as the husband is concerned, the interim order would be considered after the appearance of the wife. One additional SPP, 2 emergent notice returnable by 4th December. Yes.
32.
And stay of this,
Madam,
stay of proceedings against these.
A to A3 ಕೊಟ್ಟಾಯ್ತು. Husband ಮಾತ್ರ 4th will consider. Heard the learned counsel Srimati Revati Adinatha Narade. The petitioners are before this court calling in question so and so. On the same cause of action,
Case and count.
on the same cause of action, the complainant has instituted.
I didn't get it, my lord. There's a
Same- on the-
civil
on the
dispute,
same
my lord.
cause of action, a civil suit between the parties is pending in OS 430 of 2020. Notwithstanding the same, the criminal law is being set into motion on a issue which is purely civil in nature. Therefore, there shall be an interim order of stay.
My lord, it may be also connected with the other criminal petition where the complainant,
Case
the
and
complainant is, that is 4836 of 24, my lord.
Tax so and so post for admission in its usual course.
Obliged.
Next, ಅದ್ರಲ್ಲಿ
Yep.
stay ಇದೆಯಾ?
ಅದ್ರಲ್ಲಿ stay ಇದೆ, my lord.
ಇದರಲ್ಲೂ stay ಕೊಟ್ಟಿದ್ದೀನಿ.
Stay of proceedings.
ಕೊಟ್ಟಿದ್ದೀನಿ.
33.
ರಥಿ ಹತ್ರ
ಸತ್ಯ.
ಏನ್ ಬೇರೆ ಏನ್ ಇರ್ಲಿಲ್ವಾ ಚಾರ್ಜ್ ಮಾಡಕ್ಕೆ?
Page 19,
ಪೇಜ್ 19 ನಾನು ಹೇಳಿದ್ದು. ಬನ್ನಿ.
11th line from bottom. ಕೆಳಗಡೆಯಿಂದ 11.
ಯಾಕೆ ಸರ್? ಯಾಕೆ ಅಡ್ಡ ಬಂದ್ರಿ ಮಾನ್ಯ ಶಾಸಕರಿಗೆ? ಮೇನ್ ಟೈಮ್ ಎಸ್ ಒನ್ ಅಡಿಷನಲ್ ಅದು ಜೈ ಒನ್ ಅಡಿಷನಲ್ SPP to emergent notice. Yes.
34.
What's the FSL report? It's against you or in your favor?
It is against, but so far as A1 is concerned.
You are-
A2, there's no room. He has no interest also in the concerned properties. He's only accounts. A1, my lord, I understand, I don't have.
The petitioners are accused 1 and 2.
Yes,
FSL against both?
Against
only A1.
Heard the learned counsel appearing for the petitioner. The issue relates to forgery. The instrument was sent to the FSL. The report of the FSL is against accused number 1. Therefore, there is no question of staying further proceedings qua accused number 1. Insofar as the accused number 2 is concerned, neither the complaint nor the summary of the charge sheet or the FSL has any ingredients of the offence. Therefore, there shall be an interim order of stay only against accused number 2 till the next date of hearing. Post the matter in admission in its usual course, one additional SPP to emergent notice.
35.
Heard the learned counsel appearing for the petitioner. The offences alleged are the ones punishable under section 406 and 420 of the IPC. The two cannot go hand in hand is the judgment of the apex court in the case of Delhi Race Club so and so 2024 SSC online SC page 2248. Therefore, there shall be an interim order of stay of further proceedings square the petitioners to the next date of hearing. One additional SPP to emergent notice.
36.
charge sheet has been filed in this case.
Challenge ಮಾಡಿ. Challenge ಮಾಡಿ move ಮಾಡ್ಬಿಡಿ.
Yes.
37.
In this case, 87.
87 KP Act.
Okay.
155 compliance ಇಲ್ವಾ?
ಮಾಡಿದ್ದಾರೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ. ಚಾರ್ಜಸ್ ಆಲ್ಸೋ ಫ್ರೇಮ್ ಮೇಲೆ.
ಮತ್ತೆ ತುಂಬಾ ಲೇಟ್. ಎಲ್ಲ ಅಲ್ಲೇ ಅರ್ಜ್ ಮಾಡಿ ಎಕ್ವಿಟ್ ಆಗ್ಬಿಡ್ತೀರಾ. I will direct 3 months ಅಲ್ಲಿ ಕನ್ಕ್ಲೂಡ್ ಮಾಡಕ್ಕೆ.
A1 to 7 and 11 to 24 are pleaded guilty.
Okay, get over there only. The petitioner is before this court calling in question Proceedings in CC 343 of 2020, registered for offences punishable under section 87 of the Karnataka Police Act. The learned additional SPP on instructions would submit that error.
A 1 to 7,
Hmm.
11 to 14.
Perkondra. So have pleaded guilty before the concerned court. The issue lies in a narrow compass. Since charges are framed and the trial is on, I deem it appropriate to direct the concerned court to conclude the trial in CC 343 of 2020 with an outer limit of 6 months from the date of receipt of the copy of this order, if not earlier, ordered accordingly. All contentions remain open. Next.
Another connected matter is the 80 of 24.
ಇದೆಯಾ ಇವತ್ತು?
ಇಲ್ಲ next week.
ಬರ್ಲಿ ಬಿಡಿ. ಬಂದಾಗ
Date ಕೊಟ್ರೆ
ಸೇಮ್ ಅದು ಮುಗಿಸ್ಕೊಂಡು ತಗೊಳ್ಳಿ.
ಅಲ್ಲಲ್ಲ
ಅದು
87
230 87 ಅಲ್ವಾ?
ಅಲ್ಲ
ಮತ್ತೆ
ಅದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಂಡ್ ಪೊಲೀಸ್ನವರು ಹ್ಯಾಂಡಲ್ ಮಾಡಿದ್ರು ಅಂತ.
ಏನ್ ಒಫೆನ್ಸ್ ಅದರಲ್ಲಿ?
ಅಫೆನ್ಸ್ ಇಸ್ ಅಂಡರ್ 353 332 ಆಫ್ IP.
ಬೇಡ ಅದ್ ಬರ್ಲಿ ಬಿಡಿ, ಸೆಪರೇಟ್ ಆಗಿ.
ಸಿಂಪಲ್ ಇಂಜುರಿ.
ಸ್ಟೇ ಇಲ್ವಾ?
ಸ್ಟೇ ಇಲ್ಲ, ಅದಕ್ಕೆ ಬಂದಿಲ್ಲ, ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ಬೇಕು.
ಮಂಡೇ ಬರುತ್ತೆ ಬಿಡಿ. ಮೂವ್ ಮಾಡಿದಿರ ನೀವು?
ಮಾಡಿದೆ, ಬಂದಿಲ್ಲ.
ಬರ್ಲಿ, ಮಂಡೇ ಬರುತ್ತೆ. ಎಸ್.
38.
ಹಸ್ಬೆಂಡ್ ಇಲ್ಲ ಬೇರೆಯವ್ರಿಗೆ ಮಾಡ್ತೀರಾ? ಹಸ್ಬೆಂಡ್ ಇಲ್ಲ ಬೇರೆಯವ್ರಿಗೆ.
ಸೀರಿಯಲ್ ನಂಬರ್ 38 ಮೇಲೆ
ನಾಯಕ್ರೆ
ಸ್ವಾಮಿ
ಎಲ್ಲಿ ಇರೋದೇ ಇಲ್ಲ ನೀವು?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಎಸ್, ಹಸ್ಬೆಂಡ್ ಕೊಡಲ್ಲ ಬೇರೆಯವ್ರಿಗೆ. ಎಸ್
39.
39 ಇದು ಕುಮಾರ್ ಅದು MTP. STP
ಅಲ್ಲ MTP.
ಸರ್, STPಗೂ MTPಗೂ ತುಂಬಾ ವ್ಯತ್ಯಾಸ. ಮೆಡಿಕಲ್ ಟರ್ಮಿನೇಷನ್ ಆಫ್ ಪ್ರೆಗ್ನೆನ್ಸಿ
Similar.
ಕೊಡಿ.
Stay was granted.
6576 of 20.
The petitioners are these 6-7 in English.
ಬಟ್ ಇದೆಂಗ್ ಸ್ಟೇಯಿಂಗ್?
ಅಲ್ಲ ಸ್ಟೇ ಮಾಡಿಲ್ಲ.
6576 ಅಲ್ಲಿ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀನ? Tag these petitions along with so and so, list them all in the fresh matters list on Wednesday.
Stay.
No, avat
40.
husband addition, partly allowed. ಬರ್ಲಿ, day after tomorrow. Husband, one additional SPP, 2 emergent notice. Next.
41.
Petition. Promise to marriage 417 and 419.
376 ಇದೆಯಾ?
376 ಇದೆ.
417, 420.
419.
419. The petitioner is ಎಷ್ಟು ಜನ ಇದ್ದೀರಾ?
ಒಬ್ಬರೇ.
The petitioner is accused who is said to have had a relationship with the complainant. The relationship was physical and the allegation is that it was on the promise of marriage. The promise of marriage having been breached by the petitioner has resulted in the impugned proceedings. Breach of promise of marriage would not result in offense of cheating is by now settled principle of law. Therefore, there shall be an interim order of stay. So and so till the next date of hearing. ಮತ್ತೆ ಯಾಕೆ ಹಾಕಿದ್ದಾರೆ? ಇದೆಲ್ಲ ಸೇರ್ಸ್ ಮಾಡಿ ಹೋದ್ರಲ್ಲ ಈಗ ಕುಮಾರ ಕೆಜಿ ಇತ್ತಾನೆ. ಹೇಗೆ ಪ್ರಕಾಶ ಹಸ್ಬೆಂಡ್ 498. ಭುವನೇಶ್ to FIR stage, charge sheet. You can stay ಕೊಟ್ಟಿದ್ದಾರೆ. Yes. SBI, similar order by ಕೊಟ್ಟಿದ್ದೀನಾ?
Companion orders.
Number, order.
8258.
order. Annexure ಮಾಡಿಲ್ವ order?
ಇಲ್ಲ, annexure
I will dismiss it then. Annexure ಮಾಡಕ್ಕೆ ಏನು order?
ಆರ್ಡರ್ ಮಾಡಿದೆ. Before the interim order.
ಆಯ್ತು, ಈಗ ಮೆಮೊ ಇಲ್ಲದೆ ಎಂಟ್ರಿ ಮಾಡೋ ಜೊತೆ
ಅಲ್ಲ,
ನಿಮಗೆ ಅವ್ರಿಗೆ ಸರ್.
ಅಲ್ಲ,
Where is the memo? Huh? Heard the learned senior counsel G. Krishnamurthy appearing for the petitioner. Number is
8258 of 2024.
same order.
96 same. ಇದು DGM AGM ಅಷ್ಟೇ.
Reach ಆಗಿ. Yes.
43.
B report.
Yes. 43 melons, filing withdrawal melons. In terms of the memo.
44.
2 to 4.
406, 420. No case.
Civil dispute, they are mediators.
Mediators.
Not accused number one.
Petitioner is before this court calling in question proceedings in CC 4028 of 2022 for offences punishable under section 406 and 420 inter-alia. The perusal at column number 17, summary of the charge sheet would not indicate the ingredients of those offences qua the petitioners. Therefore, there shall be an interim order of stay qua these petitioners to the next date of hearing. Post in admission usual course.
35.
Mother and son. Mother and son.
No, madam.
Then
They're different, ma'am, different.
complainant yaru.
Complainant, she's my vendor, ma'am. Vendor's daughter, ma'am.
ಕೊಡಿ ಮೇಡಮ್. ಇದು ಎತ್ಕೊಳ್ಳೋದು ಕಷ್ಟ ಇದೆ.
Using their husbands who was a
Yes, sir.
Yes. In this case, my lord, the petitioner, first petitioner, my lord, has purchased the property way back in the year 2022, my lord, July 2022. And after 2 years, my lord, the daughter of my vendor has complained stating that the property which has been purchased by the petitioner
In the
is
meantime,
to a lesser price, man.
in the meantime, next.
46.
Heard so and so, same order in the meantime, and for the petitioner. Land dispute, yes.
47.
8, sir, next.
47.
Protest petition dismissed.
Please, ma'am.
ಯಾಕೆ appear ಆಗಿಲ್ವಾ?
Theft from the police station, ma'am.
Theft from police station.
Please, ma'am.
Yeah,
Police have
Drishyam
seized
4.
Police have seized the materials, my lord.
ಹಾ,
This respondent thefted from police station.
ಅಲ್ಲೂ ಬಿಟ್ಟಿಲ್ವಾ ನೀವು? Yes, sir,
notice has to go.
to the police station, yes. Additional SPP is directed to accept notice for the first respondent. Complainant ಅವರೇ ಅಲ್ವಾ? 2, 3 and 4 ಯಾಕೆ ಮಾಡಿದೀರಾ?
My lord, ಅವ್ರು accused ಆಗಿದ್ರು.
So ಅದು ಯಾಕೆ ಮಾಡಿದ್ರಿ?
ಅವರೇ
ನೀವು
theft ಮಾಡಿದ್ರು.
complainant ಅಲ್ಲ, sorry.
ಹೌದು.
1 additional SPP, 2, 3 and 4 emergent notice. Next.
5, my lord.
5.
Please.
ಎಲ್ಲರೂ
Respondent number 5,
ಉಳಿದವರಿಗೆಲ್ಲ emergent
2
notice.
2. Please. 8 for petitions.
50,
48.
447.
My lord, 440, please, my lord.
ಹಾ,
My lord, civil dispute is pending, my lord.
ಪೊಸಿಷನ್ ಯಾರಿದ್ದಾರೆ?
My lord, there is a dispute going on, my lord.
ಪೊಸಿಷನ್ ಯಾರಿದ್ದಾರೆ?
Daughter of the complainant, my lord.
Yes. Additional SPP, emergent notice to the second respondent. Next,
My lord, in the meantime, my lord, kindly see the complaint, my lord.
maybe. Let the complainant come.
Please.
Settle ಆಗುತ್ತೆ ಬಿಡಿ, ತೊಂದ್ರೆ. Yes.
Krishna, please. Connected matter, my lords, so please to stay.
Number
2785 of 24.
ಬರ್ಕೊಂಡ್ರ?
Oblige.
Husband,
Petitioner, 498 AM.
husband,
Husband.
Only omnibus allegation made against him. my lord,
Omnibus
and
husband.
2021 only
that,
charge.
column number 17
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಾ?
2021.
charges are framed.
ಅಲ್ಲೇ ಮಾಡ್ಕೊಳ್ಳಿ. ಮೀನಾಕ್ಷಿ ಬಾಲ.
Notice may be issued, my lord,
ಬೇಡ
kindly.
ಸರ್. ಅಲ್ಲೇ ಎಲ್ಲ ಮಾಡ್ಕೊಂಡು.
No,
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿ 4 ವರ್ಷ ಆಗಿದೆ.
yes, my lord. Yeah, there is some delay, my lord, but framing of
Inordinate.
complaint is also made as a retaliatory measure, my lord, after a legal notice is
Will
issued.
get acquitted.
Yeah.
Did you?
Admittedly, for 3 years, they have resided separately.
No problem.
Notice may be issued, my lord,
No,
to the
sir.
respondent kind.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿ 4 ವರ್ಷ ಆಗಿದೆ. ನೋಟಿಸ್ ಅಲ್ಲಿ ಇಶ್ಯೂ ಮಾಡೋದು. Next, yes.
A direction for expeditious
That will
disposal,
see.
at least, my lord.
At this
kindly.
juncture, one para ಬರ್ಕೊಳ್ಳಿ. At this juncture, the learned counsel submits that the court be directed to conclude the proceedings within a time frame. In the light of the issue being of the year 2020, I deem it appropriate to direct the concerned court to conclude the proceedings within 6 months, if not earlier. Next.
Grateful.
P1.
Same teacher, entry order ಕೊಡಿ. Tag, same order. ಇದೆಲ್ಲ ಸುಮಾರು ಅಕ್ಯೂಸ್ಡ್ ಇದ್ದಾರೆ. ಅಲ್ಲ, ನೀವು 1994 ಅವಾಗ ಆಗಿರೋ ಸೆಲೆಕ್ಷನ್ ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ತಪ್ಪು ಅಂತ 2024 ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರಿ.
ಅಲ್ಲ, the complaint came, issue may not popped up later and then they.
What issue popped up after 30 years, sir?
Mask card itself is fake mask card.
No, that's all right. After 30 years, what have you now sought? ನೀವು ಸುಮ್ಮನೆ ಇಲ್ಲ. 30 ವರ್ಷ ಆದ್ಮೇಲೆ 30 ವರ್ಷದವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? Can you exhume everything and put the clock back to 30 years and bring these people and books? They are retired. ಕೆಲವರು 70 ವರ್ಷ ಆಗಿದೆ.
That's correct. No,
ಅವ್ರನ್ನೆಲ್ಲ ಈಗ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ಗೆ ರಿಜಿಸ್ಟರ್ ಮಾಡಿ ಮಾಡ್ಬೇಕಾದ್ರೆ ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
the fact that they have
If it comes to light after 20 years, 2044 ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ತೀರಾ? ಇದೇ ಮಾಡ್ತೀರಾ? Yes.
But also that we should not put a
Premium. Putting a premium on delay, sir, not on their acts.
their act, my lord, has to be.
You, sir, act should some 94 ಅಲ್ಲಿ ಯಾವ ಮಾಸ್ ಕಾರ್ಡ್
That's
ಅವಾಗ
correct.
ಆಯ್ತು.
That's correct.
2024 ಅಲ್ಲಿ you found on somebody's complaint. ಅದು ಇವ್ರು ಇಶ್ಯೂ ಮಾಡಿದಾರ, ಯಾರು ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ, ಏನು ಒಂದೂ ಇಲ್ಲ, ಎಲ್ಲರಿಗೂ ಕ್ರಿಮಿನಲ್ ಕೇಸ್.
ಅಲ್ಲ, they have produced it and obtained the employment.
ಯಾರು 1994 ಅಲ್ಲಿ.
Lord, it is not the case that we have produced fake documents or fraudulent. They have cross-verified with the university. University has certified that this is the authenticated certificate.
Which university?
Mysore University.
Serious. Less said the better. It's all right. Yes. Same order. Tag.
P2.
Customer.
Customer.
ಗೊತ್ತಾಗ್ತ ಕೆಜಿ ITP customer. ನಂದೇ
Allowed. Stay home.
ಏನ್ allowed? Dismissed. Yes.
Please.
P3.
In the meantime, next.
P4.
For the petition,
Complaint dismissed.
your lordship,
One additional SPP, 2 emergent notice. Next.
his lordship, a stay may be granted in this lordship.
ಯಾವ್ದಕ್ಕೆ stay, sir?
54, your lordship.
What have you challenged, sir?
Your lordship, I have challenged the order passed by the learned trial court that.
What is that order, sir?
My lords, I have challenged the charge sheet, your lordship.
Hello, what? Charge sheet?
Charge sheet, your lordship. Charge sheet at page number 12, your lordship.
Serial number ಏನ್ ಮಾಡಬೇಕು?
54.
54.
Based on an PCR, charge sheet has been filed, your lordship. I am the owner of the property. Subsequently, the accused number 1, 2, and 3 had sold the property to the complainant. I am nowhere concerned with the transaction, your lordship.
Now, ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದಿರಾ?
ಇಲ್ಲ
ಅಲ್ಲ,
sir.
charge sheet ಹಾಕಿದೆ.
Charge sheet ಹಾಕಿದ್ದಾರೆ.
List day after tomorrow in the fresh matters. Yes, next.
P5.
For petition,
Your accused number 10 or 1?
1 man.
ಮತ್ತೆ ಯಾಕೆ 10 ಅಂತ
Partition suit pending ಇದೆ.
ಅಲ್ಲ ಸರಿ, ನಿಮ್ ಕಾಸ್ಟ್ ರೇಟ್ಲಿ ಬನ್ನಿ.
ಅದು 1 ವರ್ಷ ಆದ್ಮೇಲೆ.
ಅದು 1 or 10 ಸರ್?
1
ಮತ್ತೆ ಯಾಕೆ ಹಿಂಗ್ ಬರ್ದಿದ್ದೀರಾ?
ಒಬ್ಬರೇ ಆಗ್ತದೆ.
Yes, Jagdish.
Page 28, madam.
Yes, page 28 money. Partition suit pending ಇದೆ, that's all.
6332 ಮೇಲೆ ಅದಾದ್ಮೇಲೆ ಒಂದು
No
ವರ್ಷ ಆದ್ಮೇಲೆ
problem.
ಕಂಪ್ಲೇಂಟ್.
One additional SPP2 emergent notice. Next.
56.
Petition by has.
A1 no. A1 ಗಿಲ್ಲ. Okay, 2621. Kailas pen.
Is 57.
In the meantime, next.
66 of IT.
58.
Huh?
57, my.
Ah,
Serial number 57.
ah,
IT Act, my. 66 of IT Act.
correct. ಆಮೇಲೆ
The petitioner was into a
yes.
58.
The petitioner is in this matter.
The petitioner is before this court calling in question proceedings in charge sheet ಆಗಿದೆಯಾ?
Charge sheet ಅಲ್ಲಿ report is pending.
Proceedings,
To be filed, my lord, but
ಏನ್ to be filed ಎಲ್ಲ ಇಟ್ಕೊಳ್ಳಿ. In crime number 57 of 2024 registered for offences punishable under section 3 and 25 of the Indian Arms Act 1959. The allegation against the petitioner is that in the boot of his car, double barrel gun and live cartridges were found. 2 live cartridges were found. The petitioner is said to be a coffee planter who has licensed double barrel gun along with the cartridges. Therefore,
father.
father, all right. Therefore, the offense that the offense for possessing arms without license cannot be laid against the petitioner. Therefore, there shall. Adu petitioner word, petitioner's father had license.
59.
That's. Excuse me, petitioner. Offense is 306.
306.
Powered by judgment of the.
Covered. ಯಾವ್ದು sir?
That's Singaravelu judgment minutes. And more so, minutes is the financial transaction minutes, it is categorically in page number
The
86.
petitioner accused 1, 2, 4. 1, 2 and 4 are before this court calling in question proceedings in CC so and so registered for offense punishable under section 306, 342 of the IPC. A perusal at the summary of the charge sheet would indicate that the complainant's wife, the complainant's wife commits suicide on account of several transactions between the husband, between the complainant and the petitioners. Such financial transactions leading to commission of suicide would not become a crime, would not meet the ingredients of section 107 of the IPC for it to become an offense under section 306 of the IPC.
342 bill.
342 wife abortion. ಅಲ್ಲ ಇದು restraint, wrongful restraint, yes. So, nor under section 3, nor would meet the ingredients of section 342 of the IPC as obtaining under section 339 of the IPC. Therefore, permitting further proceedings would run foul of the judgment of the apex court in the case of Nipun Aneja 2024 INSC 2024 767. Yes, next. Therefore, there shall be post for admission in the usual course. Yes, madam.
In serial number 60, I appear for the petitioner who is
Emergent notice to the respondent in the meantime. Next.
Lordship, this matter may be tagged along with criminal petition number
Numbers kodi.
5404 of 2024, Your Lordship. And the same issue is also there in serial number 95, Your Lordship. The
For
same.
that, you have to wait. You are in the office anyway. Yes.
Yes.
Petitioner is before this court calling in question registration of a crime in crime number so and so of 24 registered for offense punishable under section 420 and 34 of the IPC. A perusal at the complaint would clearly indicate that the criminal law is being set into motion for the purpose of recovery of money, which is clearly impermissible in the light of the judgment of the apex court in the case of Lalit Chaturvedi versus so and so 2024 SSC online SC page 171, therefore, counts. Next. Post for admission in the usual course. One additional SPP, two emergent. Settle ಮಾಡ್ಕೊಳ್ಳಿ. It's a settleable issue.
If multiple cases have been
Issue is
filed
that,
against
my
each
lord,
other.
my contention is that there are no dues from me.
One additional SPP, two emergent notice. Returnable by the 5th of December in the meantime. Settle ಆಗುತ್ತೆ ಬಿಡಿ. Yes.
63.
For petition, speed trial madam.
Huh?
Speed trial ಗಾನು.
Speed trial ಆಗ್ಬೇಕಾ?
ಬರ್ತಾನೆ ಇಲ್ಲ ಸ್ವಾಮಿ ಅವರು.
ಯಾರು ಬರ್ತಾ ಇಲ್ಲ?
ಅವ್ರ ಕಂಪ್ಲೇಂಟ್.
ಯಾವ ವರ್ಷದಿದು?
2000 CC ಇದು ಕ್ರೈಮ್
22 ನಲ್ಲಿ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆ.
The petitioner is before this court seeking the following prayer. Though the prayer that is sought in the petition is to quash the proceedings, he would restrict his prayer at this juncture for a direction to the concerned court to expedite disposal of the proceedings. As the issue is of the year 2015 and the charges have already been framed in the year 2022, I deem it appropriate to direct the concerned court to conclude the proceedings within an outer limit of 6 months, if not earlier. All contentions kept open, ordered accordingly. Next. With the aforesaid observation, petition stands disposed, all contents kept open. Ordered.
64.
Wildlife.
Proclamation is pending.
Preparing for the petition. My lord's senior will appear in this case, my lord. She's on his legs before.
Just after 4 weeks. Yes.
Much obliged.
65.
Petitioners in law. The offences alleged against petitioners are 409 and section 8 and 9 of Karnataka State Public Records Act.
ಅದಕ್ಕೆ learned additional SPP is directed to secure the investigation papers. List the
Direction. Pursuant to direction issued by coordinate bench below this affair.
ಎಲ್ಲಿದೆ order? Order of the coordinate bench.
Accused number 1 already approached this honorable court.
Where is
They
that?
were issued. These petitioners accused number 2 and 3, Mila.
It's all right. Coordinate bench is directed. Get the records. Learned additional SPP is directed to secure the records of investigation. List on 15th. Next. NDPS
Charge sheet
A2.
has been filed.
Challenge ಮಾಡಿ.
Liberty.
Yes.
67.
Liberty is granted.
498.
Husband.
Husband and mother-in.
Husband and
Mother-in. Father-in-law is no more petted during the trial, during the course of investigation. Third petitioner was accused number 3 was abated.
A3 A3 ಇಲ್ಲಲ್ಲ?
ಇಲ್ಲ ಇಲ್ಲ 1 and 2.
A2 ಮಾತ್ರ. One A2 stayed.
Please.
Course for admission in usual course. It is made clear there is no interim order granted, query the husband ಅಂತ ಮಾಡು.
Petition 420 madam.
ವಾಪಸ್ ಕೊಡಿ. ಎಷ್ಟು ತಗೊಂಡಿದ್ದೀರಾ?
I received the amount 35 and 21.
35?
35 plus 21 madam. 35,000 and 21,000.
35,000.
2 lakhs.
But petitioner received 35,000 and.
Seek instructions when you will return the money.
Please. 1 week time.
List on Monday, the 11th. The petitioner shall seek instructions as to when the accused would return the money back to the complainant. Yalla close out. Yes.
69.
Will stay only atrocities, not other offenses. Other offenses are met.
Languages.
Huh?
Language is quite bad.
Atrocities again, ingredient. ಇದೆ.
ಅದಕ್ಕೆಲ್ಲ ಬೇರೆ offense.
ಬೇರೆದಕ್ಕೆಲ್ಲ ಇದೆ 100%. The petitioner is before this court seeking the following prayer and so and so ಮಾಡಿ. In so. A perusal at the summary of the charge sheet as obtaining in column number 17 would clearly indicate the ingredients of all other offences being met, except the offence under the Prevention of Atrocities Act. Therefore, there shall be an interim order of stay only of the offences under the Prevention of Atrocities Act. Insofar as the other offences are concerned, the further proceedings shall continue. One additional SPP, two emergent notice post for admission in the usual course.
70.
Gandhi Charka. Gandhi Charka.
If only a witness to the agreement, Your Honor. Accused number 2, Your Honor.
But 2016 charge frame ಆಗಿಲ್ವಾ ಇದರಲ್ಲಿ?
ಆಗಿದೆ, charge sheet
Charge
Charge frame ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ.
frame ಆಗಿಲ್ಲ. They are not appearing.
It's accused number 2 only.
In the meantime, finding that there is no ingredient against accused number 2 to meet the ingredients of the offence either in the complaint or in the charge sheet. States,
71.
allow ಮಾಡ್ಬೇಕಾ ಈಗಲೇ?
Notice.
ಅದೆಲ್ಲ ಆಯ್ತು. Yes.
353 plus 2 BNS.
353, 153 yeah.
153 IPC.
505. ಇದಕ್ಕೆ ಸ್ಟೇ ಮಾಡ್ಬೇಕಾ ಬೇಡ? ಎಲ್ಲ ಒಂದೇ ಸರ್. ಆ ಕಡೆ ಆದ್ರೆ ಈ ಕಡೆ. In the meantime, yes.
22.
72 charge sheet is filed.
Anyway, husband, charge sheet challenge ಮಾಡಿ. Yes, Liberty, next.
73.
419,420 of
Hawala transaction.
all the allegation on A1 and A2, my lords.
Yes, Jagdish. Allah, A1, A5, A6. The petitioners are before this court calling in question so and so. A perusal at the summary of the charge sheet would not indicate any offences against these petitioners A5 and A6, as the offences alleged are all against accused number 1 and 2 or others. Therefore, there shall post for admission, usual course.
74.
B report.
B report.
75.
2, 3 and 4, 2, 6, 2, 1. Kavya. For Kailas pen, yes.
26.
76 charge sheet is filed.
Charge sheet file ಆಗಿದೆ. Challenge ಮಾಡ್ಬಿಡಿ.
77.
In this case, my lordship, the petitioner, my lordship, is a new to the city.
New to the city.
Yes, my lordship. He is basically from Tamil Nadu, my lordship. He is a professor in Jain University. So he was looking for an house, my lordship, and he found one house. And the alleged allegations against the petitioner is, my lordship, 329(4), 351(2), 352, 77, and 35, my lordship.
Of BNS.
BNS, my lordship. In this case, my lordship may kindly produce the FIR.
I have already perused. All offences met.
All the offences are
ಹೆಸರು ಮಾತ್ರ ಪುಣ್ಯಮೂರ್ತಿ ಅಷ್ಟೇ.
all the offences are available in nature, my lordship.
ಯಾವುದು ಬೇರೆ?
All the offences, my lordship.
No, sir.
The 77 is the first time offender, my lordship. But if he is a subsequent offender, then it is a non-bailable.
One additional SPP, 2 emergent notice.
I may be.
No.
If it is clear in the allegation, my lordship. may not be in the FIR.
Returnable by 5th December. Avat ಕೊಡೋಣ.
78.
I represent.
Sarvan Prasanna Kumar.
ಇದರಲ್ಲಿ
Serve ಮಾಡಿ sir.
copy ಕೊಡ್ತೀನಿ. 17 not complied, 17A not complied, and also 19 is also not complied.
We'll dispose it, serve on him. We reserve liberty to comply with everything.
Other side. I will serve the copy.
Close them on. Counsel P. Prasanna Kumar is directed to accept notice, petitioner to serve on the counsel, serve on P. Prasanna, requisite set of papers on P. Prasanna Kumar. The learned counsel appearing for the petitioner submits that there is gross non-compliance with law in the case at hand.
Yes.
Section 17,
17A
17A
and 19.
and 19 all of them are given a go by. Therefore, list this matter on Thursday in the fresh matters list.
Obliged.
ಇವತ್ತೇ ಕೊಟ್ಬಿಡಿ, he will seek
Ah,
instructions.
Tarun.
Yes.
79.
You have a petition in this
A2
case.
only.
Like matter posted for evidence
Charge frame ಆಗಿದೆಯಾ?
charge frame. Speedy disposal or A2 65 years old, my lord.
Correct.
Exempted,
ಅದ್ ಮಾಡ್ತೀನಿ.
please.
ಕವಿ, ಇದು ಮೀನಾಕ್ಷಿ ಬಾಲ ಹಾಕ್ಬಿಟ್ಟು the accused number 2 is said to be 65 years old. In that light, I deem it appropriate to exempt A2's appearance before the concerned court for further proceedings, as the charges are already framed and the trial is on. Ordered according.
Grateful.
Yes.
80.
Charge sheet is filed.
Case and counter case.
Please, move.
87 and 89 of 24. Charge sheet
Charge sheet
ಆಗಿದೆಯಾ? Challenge ಮಾಡ್ಬಿಡಿ.
Please.
Challenge move ಮಾಡಿ, saying that I have withdrawn it for the charge sheet purpose. We'll take it the next day.
81.
81, I represent the petition. 3
Mobile phone is sent to FSL.
ಕಳಿಸಿದ್ದಾರೆ.
Report.
A report has come.
Positive. Matches with the voice of the.
ಕೊಡಿ.
ಕಷ್ಟ ಮನೋಹರ್.
ಒಪ್ಪಿತಲ್ಲಪ್ಪ. ಕೊಡಿ. ರಿಪೀಟ್.
ಎಲ್ಲಿದೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಪೇಪರ್ಸ್ ಎಲ್ಲಿದೆ? FSL ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ
ಇದೆ.
ಮ್ಯಾಚಸ್ ವಿತ್ ಯುವರ್ ವಾಯ್ಸ್.
ಇದೆ. ಲಾಸ್ಟ್ your lordship may kindly turn to page 4. Page 4, 4 lines ಬಂದಿದೆ. 4 lines does not invoke section 107 of IPC. ಇವರು ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಇರ್ತಾರೆ. She called. ಬನ್ನಿ ಅಂತ. ಬನ್ನಿ ಅಂತ. They were in love ಅಂತ ಹೇಳಿ there is a case of the prosecution.
Correct. That is why.
They were in love ಅಂತ ಹೇಳಿ. ಬನ್ನಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ, who else can instigate suicide? Only you can do it. Absolutely. Over phone. There is no instigation. Your lordship may kindly look into page 4 in the bottom. 4 lines they have retrieved from the mobile phone.
No, there are multiple connotations. The only.
ಅದಕ್ಕೆ who else can do it? Nobody else.
ಅಲ್ಲ, first initially the case has been registered in UDR.
First ಆಗದೆ UDR.
UDR ಅಲ್ಲ.
Correct. Mobile
I
phone
have ಸಂಶಯ ಇಲ್ಲ ಅಂತ ಹೇಳಿ.
sick ಮೇಲೆ 306 ಬರುತ್ತೆ.
They said that we don't have any suspicion against anybody.
Correct.
Later after
See, grieving parents or the complainant, you go and ask when their daughter, wife is dead.
Yes.
Who will say, no, I have suspicion on 1, 2, 3, 4. They will say, I have no suspicion, please leave me alone.
Correct.
ಅದು UDR unnatural death report register ಮಾಡ್ತೀರಾ. ಆಮೇಲೆ ಏನಾರು ಒಂದು ಎವಿಡೆನ್ಸ್ ಸಿಕ್ಕಾಗ 306 ಬರುತ್ತೆ.
After 2 months later.
Forward, sir.
2 months later, a mobile phone has been found.
Correct.
And they suspect some messages were found.
Not some messages, lots of messages.
They suspect, and then the investigating officer sent to FSL. FSL has retrieved the messages.
Yes, sir.
That messages your lordship will find at
I have
page
seen, sir.
4.
Ah,
Page 4 I have produced.
Correct, yes.
Page 4 lines.
ಇದಲ್ಲ, I have not seen. I'll see it now. Yes.
Page 4. Last 4 lines.
The comparison of respective voices based on so and so, said to be the accused Pawan, found recorded in audio video Sandis so and so. Sample speeches found recorded in their audio video are similar.
ಓದ್ತೀನಿ.
ಓದಾಯ್ತು, ನೀವು ಓದ್ಬಿಡಿ.
Bottom 4 lines.
ಅದೇ ನಾನು ಓದಿದ್ದು. ನೀವು
ಕನ್ನಡದಲ್ಲಿದೆ.
ನೀವು ಓದ್ಬಿಡಿ.
ಅವ್ರ ಕಾನ್ವರ್ಸೇಷನ್ ಏನು ಅಂತ ಕನ್ನಡದಲ್ಲಿ ರಿಟ್ರೀವ್ ಮಾಡಿದ್ದಾರೆ. Page 4 last 4 lines.
ಓ, ಇದು ಓದಿಲ್ಲ, ಓದಿ.
Last 4 lines. ಹೋಗ್ಬೇಡೆ, ನೀನು ನೋಡ್ಕೋ ಹೋಗು, ನೀನೇ ನೋಡ್ಕೋ ಹೋಗು, ಏನ್ ಮಾಡ್ತೀಯ ಮಾಡ್ಕೋ, ಏನು ಬಿಡು, ನನ್ಗೆ ಬದುಕೋಕೆ. ಅಕ್ಯೂಸ್ ಸೇಸ್ ದಟ್, ನನ್ ಬಿಟ್ಬಿಡು, ನಾನು ಬದುಕೋಕೆ. ಮಾಡ್ಕೊಂಡು ಸಾಯಿ, ಏನ್ ಕಾಲ್ ಮಾಡ್ತಿರೋದು, ಹಲೋ ಏನ ಮಾಡ್ಲೆ, ಹೋಗೆ ನೀನು.
ಸರಿ ಬಿಡಿ, ಓದ್ಬೇಡಿ.
ಹಲೋ ಹೋಗೆ.
ಹಲೋ ನೀವು ಓದ್ಬೇಡಿ
ಅಷ್ಟೇ.
Nobody else can instigate. Discharge. ಇಲ್ದರ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಬರೀತೀನಿ, ಬಟ್ ಇವತ್ತಲ್ಲ ನಾಳೆ ಬರೀತೀನಿ.
Except these 4 lines, sir. The entire charge sheet, nothing is contained to implicate the accused present petitioner or an offense under section 306.
ಅದು FSL ಕಳಿಸಿದ್ದು.
FSL.
But there are multiple conversations between you and the deceased.
They have retrieved only this last conversation.
Don't worry.
They have sent it.
Matter of trial.
Your lordship's judge, there are innumerable judgments of your lordship.
No, many that I have allowed and few that I have dismissed. ಆ ಫ್ಯೂ ಅಲ್ಲಿ ನಿಮ್ದು ಬರುತ್ತೆ, ಮೆನಿ ಅಲ್ಲಿ ಬರಲ್ಲ.
ಡೀಟೇಲ್ ಆಗಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋಣ.
ಮಾಡಿ ಅಲ್ಲಿ.
ಅದು ಇಲ್ಲಿ ತಮ್ಮದೇ ಮಾಡ್ತಾರೆ.
ಇಲ್ಲ ಇಲ್ಲ.
It's a fit case to exercise powers
Oh,
under
no,
482.
sir. Unfit case.
Viewing in any angle except these 4 lines.
Every
absolutely
angle,
there is no material.
any alla, every angle.
Except these 4 lines, absolutely there is no material. None of the witnesses have spoken about that.
Witness ಯಾಕ್ ಬೇಕು ಸರ್?
ಅದೇ,
Between two,
except this FSR
between
report.
two people who are in love.
Correct.
And the boy or the man talking this
Yes.
to the girl over
Yes.
the phone. What witness you need?
Yes. Proximity.
Phone ginta
Conversation has
proximity
taken
ಬೇಕಾ?
place. After lapse of
Speed, sir.
after lapse
Electronically you have instigated.
of, after lapse of 2 months, she has come to this.
She is.
How can she? The prosecution can attribute this conversation is the
That's
root
all.
cause for the commission of suicide.
That's the only circumstance. ಯಾಕಂದ್ರೆ immediate ಆಗಿ death is not immediate,
Death
but
is not-
conversations have been later.
Conversations have been admittedly, I cannot dispute it at this stage. But the proximity of death and the messages, there is a big gap.
Discharge ಹಾಕೊಂತೀರಾ?
ಅಷ್ಟೇ. ಅಲ್ಲ.
ನೋಡೋಣ.
Charge ಇದೆ.
ಹಾ, ಚಾರ್ಜ್ ಇದೆಯಾ?
ಹಾ.
ಚಾರ್ಜ್ ಇದೆ, ಬಟ್
Charge.
ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿಲ್ವಲ್ಲ, ಹಾಕಿಲ್ವಲ್ಲ.
Trim order ಕೊಟ್ರೆ so that full-fledged we can argue. The next date itself, I am ready to argue.
Not a case.
Any date may be fixed.
One additional SPP, 2 emergent notices. Not a case for stay. Pendency of this petition will not come in the way of further proceedings before the concerned court. Next.
52.
Date ಕೊಟ್ರೆ.
451, 457.
Rival claim.
Rival claim ನೀವಾ?
Please, R2I. Date may be fixed.
ಬೇಡ, ನನ್ ಮುಂದೆ ಬೇಡ, ಚಾನ್ಸ್ ತಗೊಳ್ಳಿ.
Very difficult to get the matter.
4 ವಾರ ಬಿಟ್ಟು, ಅಲ್ಲ, ಜನವರಿ ಫಸ್ಟ್ ವೀಕ್ ಆಗ್ತೀನಿ.
First week.
ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಜನವರಿ.
Okay.
Yes.
I accept notice for R2, please, my lords. It may be clubbed along with criminal petition 11133 of 24.
Counsel Bharat Kumar accepts notice for
R2.
R2. Registry to print so and so. Tag so and so.
Criminal petition 11133 of 24.
ಆಯ್ತು, ಯಾವತ್ ಬೇಕು?
Any date.
Any day.
28 November.
Obliged.
Obliged.
83.
A2 to A5, 498A. Okay.
Connected with 750 of 2000.
Tag this petition along with
750 of 2019.
so and so. Post for admission in its usual course.
Eighty-four.
Charge sheet is filed.
ಶಾಕ್ ಆಗ್ಬಿಟ್ರಿ, ಗೊತ್ತೇ ಇರಲಿಲ್ಲ.
ಕನ್ಸೆನ್ಷನಲ್ ಫಿಸಿಕಲ್ ನೈಬರ್ಸ್ನು ಸೇರಿಸಿದ್ದಾರೆ.
ಎಲ್ಲರಿಗೂ ಸ್ಟೇ ಮಾಡ್ಬೇಕಾದ್ರೆ, ಬಟ್ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ, ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಚಾಲೆಂಜ್ ಮಾಡಿ ಮಂಡೇಗೆ ಮೂವ್ ಮಾಡಿ. ಎಸ್, ಮಂಡೇಗೆ ಮೂವ್ ದ ಮೆಮೋ ಅಂಡ್ ಮೆಮೋ ಮೂವ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಚಾರ್ಜ್ ಶೀಟಿಗೆ ವಿಡ್ರಾ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಹೇಳಿ 2:30ಗೆ ತಗೊಂತ. ಎಸ್.
85.
This case I am.
A2 and A3, 498A. Yes.
Please.
86.
424, 65%.
ದುಡ್ಡು ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ.
I have not received that.
ಆ,
I have not at all received. I have produced my entire statement, my lord. Account. I have produced my entire statement. It is not transferred to my account, my lord. He stated that it is the amount, entire amount, 80 lakhs rupees transferred to one Mr. Jakaria, not to my account, my lord.
Zakaria Varghese.
So he is not my.
Yes, sir.
The amount transferred to one Jakaria Varghese, not to me. He stated that
Zakaria-
only 20 lakhs transferred.
Zakaria was not even in India, and in his name, somebody else has been.
Zakaria.
I am in possession of the property by as a leaseholder, my lord. The
Return the money, sir.
I have not received, my lord. I have
Who
not
was
received.
received?
Huh?
Zakaria.
I don't know. That account is not mine.
ಸ್ವಲ್ಪ ನೋಡ್ಬಿಟ್ಟು ಯಾರ್ಗ ರಿಸೀವ್ ಆಗಿದ್ದಾರೆ ನೋಡ್ಬಿಟ್ಟು you see how it can be returned.
My lord, I am no way connected to this.
Additional SPP 2 emergent notice.
No, madam. The complaint clearly stated that he paid amount of 80 lakh rupees to one Mr. Jakaria and 20 lakhs to the petitioner, my lord. He stated that in the complaint, my lord, 20 lakhs.
ಅದಕ್ಕೆ ಯಾರ್ಯಾರಿಗೆ ಎಲ್ಲೆಲ್ಲಿ ಹೋಗಿದೆ ಸ್ವಲ್ಪ ಚೆಕ್ ಮಾಡ್ಬಿಟ್ಟು ಯಾವಾಗ ವಾಪಸ್ ಕೊಡ್ತೀರಾ ಬನ್ನಿ, ಆವಾಗ ಸ್ಟೇ ಕೊಡ್ತೀನಿ.
But I don't know that.
No.
He said that 20 lakhs transferred to me,
ಕೊಡಿ ಅದನ್ನ.
but no statement is provided.
No problems. Give
He
it.
has not at all transferred any amount to me. But he said that from his mother-in-law's account, he has transferred 20 lakhs rupees. That is in the month of February. For the for different transactions, that is in for a sale transaction, that is in page number 77. my lord.
Dismiss
Kindly
ಮಾಡಿ,
pay-
notice ಮಾಡಿ.
Hello, sir.
Stay ಕೊಡು ಅಂತ
Kindly page 77, my lord. There was a sale transaction between the complainant as well as the petitioner, my lord, in the
Exactly.
month of February, my lord. In respect of that transaction, he has transferred 20 lakhs
Exactly.
Right.
Yes, sir.
from his mother-in-law's account, my lord.
Correct.
Thereafter, but in the complaint, he said that accused number 2 and 3 introduced me after February. But in the before that, he know if the petitioner has the complaint.
All are seriously disputed questions of fact. We will dismiss it on that ground. One additional SPP, 2 emergent notice.
But the police are frequently calling me every week. ಒಂದು notice ಕೊಡ್ತಾ ಇದೆ.
ಏನ್ ಮಾಡಕ್? ದುಡ್ಡು
Even
ದುಡ್ಡು ತಗೊಂಡ್ಮೇಲೆ ವಾಪಸ್ ಕೊಡ್ಲೇಬೇಕು.
I have not received, my lord.
ಪರವಾಗಿಲ್ಲ. ಅಂದ್ರೆ ಎಸ್.
But there is no material at all.
ಈಗ ಬರುತ್ತೆ ಎಲ್ಲ.
At least date may be given, my lord.
ಬರ್ಲಿ
It will not be listed, my lord.
ದುಡ್ಡೆಲ್ಲ ಕಲೆಕ್ಟ್ ಆದ್ಮೇಲೆ ಮೂವ್ ಮಾಡಿ. ವಾಪಸ್ ಕೊಡಕ್ ದುಡ್ಡೆಲ್ಲ
I
ಕಲೆಕ್ಟ್
don't have
ಆದ್ಮೇಲೆ.
received, my lord.
ಪರವಾಗಿಲ್ಲ, ಯಾರ್ಯಾರ ಹತ್ರ ತಗೊಂಡಿದ್ದಾರೆ ಕಲೆಕ್ಟ್ ಮಾಡಕ್
Let
ಆದ್ಮೇಲೆ.
the prosecution to produce the material to show
They
that I
will
have received money.
No worries, they will produce.
Let them produce any material to show that I have received the amount, my lord.
ನೀವು ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ದೆಲ್ಲ ವಾಪಸ್ ಕೊಡಕ್ ರೆಡಿ ಮಾಡಿ ಆಮೇಲೆ ಸ್ಟೇ ಕೊಡಿ.
ಅವ್ರು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಆಲ್ರೆಡಿ.
ಮಾಡ್ಲಿ ಬಿಡಿ.
Let them produce the document.
Let them investigate, sir.
Sir, already they conducted
Complete
investigation.
ಆಗಿದೆಯಾ?
It's only.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆಯಾ? ಮತ್ತೆ ಜಕಾರಿ ಹೆಸರೆಲ್ಲ ತಗೊಂಡ್ರು ದುಡ್ಡು.
But I am not the Jakari.
You are not Zakaria, you have taken in his name. All right. ಅಷ್ಟೇ. ವಾಪಸ್ ಕೊಡೋದು ಯಾವಾಗ ಅಂತ ನೋಡಿ, ಟೈಮ್ ಲೈನ್.
No, but I have not received, my lord. How can I repay back the, my lord?
Cooperate with the investigation.
I already cooperated, my lord. See, I have granted answer
Further
to the-
cooperation. Further cooperation.
ಅಲ್ಲ ಕಂಟಿನ್ಯೂಸ್ ಒಂದು ವಾರಕ್ಕೆ ಒಂದ್ಸರಿ 2 ಸರಿ ನೋಟಿಸ್ ಕೊಡ್ತಾರೆ.
ಯಾಕೆ ವಾರಕ್ಕೆ ಒಂದೇ ಸರಿ ಮಾಡ್ತಾ ಇದೀರಾ?
ಅಲ್ಲ
ಎರಡು ಸರಿ ಮಾಡಿ.
ಅಲ್ಲ ಸರ್, ವಾರಕ್ಕೆ ಒಂದ್ಸರಿ 2 ಸರಿ ಕರಿತಾನೆ ಇದಾರೆ. ಕರೆದ್ರೆ ಏನು ಸುಮ್ಮನೆ ಕರ್ಸೋದು ಕೂರ್ಸೋದು ಕಳ್ಸೋದು ಅಷ್ಟೇ.
Yes, sir. Why you should frequently call him and finish investigation fast. ಬರೀ 2 ಸರಿ ಯಾಕೆ? You're not interested in investigation? ಈ ಕಂಪ್ಲೀಟ್ ಮಾಡ್ತಾರೆ.
There's off the record, I would like to say, my lord, they're getting, they would like to extract something from me, that, but they
Something.
Yes, my lord.
Yes. Jagdish, what thing?
When I'm not ready to pay, they are frequently calling me.
You should be ready to pay, sir. Back to the complainant.
Not that amount, my lord. They're
ನಂಗೆ ಗೊತ್ತಿಲ್ಲ
something, my lord.
ಏನ್ಗೆ. That amount ಆದ್ರೆ ಸಮಥಿಂಗ್ ಆಗಲ್ಲ. But everything. Next.
At least date may be fixed, my lord.
ಬರ್ಲಿ, ಮೂವ್ ಮಾಡಿ. When you're ready, you move.
Move ಮಾಡಿದ್ರೆ ಬರ್ತಾ ಇದು ಮೂವ್ ಮಾಡಿದ್ರೆ
ನೀವು ಮೂವ್ ಮಾಡಿ ಸರ್. ದುಡ್ಡು ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡಿದೀನಿ ಅಂತ ಮೂವ್ ಮಾಡಿ ಗೊತ್ತಾ?
But I have not received, my lord. Let them produce the
ಹಾಗಾದ್ರೆ
document.
ಬರ್ಲಿ ಬಿಡಿ, usual course. Yes.
Appear for petitioner.
80?
Appear for petitioner, man. Petitioner is
In time.
actually.
Yes. States. Petitioner to serve on the council who represents the respondent in the trial proceedings and file an acknowledgement to that effect in the next 1 week. In the meantime, there shall be an interim order of stay of further proceedings by the petitioner. Next.
89.
ಯಾರಿಲ್ವಾ? Syed Zafar. Ready to be stayed. 306.
Love affair breakup.
Love affair. No representation, 4 weeks.
90.
Next week, madam.
Misappropriation. Next week ಬಂದ್ರು ಸ್ಟೇ ಕೊಡಲ್ಲ.
Next week, madam.
ಪರವಾಗಿಲ್ವಾ? 1-2 ವಾರ ಬಿಟ್ಟು ಬನ್ನಿ. List after 2 weeks.
91.
Excise Act, madam. And actually.
32-34.
32.
Violation of 53-54. Same order. Right ಆಗ್ಬಿಟ್ಟು ಹಿಂದೆ ಹೋಗಿ. Same order. ಕೊಡಿ ತೊಗೊಳ್ಳಿ.
520.
512. List on 512. ಜಗದೀಶ್ ಅದೊಂದು 512 ರೆಡಿ ಆಗಿ
Yes.
ಯಾರಾದ್ರೂ ಸರಿ.
But office objection, man, I had given a residential address, my lord, they had given the bar address.
ಏನ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ವಲ್ಲ?
That's the objection.
ಆಫೀಸ್ ನೋಟ್.
Notice, I had given the explanation.
ಆಫೀಸ್ ನೋಟ್. ಲ್ಯಾಂಡ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ಸ್ ಏನಿಲ್ಲ ಸುಮ್ಮನೆ ನೀವು ನೋಟ್ಗೆಲ್ಲ ವರಿ ಮಾಡ್ಬೇಡಿ. ನೆಕ್ಸ್ಟ್
92.
4 weeks not to list. 92 ರೋಹಿತ್
Please, my lord.
ಡ್ರೈವರಾ?
He is
Driver,
my lord. There are two vehicles, my lord.
ಗೊತ್ತು ಮೋಟರ್ ಸೈಕಲ್ ಡ್ರೈವರಾ?
He himself, my lord, dash record by vehicle.
ದ ಮ್ಯಾಟರ್ ಆಫ್ ಎವಿಡೆನ್ಸ್.
My lord, fair reading of complaint, my lord, is clearly showed.
ಅಲ್ಲ, ಯು ಆರ್ ನಾಟ್ ದಿ ಒನ್ ಹೂ he came and
He
crashed
came and ನನ್ ಗಾಡಿ ನಾ ಮುಂದೆ ಹೋಗ್ತಿ ಹಿಂದೆ ಬಂದು ನನ್ನ ಗಾಡಿ ಕೂತ್ಕೊಂಡೆ.
ಬ್ಯಾಕ್ ಸೈಡ್ ಇಂದ.
ಅದು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೇ ಇದೆ.
ತಲಭಾಗಕ್ಕೆ ತಿರುಗಿದ ಪರಿಣಾಮ ಹಿಂದೆ.
ಇಲ್ಲ ಅದು ನಾನು
ಮೊನ್ನೆ
ಕಂಪ್ಲೇಂಟ್
ಒಂದು
ತಗೊಂಡಿಲ್ಲ.
ಕಾನ್ವಾಯ್ ಒಂದು ಸಡನ್ ಆಗಿ ಹಿಂಗ್ ತಿರುಗಿದ್ದಕ್ಕೆ ಕಾನ್ವಾಯ್ ಎಲ್ಲ ಹೋಯ್ತು ಕೇರಳದಲ್ಲಿ. ಅದಕ್ಕೆ ಸಡನ್ ಆಗಿ ತಿರುಗಬಾರ್ದ.
ಸಡನ್ ಇಲ್ಲ, ಅದು ನಾನು ಕಂಪ್ಲೇಂಟ್ ಕೊಡಕ್ಕೆ ಹೋಗ್ತೀನಿ, ನನ್ನ ಕಂಪ್ಲೇಂಟ್ ತಗೊಳಲ್ಲ ಅವರು. ಬಿಕಾಸ್ ಅವ್ನು ಡೆತ್ ಆಗಿರೋದಕ್ಕೋಸ್ಕರ ಅದಕ್ಕೋಸ್ಕರ.
In the meantime, till the next date, one additional SPP, 2 emergent notice.
Please.
Next.
93.
The petitioner is the husband. The offense is the one alleged under section 498A of the IPC inter-alia. A perusal at the complaint or the summary of the charge sheet would not indicate any ingredient of the offense even against the husband, except minor skirmishes that happen in day-to-day life of in a day-to-day life in a family. Therefore, there shall be an interim order of stay of further proceedings qua the husband, failing which
1 to 3.
1 to 3, failing which the failing which it would run foul of the judgment of the apex court in the case of Achin Gupta 24/759 and Kailas Ben 24/2621. ಮಧ್ಯದೆಲ್ಲ fill up ಮಾಡ್ಕೊಂತೀರಲ್ಲ, fill in the blanks.
94.
Except husband, all others
Kindly have a date, my lord. Matter has been settled between the parties.
settled. Counsel for the petitioner submits that the matter has been settled between the parties to the list and would list on
21, my lord.
list on 21st November at 2:30 PM to report.
Meanwhile,
22nd
much of that.
22nd to report settlement.
Meanwhile, on FIR, one more case is pending, my lord. Same may be tagged along with this.
Tag along with swords. ಎರಡು settle ಮಾಡ್ಬೋಣ.
ಎರಡು ಆಗಿದೆ.
ಆಯ್ತು, next.
Your lordship, I appear for the
95 same order.
Your lordship, criminal petition 5.
95.
95 same order. Which serial number?
Your lordship, criminal petition number 540.
Serial number ಏನ್ ಇವತ್ತಿದ್ದು?
60, your lordship.
60. Tag along with 60.
Obliged.
Same order.
96.
Same order. 41, serial 41. 42.
Same. Heard the learned senior counsel G. Krishnamurthy. ಆಮೇಲೆ ಸೇಮ್ ಆರ್ಡರ್ ಟ್ಯಾಗ್
40, serial number 42.
48. ಎಲ್ಲಿದೆ ಮೆಮೊ? ಇಷ್ಟೊತ್ತರ ತರ್ಬೇಕು ತಾನೆ, ಒಂದು ಆರ್ಡರ್ ಕಾಪಿ ತಗೊಂಡು ಅವ್ರಿಗೆ. ಎಸ್ ಎಸ್
96.
90
97.
97 husband.
The allegation, my lord, absolutely no allegation,
Oh,
my
no,
lords,
no,
of
no.
assault or torture.
No.
Wait, that is one thing. Second thing, I have filed a complaint against her on
Maybe.
15 and
So what?
she assaults me. I go to the police station.
Your wife has assaulted the husband.
ಹೌದು. Based on that, FIR was registered.
ಯಾವ್ದ್ರಲ್ಲಿ dangerous weapon used?
My lord, she has used the hair dryer.
Hair dryer.
Hair dryer. I have gone to the hospital.
ನಿಮ್ ಹೇರ್ ಡ್ರೈ ಮಾಡಕ್ ಹೇಳಿದ್ರೆ ಅದೇ ಮಾಡೋದವರು.
My lords, they're more than 8 years after the marriage and thrice I have been assaulted.
ಹೇರ್ ಡ್ರೈಯರ್ ಏನ್
Matrimonial
assault
cases
ಆಗತ್ತೆ?
against. Allegation is that.
ಹೇರ್ ಡ್ರೈಯಲ್ಲಿ ಬ್ಲೋ ಆಗುತ್ತೆ.
ಅಲ್ಲ, ಏನಾಗಿದೆ ಅಂದ್ರೆ the allegation, my lords, I ask her, she does not return to home.
You registered a crime of assault against the wife
Yes, it is
for
registered.
blowing your hair dry.
I have been, my lords, I have suffered injuries.
Injury na?
ಹೌದು, even I have produced the MLC also. I have suffered injuries and 29th is the assault, 30th, my lords, is the FIR registered, 31st she registers this complaint. Sequential, my lords, 29th, my lords, and the allegation, my lords, I ask her, she does not return home.
Sequential ಯಾಕೆ ಅಂದ್ರೆ it is consequential because you are the husband.
My lords,
Here what happens, my lords, I ask her, she does not return home.
Why?
3-4 days, she does not return home. I ask her the reason for that, she has assaulted me. And she makes an allegation in this complaint saying that I return home only at 11 o'clock in the night. This is the allegation against me, and I do not permit her to, my lords, dry my clothes. I dry my own clothes. This is the allegation. That is the allegation against the husband for 498A.
Hair dryer la.
Hair dryer alla, washing machine.
Washing machine.
Washing machine though.
Yes, in the meantime. Next.
98.
Complaint and counter complaint, my lord.
Counter complaint stay ಆಗಿದೆಯಾ?
Yeah, stay.
ಕೊಡಿ petition ಕೊಡಿ. Tag sounds next.
Criminal petition 3150 of it.
ನೀವು ಕೊಟ್ಟಿರೋದು ಅಲ್ವಾ ಅದು? ಹಾ ಸರ್.
Please.
59.
For petitioner.
213 application is dismissed, not challenged.
Accused 13 to 19. ಏನಿದೆ? The petitioners are accused 13 to 16. A perusal at the summary of the charge sheet would not indicate any of the offences, ingredients of the offences so alleged. The learned additional SPP submits that the petitioners had sought discharge from the area of accused before the concerned court, which has been dismissed, notwithstanding that I deem it appropriate.
A123.
A123 na ivaru? A123 ಆದ್ರೆ ಇಲ್ಲ.
123.
Serial number ಏನು?
99.
59.
Specs ತೆಗೆದ್ಬಿಟ್ಟು 100 ಕಾಣ್ತಾ ಇದೆ ಅದು. Yes, sir.
Lord, non-action to execute the sale deed.
No, but you see one thing. The incidents have happened between 2013 to 2016. That is, execution of sale deed is denied. Then 2017 crime is registered for denial of execution of a sale deed or the subject matter of sale deed in 2013. No explanation for delay. ಅದು ಸ್ಪೆಕ್ಸ್ ತೆಗೆದಿದ್ದಕ್ಕೆ ಅಕ್ಯೂಸ್ 13 to 16 ಕಾಣಿಸ್ತಾ ಇದೆ. Yes, sir. The petitioners are before this court calling in question so and so. The incident occurs between 2013 to 2016 is the crux of the complaint. The issue is non-registration of the sale deed. 2017, the crime comes to be registered and the police after investigation have filed a charge sheet in the year 2019. The issue being purely civil in nature and hit by gross delay in registering the complaint even, I deem it appropriate to stall for grant stay of further proceedings, square these petitioners till the next date of hearing.
Right.
100.
Petitioner.
Civil
litigation pending with.
ಏನ್ ಸಿವಿಲ್ ಅಲ್ಲ 138.
138 is a civil suit was filed by the petitioner.
ಅದೇ ಚೆಕ್ is stolen.
That is the another allegation.
Sir, on the
Previously,
respond.
We filed this
One-
partition pending before the.
One
civil-
additional SPP, 2 emergent notice returnable by 27th November.
Kindly see the.
ಅವತ್ತವರೆಗೆ. Yes, next.
101.
Litigation is atrocity.
Huh?
That
What's wrong?
complaint is made against owner.
So what?
See, the incident within the.
Yes, Harish.
4 weeks.
My lord.
Page 35.
35.
Only atrocity, na?
Only atrocity.
Only atrocity.
506.
ಅದ್ ಮಾಮೂಲಿ. ಅದಿಲ್ಲದೆ ಏನ್ ಕ್ರೈಮೇ ಇರಲ್ಲ.
Page number 50, restatement of the complaint.
The petitioner is before this court calling in question proceedings in special case 2949 of 2023, registered for offense punishable under section 506 of the IPC and so 504 and 506 of the IPC and 31R and S of the Atrocities Act. For an offense to become punishable under section 31R or S, the hurling of abuses must have happened in a public place or a place of public view. Neither of it is the fact in the case at hand. The hurling of abuse has happened in the car parking area at the basement. where, which is neither a place of public view nor a public place. Therefore, there shall be an interim order of stay of further proceedings qua this petitioner, failing which it would run foul of the judgment of the apex court in the case of Hitesh Verma versus so and so 2020-10 SEC page 710. Therefore, there shall be.
102.
Petitioner CC.
499, 500
Yes, my lordship. There is.
in the meantime for a period of 4 weeks. Emergent notice to the respondent.
And 3.
Waiting for the petitioner, my lord.
You are not the manufacturer.
No, my lord, I'm not the manufacturer. None of it.
In the
is-
meantime, next, Corporate Act,
Please.
except husband,
In this case, what happened, this is second FIR.
Parval, except
And
husband,
moreover, madam,
yes.
moreover, madam, the BNS invoke ಮಾಡ್ಬೇಕಾಯ್ತು, IPC invoke
Parval, ಅದೇನ್ in,
After lapse of.
I don't agree with that view that it is incurable defect.
And after, madam,
It is curable, sir. In fact,
submission, madam.
allegation is
After
a.
lapse of 6 months, madam, parallelly she is, madam, got a decree of divorce. Decree of divorce I have produced.
Parval, all except husband, Burley, ಆಮೇಲೆ husband no.
Even allegation is there on all the accused.
Divorce ಆಗಿದೆ already. Yes,
And then 5.
I am for the petitioner, my lords.
2621.
I am for the petitioner, my lords. All the revenue record stands in my name, my lords. In fact, I filed an FIR for interfering in my possession. And
The petitioner is before this court calling in question so and so. The petitioners are accused 1, 2 and. Sir, ನೀವು ಆಫೀಸಲ್ಲಿ ಇದ್ರೆ ಸುಮ್ಮನೆ ಇರಬೇಕು, ಇಲ್ಲ ಇಲ್ಲಿರ್ಬೇಕು.
Sorry.
Accused 1, 2 and 3. The crime is registered on a private complaint in PCR 62 of 2024. The private complaint does not meet the directions of the apex court in the case of Babu Venkatesh versus so and so 2022 SEC online SC page 200. Therefore, there shall be. Next.
Charge sheet is ready, my lord.
Keep it with you, sir. 2 to 6.
Already second complaint within a span of 2 days.
302 na.
Allala, within a span of 2 days.
Accused
it
number
filed
2 to 6.
Please.
Stayed 2621. Yes, next.
7.
Waiting for the petitioner, my lord.
Husband.
My lord, in this, the husband is there, my lord. The series in this is, my lord. Initially, the mother-in-law comes and resides with the petitioner and the complainant, my lord. And along with that, the mother of the petitioner also comes. There is a newborn baby, my lord. The mother of the petitioner comes to aid with the delivery of the baby and other things, my lord. The conflict arises between the mother-in-law and the mother of the petitioner, my lord. This is a situation where, my lord, where on the day where the departure of the mother of the petitioner.
Departure.
Yes, my lord. They do not reside in the place with the petitioner and the complaint, my lord. During the departure, the mother had to leave, my lord. The mother-in-law assaults the mother. They have a conflict, my lord, internal conflict. They both assault each other. And the petitioner, who is the accused, my lord, tries to defend his mother, my lord. And the petitioner's mother-in-law smashes the glass bottle on the head of the petitioner, my lord. And because of that, he goes and files a complaint in the Expeditious station on 15th, my lord. Page number 45, my lord, there's a complaint written, my lord, by the petitioner. This is to inform you that my name Nasir Malik has been married to Suraina so and so for 2 years now. Recently, 11 days ago, we are blessed with a baby girl. My mother-in-law, Suraina Nazim, who has been with us for past 1.5 months, she is very abusive towards me and my marriage, influencing my wife for divorce and threatening me. Yesterday, she abused my mother and my whole family and forced my mother to leave. While leaving, she assaulted my mother and me, hitting me with a glass bottle.
One additional SPP to emergent notice.
My lord. My lord, in this matter, my lord, after I've registered the complaint, my lord, later on, after 4 days, my lord, she goes and files. When I have registered the complaint, my lord, NCR has been registered, my lord. I have been hit by a glass bottle. I get an MLC done, my lord.
I don't, Burley, yes.
After that, my lord, and on 19th, she goes and registers the complaint.
Returnable by 5th December. Yes, next.
Much of it.
Then 8.
A2 and A3, no A1, 498.
Marriage was dissolved in the year 2023, my lords. Kindly possess the page number 20, my lords. The page number 20, I have to return.
AN material illa. Produce the investigation papers.
A1 had to return the gold within 1 year. Just for not.
A2, A3, stay madi. Insofar as A1, the same would be considered after perusal of the papers of investigation. List on 21st, 22nd, investigation papers we produced on the said date. Next.
109.
In this case, no.
Wound certificate. Wound certificate.
That is a created.
109 ತಾನೆ?
Yes, my lord.
Page 32.
It's not, earlier to earlier, 3 days earlier, I have lodged a the petition.
All
lodged
right,
a
where is
complaint
the wound
against-
certificate, sir?
Right.
You said you have sustained injuries. Where is the wound certificate?
Not yet produced, my lord.
I'll produce, my lord.
Produce the documents.
I'll produce.
The petitioner, the learned HCGP to secure and produce the entire charge sheet material by the next date. List on 12th in the fresh matters list. Yes,
13th,
12th.
12th, I will not be. 13th or 14th.
13th.
Obliged.
110.
4988. Or in-laws, my lord.
See,
petition number 1.
come to page 30, sir. 30. A1 and A4 I will not grant. Others I will grant.
The allegation. A1 is 65 years, my lord.
See the allegations. Page 30 note.
She left the place of the,
A1 and A4 ಆಮೇಲೆ ನೋಡೋಣ. ಮಿಕ್ಕದು ಯಾರಿದ್ದಾರೆ ಅವರು. A1 and A4 will be considered, the petitioners are before this court so and so. A perusal at the complaint so registered would not inure for grant of an interim order qua accused number 1 and 4. Others interim order. The same would be considered, qua accused 1 and 4, the same would be considered on the appearance of the complainant.
injuries, there's no injury, my lord. Page number.
11.
Latif ಅಲ್ಲಿ.
Held up in another. It's held up in another. Pillar.
Hello, it's all right. I'm not asking you if he should come. What gold flag copyright?
Only based on the confession statement of.
That
18.
we'll see. Learned HCGP is directed to accept notice.
There's no other material because it's from the A2, my lord.
Respondent 1, 2 emergent notice returnable by 5th December.
Meanwhile,
Our,
there's no other material.
no, we'll see, we'll quash it and get it.
Date, my lord.
5th December.
12.
Is the suit pending?
Yeah, RF is pending, my.
In the mean,
He purchased the property in
meantime,
2006.
yes.
13.
Why 70 accused, right?
Entire villages, my lord, there is a government land encroached by the.
Yes, government.
Respondent.
70 ಜನದ ಮೇಲೆ ಏನ್ ಕಂಪ್ಲೇಂಟ್?
Entire villages ನ ಮಕ್ಕಳು ಮರಿಗಳು ಮತ್ತೆ.
ಮಕ್ಕಳು ಮರಿ.
ಪ್ರೆಗ್ನೆನ್ಸಿ ಇರೋರ್ನೆಲ್ಲಾರು ಸೇರಿಸಿ ಸುಮ್ನೆ.
What is this?
I'll secure.
What will seek instructions?
Yes, my lord.
Mass crime in 447, 427. Who is the complainant?
Complaint
Lord,
is
prior to 6 months, my lord,
Gangadhar.
civil suit
No, that
litigation
I
was pending.
see. A complaint is registered against these petitioners in crime number 144 of 2024 for the following offences. The complainant alleges criminal trespass and mischief as obtaining under section 447 and 427 of the IPC against 70 accused who has done what is not indicated in the complaint. Mass complaint is registered against all people residing in the village. Therefore, there shall be an interim order of stay of further investigation qua the petitioners till the next date of hearing. Yes, next.
114.
2 and 3, 498A is 2621.
115.
KP Act 7980. Permission ತಗೊಂಡಿಲ್ವಾ?
They have taken permission. It's covered by lordship judgment.
Andar bara.
Please, madam.
Yes, madam. Kodi.
Page number 63.
Page 63, yes, Harish.
Permission.
Permission bidi sir, andar bahar.
Yes, under bar.
Page 63 covered. Yes, page 63. Please. Yes, post. Great.
116.
Charge sheet file ಆಗಿಲ್ವಾ ಇನ್ನು?
My lord, even that, I have cleared the loan in 2021 itself, my lord.
The petitioner is before this court calling in question so and so. The crime is registered on a private complaint being registered in PCR 147 of 2021, which nowhere meets the law as laid down by the apex court in the case of Priyanka Srivatsava or Babu Venkatesh. Apart from the fact, the learned counsel for the petitioner submits that the loan, which is the subject matter of the proceedings, has been cleared long before the registration of the complaint. Huh?
1 day prior.
1 day?
Yes, my lord. On 22nd, they filed the PCR, my lord.
1 day prior to.
Prior to the.
1 day has cleared the loan 1 day prior to the registration of the private complaint itself. On all these factors, there shall be. Next.
17.
The petitioner, lordship. This case, lordship, the offense has been 323, 504, 506, lordship. Same
323, 341 ilva?
ಇಲ್ಲ sir.
341.
Ilva?
Charge sheet ಅಲ್ಲಿ.
Charge sheet ilva?
Same incident ಗೆ 2 FIR register
ಅಲ್ಲ,
ಆಗಿದೆ.
341 ilva ನೋಡಿ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಇಲ್ಲ. 323, 504 and 506.
ಇನ್ನೊಂದು FIR ಏನಾಗಿದೆ?
ಇನ್ನೊಂದು FIR ಅಲ್ಲೂ ಸೇಮ್ ಇದೆ.
Stay ಆಗಿದೆಯಾ ಅದು?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಆಗಿಲ್ಲ.
Learned counsel for the petitioner submits on the same set of facts and on the same cause of action. 2 crimes are registered. One in crime number
Crime number 50, lordship.
50 of 20
3.
of 2023 and the impugned crime.
Another is a 51.
And the impugned crime.
Charge sheet
Therefore,
also
there
has been
shall
filed.
be an interim order of stay of further proceedings on the said.
Another serial number 150 is there, lordship. That is the crime number 51, lordship.
You are in a hurry.
Yes.
Yes. Wait, sir. Yes, next.
Same incident. That's
ಅದೇ ಅದು ಈಗಲೇ ಕೊಡ್ಬೇಕಾ?
lordship.
ಇರಿ.
Yes.
In crime number 51, my lord, 341 is there.
ಅದೇ ಎಲ್ಲೋ ಡೌಟ್ ಬಂದಿದ್ದ. Anyway, yes. ಇದು 51 ನಾ 50 ನಾ?
50, lordship.
ಆಯ್ತು ಸರ್. Next.
18.
Yes, appear for appeal.
Husband.
Husband compromise ಆಗಿದೆ 13 lakhs permanent elimination.
ಯಾವತ್ತು ಕರ್ಕೊಂಡ್ ಬರ್ತೀರಾ? ಸೆಟಲ್ ಮಾಡಿ.
ಒಂದು 2 weeks ಅಲ್ಲಿ time.
22nd?
22nd.
22nd at 2:30 PM to report.
Along with connected matter, criminal petition 61.
Tagged so and so.
61, 62 of 23. ಇದರಲ್ಲಿ stay ಅವರು ಅಲ್ಲಿ charge sheet.
Till the said date, there shall be an interim order of stay of further proceedings before the concerned court. On the aforesaid score of compromise. Next.
Then 19.
Petition. It is civil in nature.
Who is in possession?
Mila.
Who is in possession?
Actually, the land is in dispute.
Civil suit pending is.
Civil suit pending ಇದೆ.
Then ತೊಂದ್ರೆ.
ಅದರಲ್ಲಿ ಇಂಜಂಕ್ಷನ್ ಕೇಳಿದ್ದೀನಿ, ಅದು
ಕೊಟ್ಟಿಲ್ಲ ಅಲ್ವಾ?
ಸೆಟ್ ಬ್ಯಾಕ್ ಕೊಟ್ಟಿ ಅಲ್ಲ, ಇನ್ನು ಸ್ಟಿಲ್ ಪೆಂಡಿಂಗ್.
Let the complainant come. One additional SPP 2 emergent notice. Next.
Stay.
120.
Returnable by 5th December.
Date me. Date
5th.
120.
Lords, it's the case of.
Invalid check.
Lords?
Invalid check.
Yes, my lords. Bank purchase. Lords.
One emergent notice to the respondent in the meantime.
Stay may be granted.
Right. Granted, sir.
121.
Granted, sir.
Yes, sir. 421.
FSL.
FSL negative.
Huh?
Forgery ಆಗಿಲ್ಲ ಅಂತಾನೆ ಬಂದಿದೆ.
ಆಗಿಲ್ಲ ಅಂತ ಬಂದಿದೆ.
ಆಗಿಲ್ಲ ಅಂತಾನೆ ಬಂದಿದೆ.
Learned counsel for the petitioner takes this court through the documents appended to the petition with particular reference to the forensics opinion of the forensic science laboratory, which is indicative of the fact that there is no forgery. In that light, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing. Next.
122.
The petitioner wife has filed a complaint.
In the meantime, emergent notice in the meantime. Next.
In the meantime, stay.
Dates.
Agreed number 2 and already granted.
Take this petition along with so and so. Same order.
124.
Latif, 2015 CC.
Proclamation is, I am seeking, Lord, the.
Why you did not appear before the court?
Lord, the summons was served, Lord, subsequently they renumbered, the case was renumbered. He is a government servant, not he ready to appear now, because of the proclamation.
When is the next date?
Next date I'll appear. If it is proclamation is date, I'll appear on next date.
The proclamation that is hanging on the head of the petitioner shall remain state subject to condition that the petitioner would appear before the concerned court on the next date of hearing. In the event he would not appear, the interim protection granted today would automatically vanish. Yes,
125.
emergent notice in the meantime.
Twenty-six.
Either one HCGP, two emergent notice in the meantime. ಇಬ್ರು ಬರ್ಕೊಂತಾರೆ.
27.
ಆಮೇಲೆ in the meantime.
Case and counter case, my lord. There is a civil litigation also between the parties. There is a stay in the other case, page
Number.
115,
Number,
11285 of 2023.
copy ಇದೆಯಾ?
Yes, 115 I'll produce ಮಾಡಿದ್ದೀನಿ. Page 115, annexure P.
Page 115, tag Justice Hemant or Lord. Yes, next.
Let
128.
28, my lord, of KP Act. The allegation is.
7980.
7980. They have not sought any permission from the honorable.
Yes, Harish, yes, permission ಇದೆಯಾ ಇಲ್ವಾ?
Permission ತಗೊಂಡಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ?
Assistant Commissioner permission. I'll produce my lord.
Assistant Commissioner.
Yes, ma'am.
That is warrant,
As
my lord.
per-
No permission has
Sir.
been sought from the magistrate.
ರಿಜಿಸ್ಟರ್ ಮಾಡಕ್ಕೆ ಕ್ರೈಮ್ಗೆ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಪರ್ಮಿಷನ್ ತಗೊಂಡಿದ್ದೀರಾ ಇಲ್ವಾ?
Magistrate permission is not.
ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನ್ ಪರ್ಮಿಷನ್ ಯಾಕೆ ತಗೊಂಡ್ರಿ ಸರ್?
81 subclass 1 ಪ್ರಕಾರ.
ಅದು ಸರ್ಚ್ ಮಾಡಕ್ಕೆ.
Search.
The learned counsel appearing for the petitioner submits that the offence alleged are the ones punishable under section 79 and 80 of the Karnataka Police Act. The permission of the learned magistrate as required under section 155(2) of the CRPC is admittedly not obtained in the case at hand as the offences are non-cognizable. The learned HCGP on instructions and verification of the records should submit that no permission is sought from the hands of the magistrate. The issue in the list stands answer 2020 ILR 630 Vagepa. Load cost. Next.
129.
The petitioners are the family member.
2 to 8. Envision. 2 to 8, 2621. The ILR 26, sorry. SCC online, SC page 2621. Next.
130.
506, 507 and 204 for charge sheet. There was some ill will.
Page 31, 32.
Charge sheet.
Page number 68, my lord.
Not a case for stay. One additional SPP, two emergent notice.
Public.
131.
Yeah, Gurudev. No representation, 4 weeks. ಇದು
130.
ಪ್ರೊಕ್ಲಮೇಶನ್ ಸೇಮ್ ಆರ್ಡರ್. ಯಾವುದು ಈ ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್ ಏನದು?
Not 124.
124 ಏನ್ ಆರ್ಡರ್ ಆಗಿದೆ ಅದೇ ಆರ್ಡರ್. ಅದು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದಲ್ಲ? ಬೇಡ ಬಿಡಿ. ಎಸ್
133.
Let's. SC Act.
ಪೇಜ್ 28.
Page 20. No allegations.
Gone.
Let's, he has not abused at all. According to the charge sheet government, there is no abuse touching his caste.
Why? Yes.
ಮಾತ್ರ ಅಂದಿತ್ತು. That will not.
Yes, Harish.
And they were not present, 1, 2, 3 were not.
That is a matter of evidence.
Page number 28, my lord.
No.
ಆರೋಪಿ ಒಂದರಿಂದ.
Hurling abuse taking the caste ಇದೆಯಾ ನೋಡಿ.
Please.
ಎಲ್ಲಿ?
Please, my lord.
ಕಾಸ್ಟ್ ತಗೊಂಡು ಅಬ್ಯೂಸಸ್ ಹರ್ಲ್ ಮಾಡಿದಾರ? ಕಾಸ್ಟ್ ನೇಮ್ ಮೇಲೆ ನೋಡಿ. ಪೇಜ್ 28 ಹೋಗಿ. All other offenses I will not stay except atrocities.
Let's, to attract other offenses, that's 1, 2, 3, according to the complainant, they were not present.
That is a matter of trial.
And let's accuse number 4, who had assaulted the other 2 witnesses, please, they go to the hospital case is in Rajendra Hospital and
ಕಂಪ್ಲೀಟ್ ಚಾರ್ಜ್ ಶೀಟ್ ಮಟೀರಿಯಲ್ ಹಾಕಿದ್ದೀರಾ ಇಲ್ಲಿ?
charge sheet ಹಾಕಿದ್ದೇನೆ.
ಅಲ್ಲ, ಕಂಪ್ಲೀಟ್ ಚಾರ್ಜ್ ಶೀಟ್ ಮಟೀರಿಯಲ್ ಹಾಕಿದ್ದೀರಾ?
Complete
ಅಲ್ಲ, ಎಲ್ಲ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಎಲ್ಲ ಹಾಕಿದ್ದೀರಾ?
statements that.
Get the charge sheet material.
Please, madam.
I'll take it on Friday, 8th in the fresh matters list.
Agency register does not speak about.
ಅಲ್ಲ, 8th in the fresh matters, we'll see.
134,
Same, 4 weeks, no representation.
35,
Desu Reddy. Same, 4 weeks. ಅದು ಯಾರು ಬರ್ತಾರೆ ಮಧ್ಯಾಹ್ನ ನೋಡೋಣ.
136,
Delay in lodging the,
ವಾಪಸ್ ಕೊಡಿ, ಡಿಲೇ ಬಿಡಿ.
ಅಲ್ಲ, accused number 2 is the amount is,
ತಗೊಂಡ್ರದ್ದು ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ.
ಅಲ್ಲ, ನಮ್ಮ ಹತ್ರ ಇಲ್ಲ. Accused number 2 ತಗೊಂಡ್ರು. The huge amount is 21 lakhs is kept in the room with the performing the puja. That is a doubt.
ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ಯಾರು ಸರ್?
Accused number 2 is a unknown person ಅಂತ ಹಾಕಿದ್ದಾರೆ.
ಹ್ಮ್.
But remand application.
ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ಯಾರು ಸರ್?
Obin Ajmer.
Huh?
Obin Ajmer, remand, page number 17.
Who is he? Your husband?
ಅಲ್ಲ, ಹಸ್ಬೆಂಡ್ ಅಲ್ಲ.
ಹಾ.
ನಮ್ ಜೊತೆ ಬಂದಿದ್ದಂತ ಅವ್ರು ತಗೊಂಡು ಹೋಗಿದ್ರು. That is the.
Give it back. 1 additional SPP, 2 emergent notice. ವಾಪಸ್ ರೆಡಿ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ. Yes.
137,
Parents of petitioner. 5 ವರ್ಷ ಆಗಿದೆ.
ಹಾ?
5 ವರ್ಷ ಆಗಿದೆ.
ಯಾವಾಗ ಆಗಿದೆ?
2009.
9 ಅಲ್ಲೇ ಆಗಿದೆಯಾ?
Please.
Emergent notice to the respondent in the meantime. Next. Stayed.
138,
Please.
Yes. In the meantime.
39,
A2 to A4, 498A. Yes.
My lords, may I make one submission?
No submission. You are late.
My
Wait.
lords, I am not keeping well, my lord. By the time I could connect, my lords.
All right.
131.
Wait. Yes. Come at 2:30.
Obliged.
406, 420 and 120.
Serial number ಯಾವ್ದು ಮೇಡಮ್?
One part.
ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆಯಾ?
Petitioner is purchaser. Compromise with,
You are accused number 2. Yes.
Yes, ma'am. Forged the death person's.
Alla, he is the purchaser.
purchaser is accused number 1.
You are accused number 2.
Yes,
ನೀವು purchaser.
purchaser from accused number 1.
Who is accused number 1?
My vendors, accused number 1 is acquired the property through GPA award.
The petitioner is said to be the purchaser from the hands of accused number 1, who is said to be the GPA holder from the hands of the complainant. In the light of the petitioner being the purchaser and no offense of either 406 or 420 being made against him against him on a perusal at the summary of the charge sheet, there shall be an interim order of stay. Next.
Please.
41,
1780 of the PPR. Page 86.
Covered.
Covered.
Page?
86 months. Last decision.
Yes, Harish.
Yes, madam. Covered.
86 page.
Covered.
42,
Let's stay.
Dispose, sir.
Please.
Dispose ಆದ್ಮೇಲೆ stay.
Yes.
There is already decree of diversement, page number 80, I have produced. Copy of the judgment I have produced, page number 80.
In the meantime. Yes, next.
143,
I prefer petitioner in this case.
Petition, the HCGP is directed to secure the investigation papers and place it before the court on the next date list on 15th in the fresh matters list.
Much obliged.
Next.
44,
For petitioner.
The petitioner is before this court calling in question so and so. The offense alleged is the one punishable under section 507 and 509 of the IPC. Though the ingredients are in the first blush met in the complaint itself is registered after about 8 months of the said incident, which is unexplained. Solely on that ground, there shall be an interim order of stay of further proceedings, square the petitioner till the next date of hearing.
45,
Let's select this 500 for.
CC of 2018, sir.
Yes, ma'am.
CC of 2018.
Cognizance was taken in 22. And
Petition is filed in 24.
24.
Why should I interfere?
No, my lord, my submission is only this, sir. The summons was issued in 22.
What is the stage now?
Now, it is at the appearance stage. The respondent number 4.
Let the respondent appear.
The petitioner number 4 has received the summons on the last occasion.
Heard the learned senior counsel Ravindranath appearing for the petitioner, Ravindranath Kamath appearing for the petitioner. Emergent notice to the respondent, returnable by 4th December.
No, my submission is only this, my lord. So far as accused number petitioner 1, 2, 4 are concerned, the paper publication only states that there was a meeting in the panchayat. The petitioner number 1 has given a complaint. That's all. There is no defamation in the newspaper.
List on 4th December.
Please.
Because it's a very old matter. Yes, next.
The summons has come to the petitioner.
Yes.
Number 3
on that date. Yes.
146.
No, I want the investigation papers. List on 15th. The learned HCGP is directed to secure the investigation papers. The said date. Next.
47.
2, 3 and 4, 498A. 2621. Yes, next. Time
148.
beka.
Yes, Lord.
Time beka.
No, Lord.
Stay beka.
Yes, Lord.
For type. Yes, next.
Much obliged.
148.
Others, identical matter. 148.
Yes, my lord. Smart. Sorry, I appear in 148.
148 new.
148.
Raghuram.
Raghupati. And Raghuram. My lord,
Identical
my lord,
matters.
there are two other matters, my lord, 168 and 169, my lord. They're both
Awagi,
coming up.
okay. So we'll take it along.
Please.
149.
I appear for petitioner.
Which are the suits pending? OS.
4 cases, sir.
The
Total
OS ಹೇಳಿ ಅಲ್ಲ.
OS number, P&SC 516 of 2022, OS number 5025 of 2022, OS number 6178 of 2022, OS number 439 about 2023, all cases filed by the petitioner against the respondent.
You are in possession of the property.
Yes, Your Honor. We are in possession of the property and the registered gifted.
The petitioners have instituted several suits against the complainant seeking interference with the peaceful possession. It is later the complainant registers the crime in crime number so and so for offense punishable under section 448 of the IPC inter-alia. In the light of the pendency of the civil suit between the parties and the petitioner being in possession, there shall be an interim order of stay for the proceeding petitioner. Next.
150.
Petitioner.
Page 25. Page 25.
Charge sheet, Lord.
ಅದೇ ಎಲ್ಲ ಇದೆ.
In this case, no lordship. In this case, lordship, crime number 49, I registered, they assaulted against me. I have given the complaint
Crime
and
number 49 ಏನಾಗಿದೆ?
charge sheet was filed, lordship.
ಎಲ್ಲಿದೆ? Get the details, get the records.
Yeah, it is there, lordship.
List on Thursday in the fresh matters.
It's there, lordship. Charge sheet is there, lordship.
Charge sheet. ಯಾಕೆ ಹಾಕಿಲ್ಲ?
49 is my case, lordship.
So what? ಹಾಕ್ಬೇಕಲ್ವಾ? ನೀವು
That
ಹಾಕಿರೋ
case, I am a complainant, lordship, against
So
them.
what, sir? You should produce everything that is in your favor.
The same incident they have registered, lordship, the two
Okay,
cases,
yes.
lordship.
List on Thursday. The learned HCGP is direct to secure the entire investigation papers. Next.
151.
One additional SPP to emergent notice husband.
Tag the petition. Tag the petition.
Tag the petition so and so. Tagging the, it's made clear, tagging the petition would not mean an interim order of stay away the husband. Yes.
152.
Page 34, sir. Ella ide. All allegations. Page 34.
That's it. Complaint is not by the wife. Complaint by the mother-in-law. And
Anybody?
that too, after a long lapse of time. That is one aspect of the matter. I only invite my lord's attention to annexure
E, page 84, my lord. Page 84,
No,
annexure
these
E.
offences would not merit any interdiction. ಆಮೇಲೆ ನೋಡುವ.
ಮದುವೆ ಮಾಡಿಕೊಳ್ಳಲು ನನ್ನ ಯಾವುದೇ ಅಭ್ಯಂತರವಿರುವುದಿಲ್ಲ. ಅದೇ ರೀತಿ ನಾನು ಭೇಟಿ
Eyewitness.
ಬೇರೆ ಮದುವೆಯಾಗಲು ಎರಡನೇ ಪಾರ್ಟಿಯಾದ ಸೊ ಅಂಡ್ ಸೊ ಬೆನಕ ಎಚ್ಚರವರು ಸಹ ಒಪ್ಪಿ ಬದ್ಧರಾಗಿರುತ್ತಾರೆ. ನಾವಿಬ್ಬರು ಬೇರೆ ಮದುವೆಯಾಗಿ ಅವರವರ ಜೀವನ ನೋಡಿಕೊಳ್ಳಲು ನನ್ನ
ಕಷ್ಟ ಸರ್.
ಇರುತ್ತದೆ. That is one.
Statement ಆಯ್ತು, but
That is
allegations are there.
Then, my lord, second one. They
No,
filed,
let the complainant come.
no, they filed a petition for divorce. That is also by consent allowed because in the, before the mediation, they have agreed for it. Kindly see the report of the mediation and also the
It's all right.
certificate that is given by the party.
They issue notice. One heard the learned counsel R. B. Sadashiva appearing for the petitioner. One additional SPP, two emergent notice.
153.
May request for a stable.
I would have granted myself.
I leave.
This case of petitioner, this is the second FIR against the husband by the wife, your lordship. The first
ಏನಾಯ್ತು ಫಸ್ಟ್ ಏನಾಗಿದೆ?
charge sheet agide
ಹಾ.
as against respond number 2, that is the mother of the husband,
ಹಸ್ಬೆಂಡ್ ಮೇಲೆ ಏನಾಗಿದೆ?
charge sheet file agide.
ಎರಡನೇದ?
ಎರಡನೇದು.
Please, your lordship, but he has
First-
assaulted the minor.
Huh?
Minor son. MLC reported page 41. Yeah.
ಚಿಕಿತ್ಸೆ ಪಡೆದು ಏವನಾರು ತೊಂದರೆ ಇಲ್ಲ. One additional SPP, two emergent notice.
Your lordship.
No. Next.
54.
Doctor 304.
Delay of 3 years and 8 months.
Medical negligence. Injection.
Death.
There is no whisper about the petitioner's name anywhere, not even the person.
The petitioner is a doctor by profession. Is said to have treated his patient 3 years ago. The patient dies later, is it? Or death avagla?
After 3 days. That is the year
The
2000.
patient dies after 3 days of the treatment. The complaint is registered after 3 years of the death. Even otherwise, the petitioner having taken all precautions and the treatment that is necessary to be given to the patient, an offense under section 304 cannot be laid unless there is mens rea on the part of the accused. That is not the allegation and that is not the ingredient of the complaint even. On the aforesaid score, if further proceedings are permitted to continue, it would run foul of the judgment of the apex court. The case of Anbalagan versus State of Tamil Nadu, reported in 2023 SEC Online SC page 857, which delineates the difference between 304A and 304 of the IPC. Therefore, there shall be an interim order. Next.
155.
Petitioner.
Case and counter case.
We will discuss.
107 and 109 in the meantime. Yes, ಅವರು ಬರ್ತಾರೆ ಎರಡು quash ಮಾಡೋಣ.
There is a date fixed for appearance on
I have already stayed, sir. Yes.
56.
406, 420.
No offense has taken place in Bangalore. He has lodged a complaint, please, my lords, against the original partner with Metagally police station, please, my lords. My lord would kindly find it in page number 16162.
Yes, madam. ನೋಡಿದ್ದೀರಾ?
Please, your lordship.
ಏನಿಲ್ವಾ?
Plus civil.
ಮಾಡ್ಲಾ?
ಬೇಡ.
ಬೇಡ್ವಾ? ಬೇಡ ಅಂತ.
My lord would kindly take 167, my lord. He himself, my lords,
He has
would come into the
utilized.
picture only after, my lord, all the initial transaction would take place with the other partner. He lodges a complaint against the other partner, in which, my lord, he accepts that, my lord.
Let's
Everything has been done by the other partner. He has no.
Day after tomorrow is the fresh matters list. Yes.
My lord was pleased to, my lords, in the crime stage, please, I have filed the petition. My lord were about to dictate.
About to dictate.
About to dictate. By then, my lord, the
I will dictate on
decision
Wednesday.
stated that, my lord,
On
charge sheet is filed. Thereafter, my lord directed me to file it,
ಕೊಡಿ.
file the petition.
ಯಾವತ್ತು ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ದು?
27/8/2024, please, my lords. The learned HCP submitted, my lord, that charge sheet is filed. Thereafter, my lords, I obtained the certificate copy of the charge sheet
In
and
the meantime, yes.
please.
Next.
157.
MTP,
My presence not there, my lord.
you are present, not there.
ನಾನು ಇಲ್ಲ ಅಲ್ಲಿ. ಆ place
ನೀವು
name-
ಇಲ್ವಾ
I am
ಅಲ್ಲಿ?
residing in Bengaluru, my lord. I filed a,
He has taken a ground that is not,
I filed it. Footage also, my lord.
Additional SPP is directed to accept notice for the respondents. List on 27th. Go through the papers and makement. Yes.
Same.
Not in MTP. Yes, next.
Any date may be, my
27th.
please.
Husband on bit eldergo. Same. Yes.
59.
Heard the learned senior counsel R.S. Ravi appearing for the petitioner in the meantime. Next. One edit HCGP to emergent notice.
60.
160, I appear for the petitioner. The petitioner is a father. Sons were directed to pay rupees 3,000.
That is cancelled.
Cancelled.
Notice ಮಾಡ.
My lord,
Entry model restore ಮಾಡಕ್ಕಾಗತ್ತಾ?
I'll stay there because there is.
I'll
no-
let stay will grant. So
ಈಗ
One-
without the 3,000, my lord.
1 minute, sir. We'll give a date also. As emergent notice to the respondent. Petitioner is at liberty to serve on the counsel who represents the respondent in the trial proceedings. The maintenance that was granted by the concerned court is
Interment.
interment. Interim maintenance granted to the petitioner by the concerned court is cancelled by the revisional court. This is the order that is called in question. Therefore, there shall be an interim order of stay of further proceedings. Revisional court, same court.
Same court.
Therefore, there shall be an interim order of stay of further proceedings before the court till the next concerned court till the next date of hearing. Next.
Date may be.
160.
Serve ಮಾಡಿ.
Demand.
Serve ಮಾಡಿ 26th November. List on 26th November.
161.
353, my lords.
charge sheet,
Page 61 covered.
please, yellow.
Page 61 covered.
Please, madam. Manik Tane.
Huh?
Manik Tane, this third one.
161.
ನೋಡಿಲ್ವಾ ಮೇಡಮ್?
ಅಲ್ಲ, CC of 2020, your lordship.
ಪೇಜ್ 61 ಅಲ್ಲಿ ನಂದೇ ಜಡ್ಮೆಂಟ್ ಇದೆ ಕವರ್ಡ್ ಅಂತ ಕೇಳಿದ್ದೆ ಅಷ್ಟೇ.
ಹಾಕಿಲ್ಲ.
ನೋಡಿಲ್ವಾ?
ಇಲ್ಲ, ಅವ್ರು ಹಾಕಿಲ್ಲ.
ಹಾಕಿಲ್ವಾ? ಪೇಜ್ 61 ಅಲ್ಲಿ ಇಲ್ವಾ?
No, madam. Then take a Manik.
Serial number 161, your lordship.
ಮಾಣಿಕ್ ತನೇಜ ಕವರ್ಡ್.
Please.
61 ಇದೆಯಾ ಮೇಡಮ್ ನೋಡಿ? ನಾನೇ ಓದಿಲ್ಲ ಅಂತ ತಪ್ಪಾಗಿ ಓದ್ಬಿಟ್ಟಿದ್ದೀನಿ.
ಅಲ್ಲ,
ಪೇಜ್ 61.
ನನ್ಗೆ ಹಾಕಿಲ್ಲ ಇದ್ರಲ್ಲಿ.
ನಿಮ್ಗೂ ಗೊತ್ತಿಲ್ವಾ? What is this? We'll dismiss the case on this ground. Yes.
Apologize.
ನೋಡಿ ಮೇಡಮ್, ಫೈಲ್ ಕೊಡಿ ಅವ್ರಿಗೆ ಪಾಸ್ ಓವರ್. Yes, next.
162.
Page number 5, discharge application.
Discharge
302, sir.
application.
Not, madam, no allegation.
No.
madam. Only second conclusive statement of litigant by first accused, madam.
302, sir.
Assisting for disposal of the body, your lordship. 302.
ಸಾಕು. Nothing doing.
Allegation.
No, no.
No,
Discharge reject ಆಗಿದೆ.
Discharge application rejected, madam.
Not in a 302. ಅದೆಲ್ಲ ಮ್ಯಾಟರ್ ಆಫ್ ಎವಿಡೆನ್ಸ್.
Speedily disposal.
ಯಾವ ವರ್ಷದ ಸರ್?
2022, yes.
2022? No, murder case ಅಲ್ಲಿ 302 ಆಗಲ್ಲ. Yes, you urge all the contentions. The learned counsel for the petitioner is accused number 3.
Accused number 5.
Accused number 5, who is alleged of the offence punishable under section 302 and 201 of the IPC. The specific allegation against the petitioner is helping the other accused in disposal of the body alleged to have been killed by others. Therefore, it is for the petitioner to face trial and come out clean in the same. The reserving liberty to the petitioner to urge all contentions before the concerned court, the petition stands disposed.
163.
490.
Husband,
But earlier they have filed same case and they got acquittal. Have produced a certified copy of the order.
the petitioner is the husband, was charged of the same offence by the wife which had become the subject matter in CC 4503 of 2024, in which the husband gets acquitted on 4th March 2022. Again comes the same crime for the same offences. Therefore, there shall be an interim order of stay of further proceedings, further investigation, quay this petitioner till the next date of hearing. Next.
64.
The allegation against the petitioner is before this court calling in question sounds. The allegation against this petitioner is the alleged receipt of excess money for an apartment which is the subject matter before the RERA. The consumer before the RERA. In that light, there shall be an interim order of stay of further proceedings where the petitioner to the next.
There is a violation of the order, my lords. That is the main content of the complaint.
See, yes, next. Of RERA.
Please, my lords.
yeah.
However, the order was not operating against me.
Yes, next.
65.
Has been already decided by the Honorable Session.
Huh?
Honorable Sessions Court. He approached the, respondent approached the Honorable Sessions Court.
Discharge.
Approached the civil court, civil case, civil dispute, criminal convert.
Convert madadra.
Already, this allegation has been issues involved with
The
the
petitioner is
allegation, already
before this.
decided by the Honorable Sessions Court.
ಏನಾಗಿದೆ ಹೇಳಿ sir?
In OS number 73.
OS number ಆಯ್ತು crime bad wife.
Same person filed a complaint.
ಬರೆಯಕ್ಕಾದ್ರೂ ಬಿಡಿ. Yes.
My lordship.
The petitioner is before this court calling in question sounds. For an incident that happens in the year 2006, the complaint is registered in the year 2024. The learned counsel for the petitioner submits that the complainant and the petitioner were before the civil court in OS.
OS number 73, 64 and 65 of 2010. And OS number, another OS also filed by the, he failed in OS now, in OS 5814 by 2013. Before
And all of them have ended in favor of the present petitioner. It is after that the crime is registered by the complainant. Therefore, there shall be an interim order of stay of all investigation quay the petitioner till the next date of hearing. Post the matter in the usual course in admission. 1 HCGP to emergent notice.
166.
Yes.
Civil dispute is pending, your lordship.
166. Page 55. Civil dispute pending. No representation 4 weeks. Next.
167.
The petitioner and the complainant are in a dispute in OS 600 of 2024. On the same set of facts, the complainant seeks to set the criminal law into motion. Therefore, there shall be an interim order of stay for. Next.
68.
168, 169.
169 and 148, my lord. It's a non-compete dispute with ex-employees. that
What
are
do you
already-
want?
Lord, I'm seeking a stay, my lord.
No, have I granted stay in identical
No, my
cases?
lord.
Illa
No, my
la?
lord. All three are coming up for the first time. There is a suit and an arbitration proceeding.
Anyway, then list them both day after tomorrow in the fresh matters list.
Please.
Next. Adu seri, all three day after tomorrow in the fresh matters list.
170.
My lord, I appear for the petitioners in item
Madam,
1.
this has connection with the one that I have said not before me. I will not take this. You let it be heard along with the other cases.
My lord, this
Which are
has,
the other cases?
my lord, this is not at all related to the subject
Then
matter.
I'll record that and then hear you.
My lords, this is not at all related to that, my lord.
Because in the pleading, I saw you make a mention about the other case.
My lord, that is just to show that there is a bona fide litigation pending between the parties, and that is not related to the parties inter se, which is the subject matter of litigation before this honorable court in another round of petition, my lord.
The petitioner is before this court calling in question the proceedings in CC 7987 of 2023 registered for offense punishable under section 499 and 500 of the IPC. This court was doubtful whether the matter could be taken up as it had the overtones and connection with the matter that that this court had directed not to be placed. This court had directed to be placed before any other bench. The learned counsel for the petitioner Nisha Tiwari submits that this case has no connection with the other case which this court had directed to be posted before some other bench. The said submission is placed on record. In the light of the said submission, emergent notice to the respondent, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing. Yes.
Great.
Next. Stay application idea? Ellida? Stay application is there?
My lord, prayer has been incorporated in the main body of the petition, my lord.
Madam, it is criminal petition, not a writ petition. What is all this?
My lord,
You should file a separate stay application.
my lord, that too.
E-court procedure ಏನು? Yes. Then very interim order, no interim order, you file an application, then we will pass. Otherwise, let this be there.
We'll file it.
When do you want it?
My lord, the prayer to that effect has been made at page number 21.
Madam, that's not the procedure here.
We will file.
If you have filed a writ petition, that's the procedure. It's a criminal petition, so you'll have to file an application for stay.
My lord, tomorrow I'll file it.
All right, fine. ಹೇಳ್ಬೇಕು ತಾನೆ?
My lord, tomorrow you'll.
ಅಷ್ಟೊಂದು ಕೇಸ್ ಹಾಕ್ತೀರಾ? List tomorrow, all right, tomorrow.
Grateful, my lord.
Then I will not pass any order. The same thing I will repeat tomorrow.
File it, my lords.
My lord,
We'll
obliged.
file the interim stay application. We'll
ಈಗ
file.
2:30 file ಮಾಡಿದ್ರೆ? Will
Yes,
you file it by 2:30?
My lord,
All
obliged.
right.
We'll
Then this order will remain.
Yes.
You file an application and move it. Place it before the file.
We'll do that.
Yes, next.
I'm grateful, my lord.
Yes.
171.
Here for the petitioner.
Page 17.
Serial number 214 is a counter case. Both are brothers. They want to settle the issue.
Very good. Yes.
214 serial number.
Tag 214 tag ಮಾಡಿ. One HCP2 emergent notice ಯಾವತ್ತು ಹಾಕ್ಲಿ?
Next week.
List on 14th ಹಾಕ್ಲಾ? List on 14th November at 2:30 PM to report settlement. Yes. Madi, the learned counsel for the petitioners would submit that the matter has been settled between the parties to report settlement on said date. Yes, next.
172.
My lord.
What is Ninja Cart?
My lord, they got into an agreement with accused
What
number
is
one.
Ninja Cart?
They are an
Or,
company
what?
that gets into agreements to supply agricultural goods. So they are a sort of an intermediary, my lord. So they got into an agreement with accused number one to supply these agricultural goods, which they have allegedly procured from me, accused number 2 and 3. Even if the allegations in the complaint are taken to be true, although I have actually not entered into any agreement, I am myself a victim of fraud in this case. Admittedly, as per their complaint, I have supplied those goods, my lord, and that has been received by accused number one, and they have paid me as per their complaint, my lord.
Madam?
On payment of business transaction.
One HCP2 emergent notice in the meantime. Next.
173.
2 and 3, 498A.
For the husband as well, the allegations are only this thing. One is the assault. In fact, your lordship.
One is assault, alva?
No, the
That is
first
enough.
allegation is also, no.
That is
In
enough.
fact, the petitioner has been assaulted, your lordship. We had filed a complaint in Bahrain.
But husbands are these days telling they are assaulted by wives.
Photographs are attached. Complaint may be taken up at page number 31, your lordship.
This is the fourth petition where husband is saying, I've been beaten by my wife.
He's been assaulted.
Seriously?
Yes, the photographs have been annexed, your lordship, at page number 35. 31 is the complaint at Bahrain against the wife for assault. Then 34.
ಯಾರ್ದು ಕೈ ಇದು?
It is his hand, the husband's petition number 1's hand. The photograph 30 from 34 onwards, 36, 37 as well.
ನೀವೇ ಕುಯ್ಕೊಂಡ್ಬಿಟ್ಟು ಫೋಟೋ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದೀರಾ?
No, that has been reflected in the complaint, your lordship, for the authorities in Bahrain. One. The second allegation.
Why were you standing in front of the mirror and clicking a picture while you are cutting your hand?
No. It was a photograph to show the marks on the hand.
Oh.
The white marks. And the second allegation is regarding dowry of purchase of property. The property stands in joint name of the petitioner as well as the complainant. The property is
No, you should come out with some other ideas to get a stay.
The petitioner
Husband
is
needs to
no, the allegations
make
are
laborious
vague.
effort.
No, the allegations are vague in the complaint as well.
Vague?
Yes.
No vague.
No, in fact, the complainant has paid only 22 lakhs for the
ಈಗ
purchase of
2
the
and
property.
3 ಬೇಕಾ ಬೇಡವಾ stay?
For the one, for petition number one as
One
well.
ಅನ್ನೋ. Fighting for one, you may lose 2 and 3. ಯೋಚನೆ ಮಾಡಿ.
Because he is innocent of the alleged offences.
Serious.
Yes, yes. In fact, the wife has played a victim card here. Petitioner one is the victim.
That's why you are playing the same card here.
No, no.
Ah,
He is,
right, yes.
he is purchased the property.
2 and
property
3
stands-
stay, one, 2 and 3 stay. The stay que the husband would be considered on the appearance of the wife. Next,
Problems.
54.
split, yes, madam. Split charge sheet,
Please, your lordship,
list on 15th in the fresh matters list. Next. Shashidhar,
75.
page 22.
Case and counter case abusing each other, brother and sister.
Abusing each other, ಎಲ್ಲಿದೆ counter case ಏನಾಗಿದೆ?
Counter case is stayed by this honorable
Number
court in
ಕೊಡಿ.
the criminal petition.
So and so, yes, next. Settle ಮಾಡ್ಕೊಳ್ಳಿ. Yes. Next.
76.
That petitioner is alleged to be accused number 53, my lord, wherein in FIR, his name is not specifically mentioned, my lord.
Charge sheet ಅಲ್ಲಿ ಇದೆಯಲ್ಲ ಮೇಡಮ್.
Charge sheet ಅಲ್ಲೂ particular ಆಗಿ ಅವ್ರ ಹೆಸರು ಇಲ್ಲ, my lord.
ಯಾಕೆ?
It-
ಪೇಜ್ 84 ಬನ್ನಿ ಮೇಡಮ್.
Yes, my lord.
84 and 85 ಅಲ್ಲಿ ಇಲ್ವಾ?
My lord, 85 ಅಲ್ಲಿ ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾದಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ, my lord. ಹಾಗೂ ಆರೋಪಿ ಸಂಖ್ಯೆ 3, 4, 5, 11, 13, 14, 18, 22, 24, 26, 27,
53 ಮರ್ತ್ಬಿಟ್ಟಿದ್ದೀರಾ?
53 ಇಲ್ಲ.
ಫರ್ಗಾಟ್. ತುಂಬಾ ಅಕ್ಯೂಸ್ಡ್ ಆದ್ರೆ ಹಿಂಗೆ ಆಗದು.
Please.
ಈಗ ಒಂದು the petitioner is said to be accused number 53 in column number 12 of the charge. In column number 17, neither the name of the accused nor his number as depicted in column number 12 is found for any overt act directly attributable to him. In that light, there shall be an interim order of stay of further proceedings, query the petitioner till the next date. Yes, next.
177.
Huh?
ಸೇಮ್ ಫ್ಯಾಕ್ಟ್ ಮೇಲೆ ಇನ್ನೊಂದ್ಸತಿ ಅಪೇರ್
ಏನು ಇಲ್ಲ ಮಟೀರಿಯಲ್ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನು ಹಾಕದೇ ಇಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ?
ಒಂದ್ ಕೇಸ್ ಫಸ್ಟ್ ಕೇಸ್ ಚಾರ್ಜ್
ಎಲ್ಲಿದೆ ಕೊಡಿ ಅದು?
ಪೇಜ್ ನಂಬರ್ 34 and 35 ಸರ್.
468, 420.
ಸೇಮ್ ಕಂಪ್ಲೇಂಟ್, ಸೇಮ್ ಅಕ್ಯೂಸಸ್.
Take GPA.
Same 2012. The petitioner is before this court calling in question registration of a crime in crime number 261 of 2024. The learned counsel for the petitioner submits that the very complainant had registered the complaint on the same set of facts which has become subject matter of CC 52302 of 2019. The second complaint is registered on the same set of facts, which can be gathered from the very complaint itself, as the narration begins from 1/10/2012. It is the same narration in the charge sheet of the earlier complaint. Therefore, there shall be an interim order of stay of further proceedings, query the petitioner. Next.
78.
Where is the audit report?
Lots are produced, my lords.
Page.
Page number 131, my lords. They concealed the entire
Where
audit.
audit report ಅಲ್ಲಿ relevant portion ಯಾವ್ದು?
Relevant portion is 136.
Where
Column
does it
29.
say that there is no loss or there is no misappropriation here? Which page?
ಮೋಸ ವಂಚನೆ ಹಣ ದುರುಪಯೋಗದ ವರದಿ.
ಎಲ್ಲಿ? ಮೋಸ ವಂಚನೆ ಹಣ ದುರುಪಯೋಗದ ವರದಿ. ಪ್ರಕರಣ ಇರುವುದಿಲ್ಲ, ಆಗಿರುವುದಿಲ್ಲ ಅಂತ ಎಲ್ಲಿದೆ?
There is nothing regarding to the appropriation of funds.
Misappropriation.
Misappropriation of funds.
Appropriation.
Misappropriation of the funds. The entire report does not talk anything about it.
Yes, madam.
I'll take some time, your lordship.
Take some time.
Audit, I'll seek
ನೋಡ್ಲಿಲ್ವಾ?
instructions.
Concealed the entire audit report in the charge sheet itself.
ಒಂದ್ ನಿಮಿಷ.
Regarding audit report, your lordship.
Tomorrow in the fresh matters list. Audit report ನೋಡಿ. Allegation is misappropriation of funds.
Yes, yes.
The audit report would cover his case. ನಾಳೆ.
Already it's a case and a count.
ನಾಳೆ ಬೇಡವಾ?
Irli.
Yes, ನಾಳೆ. ನಾಳೆ ಮಾಡಿ ಯಾರಿಗೆ? Yes, next.
179.
In the meantime,
Petitioners in this
2 and 3,
petitioners in this case, 180,
meantime.
180.
Accused number 2 and 3.
Right.
In the meantime, yes.
81.
Petitioner.
The petitioner is before this court calling in question so and so. A complaint comes to be registered in the year 2022 for incidents that have taken place between 2005 and 2006 without any speck of explanation for the delay in registering the complaint. Permitting further proceedings would run foul of the judgment of the apex court in the case of Chanchalapati Das versus so and so 2023 SEC online SC page 650. Therefore, there.
82.
Petitioner,
Case and counter case.
please.
ಅದೇನಾಗಿದೆ?
ಅಲ್ಲ, ಎರಡು ಪೆಂಡಿಂಗ್ ಇದೆ. The first instance ಮೇಲೆ I lodged the complaint against.
ಗೊತ್ತಾಯ್ತು, ಎರಡು ಪೆಂಡಿಂಗ್ ಇದೆ ಅಷ್ಟೇ ಕೇಳಿಲ್ವ ಅವರು?
ಇಲ್ಲ, ಅದೇನ್ ಕೇಳಿ.
ಇದು ಕೊಟ್ಟ ಮೇಲೆ ಅದಕ್ಕೆ ಬರ್ತಾರೆ ಬಿಡಿ.
Please.
ಎಸ್.
Please, your lordship.
1 HCGP 2 emergent notice. The issue is case and counter case in crime number 63 and 64 of 2024. The petition,
2024. Your lordship.
correct, ನಾನು ಅದೇ ಹೇಳಿದ್ದು. 63 and 64 of 2024. The petitioners register crime number 63 of 2024 and after a delay as a counter blast, the crime number 64 emerges. Therefore, there shall be an interim order of stay till the next date of hearing. ಇದಕ್ಕೆ ಡೇಟ್ ಕೊಡಿ. 1 HCGP 2 emergent notice returnable by 28th. ಕೂತ್ಕೊಂಡು ಸೆಟ್ಟಿಂಗ್ ಮಾಡಿ. Yes. Next.
183.
A2 498A in the meantime. States. Yes. Madam Kotal.
84.
2 and 3 498A.
185.
451 457
Release.
notice. 1 HCGP.
186.
Second R2 ಯಾರು?
Status.
State ಅಲ್ವಾ?
State.
List on 15th in the fresh matters list. Yes.
186.
In the meantime,
87.
the petitioners are 2, 4 and 6. Respondents 2, 4 and 6 in a proceeding instituted by the wife invoking section 12 of the Domestic Protection of Women from Domestic Violence Act. Finding no ingredient of any of domestic violence against these petitioners, there shall be an interim order of stay of further proceedings, square these petitioners till the next date of hearing.
Please.
Emergent notice to the rest.
180.
Post the matter in admission in usual course. ಮತ್ತೆ disposal move ಮಾಡ್ಬಿಡ್ತೀರಾ ಅದಕ್ಕೆ.
Father's offense, my lordship.
Confession.
Incident- Please.
Madam, check it. Learned HCGP is directed to accept notice for the respondent. We'll take it on 15th. Look at it.
In the mean,
No, forest offense. Sir. Yes.
89.
All offenses found.
ಇದರಲ್ಲಿ your honor, lordship kindly see, this honorable court directed them to inquiry into the matter. I mean, conduct a inquiry before you are to install the transformers. Without even following the order of this honorable court, arbitrarily they have installed.
ಗೊತ್ತಾಯ್ತು. ಯಾವ್ದು ಬಸ್ ಸ್ಟಾಪ್ ತರ ಇರೋ ಜಾಗದಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫಾರ್ಮರ್.
I produced the photograph also.
Yes, I have seen. We'll see. Yes, list on 15th in the fresh matters list. Learn HCGP is directed to accept notice for the respondent. Next. ಅವತ್ತು ಕೊಡು.
Entry ಮಾಡಿ.
Yes, because court had directed to install transformers. You could not have come in the way at all.
Before that, your lordship, they have to supposed to hear us, all the petitioner and all the stakeholders. That they have not done.
I
Complaint doesn't
we'll
speak
see
out
15th, yes.
much.
190.
Petitioner A2 498A.
298. My lord.
Yes.
The false allegations that has been placed against the mother-in-law.
Has already stay granted.
91. Much obliged.
191. Page 35. All offenses found.
in circus number 1.
Uh,
All the
Others, ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ ಬೇರೆ?
Father-in-law, mother-in-law and sister-in-law,
Ah.
3 petitions.
You're in person. What is there against mother-in-law and others, madam? Husband, you take care. All right, let her appear. No, you should bring it within 498, madam. Yes, learned, you're appearing in person? You're an advocate? Law student, all right. The learned, the respondent complainant has appeared in person, would seek a week's time to make her submissions. You should appear before the committee and make her submissions. List on 15th in the fresh matters list.
The meantime,
Parala, barli, later come.
mother-in-law, mother-in-law,
Next date in,
15th.
he says torture, we'll see. Yes, 15th. 15th, if you are not ready, I will grant stay. Yes.
92.
Please.
Uh,
No ingredients to attract 307. Moreover, the.
Page 53.
My lords, may kindly peruse page number 69, that is statement of.
Statement.
Please, my lord, which is contrary to the statement of the police official who had visited the spot and inquired accused number 1. And the witness says, when the police visited the place of occurrence, alleged place of occurrence, they ran away from the spot. Wherein CW9 Supriya, she states that I had been to the place, I have inquired accused number 1.
All these are matters of evidence.
To attract 307, there is no
Oh,
ingredients. Nor there is anything which is seized pertaining to. Just all the injuries are simple in nature as well.
307 got ಬೇಕಾಗಿದೆ. Intent. Content.
Not to the vital part.
Content later.
Not to the vital parts.
Yes. 1 HCGP 2 emergent notice returnable by 6th December. Avat noda.
Please.
Yes.
193.
The petitioner is before, petitioner is accused number 2. You obrena. Accused number 2. A perusal at the complaint or the summary of the charge sheet agideyalla? Charge sheet agidya? Perusal and summary of the charge sheet would indicate all offences against accused number 1. Therefore, there shall be an interim order of stay. Way accused number 2 till the next date of hearing. 1 HCGP 2 emergent notice. To emergent note, post the matter in admission in the usual course.
94.
The petitioner is accused number 8. A perusal at the allegations would not indicate any individual overt acts performed by the petitioner. Therefore, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing.
95.
Heard the learned counsel P. Prasanna Kumar appearing for the petitioner. The petitioner shall serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement to that effect. List the matter on 6th December till such time further proceedings before the concerned court shall remain stayed by the petitioner. Next,
96.
498A. A1 illa, all else.
A1 against.
Yeah,
because
why
The reason is,
wife has assaulted you?
no, my lord.
Ilva.
She files the complaint because husband or none of the persons from their husband's house has come out to pick her up.
You should have
reason.
dropped her.
That is the only reason she files the complaint, ma'am.
No problem. Ellargu, except husband, for the husband, it would be considered on the appearance of the wife. Next.
197. Wildlife protection.
97.
197 wildlife protection.
138 opinion.
Sorry.
Wildlife check bones. The next matter, madam, 198. The petitioner is before this court calling in question registration proceedings in CC 2499 of 2021 petitioners. The petitioners are before the court on 3 circumstances. 1, referring to para 4 of the complaint, in which the complainant himself says that the amount check was paid towards sale consideration. This is the answer elicited during the cross-examination before the concerned court. Therefore, it is prima facie not a legally recoverable debt. In that light, there shall be an interim order of stay of, madam. In para 4 of the complaint, the complainant narrates that the check was paid against a hand loan that the petitioner had taken. In the cross-examination, the complainant narrates that the check was issued, a check was taken for the sale of land,
Sale of immovable properties.
sale of the immovable property. To the income tax department as well, the complainant has projected the subject transaction to be towards sale of immovable property. If that be so, it was not a legally recoverable debt prima facie. Therefore, there shall be an interim order of stay for the proceedings. Next.
98.
Idu Wildlife HCGP is directed to accept notice for the respondents.
99.
ಕಾರ್ ಸೇಲ್ ಮಾಡ್ಬಿಟ್ರಾ?
ಸ್ವಲ್ಪ ಕಾರ್ ಸೇಲ್ ಆಗವು.
ಫೋರ್ಜ್ ಮಾಡಿ ಹೆಂಗ್ ಸೇಲ್ ಮಾಡಿದ್ರಿ?
ಕಾರ್ ನಾವು ಸೇಲ್ ಮಾಡಿಲ್ಲ, ಅವ್ರ ಸೇಲ್ ಮಾಡ್ಕೊಂಡು ನಮ್ಮ ಮೇಲೆ ಇದೆ.
ಇರ್ಲಿ ಬಿಡಿ, ಬರ್ಲಿ ಕಂಪ್ಲೇನೆಂಟ್. ಯಾರಿಗೆ ಸೇಲ್ ಮಾಡಿದ್ರು ನೋಡಿ. 1 additional HCGP 2 emergent notice. No stay. Application ಇಲ್ಲ ಬಿಡಿ ತೊಂದ್ರೆ. ಸ್ಟೇಟ್ ಇಲ್ವಾ? Why? Private complaint.
ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್.
All right, state ಇಲ್ಲ. Emergent notice to the respondent.
ಅಫಿಡವಿಟ್ ಹಾಕಿಲ್ಲ ಕಂಪ್ಲೇಂಟ್.
ಬರಲ್ಲ ನೋಡಿ. ಕಾರ್ ಎಲ್ಲಿದೆ? Yes.
100.
Just an employee in the company.
Just an employee.
Robber related transaction.
Just an employee. In the meantime, next.
Please, wait for
201.
The petitioners, my lords. My lords, this dispute has arisen out of the financial dispute between the,
Financial transaction.
please, my lords, financial transaction. There was no transaction, my lords, but the complainant alleges that there was a transaction, but in fact, there was no transaction. Because of that dispute, this case has arisen, my lords. And with respect to the delay, my lords, there's a 3 months delay which the complainant has, where he's not filed a
Complainant is an
complaint.
advocate.
Please, my lords, 25 years of practicing.
25 years of
Please,
practice.
my
Why are you concerned about his practice?
No, my lords, not
Then-
that. He had to be considerate about the delay.
The petitioners are accused so and so. Call in question the registration of the charge sheet ಆಗಿದೆಯಲ್ಲ? Charge sheet ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
Call in question proceedings in CC so and so. The second respondent is the complainant who is said to be a practicing advocate. This avocation of the complainant is projected by the petitioner to demonstrate that he would be aware of the fact that the crime should be registered immediately. In the case at hand, the incident happens on 27/3/2022 and the crime was registered on 28/6/2022, 3 months after the registration of the crime, without there being any explanation for delay. The learned counsel for the petitioner also submits that against the complainant, the petitioners have registered PCR 154 of 2018. These are all the factors that would inure to the benefit of the petitioner for grant of an interim order. Therefore, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing.
Great.
102.
Andarbar.
Please.
Andarbar. Page
61.
61. Next.
103.
Your witnesses.
A witness to a registered sale agreement.
The petitioner is said to be a witness to the registered agreement of sale which has become the bone of contention in the subject crime. The agreement of sale is appended to the petition. A perusal at which would indicate that the petitioner is witness number 1. The petitioner being an attesting witness cannot be dragged into the web of the crime, as attesting witnesses would not know the content of the document. In that light, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing. What's that? File iPad? iPad. So,
104.
you are rider of the motorcycle.
Yes.
No stay.
No negligence.
No, Amale, yes. One HCGP, 2 emergent notice. Yes.
105.
Civil proceeding, my lords.
Fresh crime, 6/7/2024, investigation papers were.
No, it's a civil
But
proceeding. After
otherwise,
filing
page 14, all the offences are found. I want to see the investigation papers.
Yes, my lords. Here, the petitioner and the complainant are both are relatives. She is complainant, say, Dodamma.
Doddamma?
Yes, my lords. After filing the OS case, she has filed this car.
Then you should settle with Doddamma.
Yes, further last.
Hmm.
will happen.
Yes, anyway, get the investigation papers, madam. List the matter on 13th in the fresh matters list. INV papers be secured in the meantime. Next.
106.
Where is the settlement? Page?
Page 54, my lord. Page 54, notice certificate. Page 55 is the affidavit of the one of the partner. And the DD copy also I produced.
Learned counsel for the petitioner submits that the issue between the petitioner and the complainant has been settled. Where he would take this court through a communication dated 23rd August 2024 and the deed of affidavit of settlement. Therefore, there shall be an interim order of stay for the proceedings by the petitioner till the next date of hearing. Emergent notice.
7.
12 of DV Act. Husband, not every time. Final
We're
hearing.
not seeking stakes. We're not seeking.
What do you want?
Notice.
Notice, granted, yes. Final hearing, Lord.
Yes.
Yes.
Please.
208.
ದುಡ್ಡು ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ.
The latest agreement entered
ಎಷ್ಟು ದುಡ್ಡು ತಗೊಂಡಿದ್ದೀರಾ?
3 lakhs.
ಕೊಟ್ಬಿಡಿ.
ಅಲ್ಲ. In the year 16 and agreement.
ಪರವಾಗಿಲ್ಲ ಕೊಟ್ಬಿಡಿ ಸರ್. ಕೊಟ್ರೆ ಎಲ್ಲ ಕ್ರೈಮ್ ಎಲ್ಲ ಖಾಲಿ ಆಗ್ಬಿಡುತ್ತೆ.
Latest
Close
agreement, my lord, in the year of 21 A2. In this regard, some family dispute partitions would also pending, my lord.
Give it back, sir.
The
30 lakhs ಗೆಲ್ಲ ಏನ್ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಕೊಟ್ಬಿಡಿ ವಾಪಸ್.
ಅಲ್ಲ ನನ್ನ ಹತ್ರ ಇಲ್ಲ ಸ್ವಾಮಿ ಅಮೌಂಟ್ A2 ಹತ್ರ ಇರೋದು ಇವಾಗ ಅಮೌಂಟ್.
ಅವ್ರ ಹತ್ರ ಇಸ್ಕೊಡಿ ಸರ್.
A2 is my sister, my lord.
ಕರೆಕ್ಟ್, ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ಇಸ್ಕೊಡಿ ಅಂತ.
Partition suit is pending, my lord.
ನೋ ಪ್ರಾಬ್ಲಮ್.
And another suit filed by the R2 also.
ನೋ ಪ್ರಾಬ್ಲಮ್.
Against me.
1 HCGP, 2 emergent notice. ನೀವು ದುಡ್ಡು ಯಾವತ್ತು ರೆಡಿ ಅಂತ ಹೇಳ್ತೀರಾ ವಾಪಸ್ ಕೊಡಕ್ಕೆ ಅವತ್ತು ತಗೊಂತೀನಿ.
ಅಲ್ಲ A2
ಸಿಸ್ಟರ್ ಅಂಡ್ ಬ್ರದರ್ ಕಲೆಕ್ಟ್ ಮಾಡಿ ಕೊಟ್ಬಿಡಿ ಕಂಪ್ಲೇಂಟ್.
ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಫೈಲ್ ಆಗಿದೆ.
ಎಸ್, ಆಮೇಲೆ
ಡಿಸ್ಪೋಸಸ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಅವರು. ವೆಕೇಟಿಂಗ್
ಮನಿ ಗಿವ್ ಬ್ಯಾಕ್ ದ ಮನಿ.
ಅಲ್ಲ ದೇರ್ ಕಂಟಿನ್ಯೂ ದಿ ಕ್ವೆಶ್ಚನ್.
ಅದಕ್ಕೂ ದುಡ್ಡುಗೂ ಏನ್ ಸಂಬಂಧ ಸರ್?
ಖಾಲಿ ಮಾಡಿ ಅಂತ ನಾವಿಲ್ಲ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಲೋನ್ ರೈಸ್ಡ್ ಬೈ ಮೈ ಫಾದರ್ ಮನಿ.
ಆಲ್ ರೈಟ್. ಎಸ್, ನೆಕ್ಸ್ಟ್.
109.
There are litigations, my lord, before revenue court.
Hmm.
And B report was submitted. 2018 was.
ಯಾರು ನೀವು?
The respondents.
ನೀವೇ ಅಪೇರ್ ಆಗ್ತೀರಾ, ಎಂಗೇಜ್ ಮಾಡ್ತೀರಾ?
Lawyer ಇರ್ತೀವಿ sir.
ಎಸ್.
Forgery ಮಾಡ್ಬಿಟ್ಟು ನಮ್ಮ ತಂದೆ
ಯಾವ ಫೋರ್ಜರಿ? 2013 ಇರೋದು 2018 ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರೆ
ಅವ್ರು ಹಾಕಿದ್ದಾರೆ ಸರ್. Forgery ಮಾಡಿ
ನೋಡ್ ನೀವು ಎಂಗೇಜ್ ಎನಿವನ್. ಎಸ್, ಯಾವತ್ ಬೇಕು?
ನೋಡಿ ಒಂದು ಡೇಟ್ ನೋಡಿ.
ಡೇಟ್ ಕೊಡ್ತೀನಿ.
1 month.
1 month. All right. Yes. The respondent has appeared in person. Respondent case Nandish has appeared in person. Seeks 4 weeks time to engage the service of a counsel. The issue in the list is rejection of the B report and cognizance being taken by the learned magistrate for the offenses punishable under so and so. The incident is of the year 2013. The allegation is that the document has been forged. The document is alleged to have been forged is that of the father of the complainant. Father is no more. Father of the complainant. In that light, till the respondent would file his statement of objections, further proceedings will remain stayed. If yavat objection ಆಗ್ತೀರಾ ಅವತ್ತು.
110.
Split 8th in the fresh matters list. In the meantime,
7. 212. 11. 112.
covered.
Confessions.
Confession covered.
Covered by Babu.
Covered by confession.
confession statement. Petitioner is accused number 2.
Just look into it, Harish. Please list on 13th in the fresh matters list.
Meantime,
HCGP is directed to accept notice for the respondent. List on 13th in the fresh matters list. Close them now. Yes, next.
Then 13. I'm appealing to the petitioner, my lord. My lord, every day petitioner used to walk with a dog, my lord, in the same way without you nearby. Only
Why
there is
did
a
you say attack, attack?
attack anta hele illa, my lord. This is
He was answering his nature's call. Why did you let the dog go there?
My lord, I used to go with a dog.
Why
every
did
day
you
in the
leave the
same-
dog to him, madam? And you are saying,
No,
is this
but
the place
nothing
to,
has happened
is
to
this
him,
the
my lord.
place?
Nothing has happened to him, my
Oh.
lord. He just hospital ಹೋಗಿ ಬಂದಿದ್ದೀನಿ ಅಂತ ಅವರೇ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ.
Nothing doing.
ಅವ್ರಿಗೆ ಏನು ಆಗಿಲ್ಲ.
You can't hold the dog and threaten a man who is.
Not with a dog, my lord. I just asked why you are using public road. You can use nearby only there is a public toilet. I just said you can go to public toilet.
ಅಷ್ಟ್
You use
ಹೇಳಿದ್ರೆ
one
ಸಾಕು.
dashboard. You
ಅದೆಲ್ಲ
use dashboard,
ಅಷ್ಟ್ ಹೇಳಿದ್ರೆ
my lord.
ಪರವಾಗಿಲ್ಲ. ನಾಯಿ ಯಾಕೆ ಬಿಟ್ರಿ?
Used one dashboard, my lord. The petitioner also used the same word to him. So he came to beat the petitioner, my lord. That
So ಅವಾಗ ನಾಯಿ ಬಿಟ್ಟು.
dog ಬಿಟ್ಟಿಲ್ಲ, my lord. That the dog nature is to protect the owner, my lord.
Dog nature is to protect you.
ಅವ್ರು
Every dog nature is.
ಅವ್ರು ಹೊಡಿಯಕ್ ಬಂದಾಗ
ಅದು ನೀವು ಅಟ್ಯಾಕ್ ಅಂತ ಹೇಳಿದ ತಕ್ಷಣ ಅದ್ ಏನ್ ಮಾಡಿದೆ ಅಂತ ಹೇಳ.
ಆತ ಕಲ್ಸ ಇಲ್ಲ ಡಾಗ್
ಏನ್ ಮಾಡಿದೆ ಅಂತ ಹೇಳ.
ಇಲ್ಲ ಅವರು ಹೊಡಿಯಕ್ ಬಂದಾಗ ಏನ್ ಮಾಡ್ತೋ ಅವ್ರಿಗೆ ಪರ್ಚಕ್ ಹೋಯ್ತು, ಬಟ್ ಹಿ ಕಂಟ್ರೋಲ್ ಹಿಮ್ಸೆಲ್ಫ್, ಮೈ ಲಾರ್ಡ್.
No, I can't say
ಆಮೇಲೆ
complaint ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದಾರೆ ಅಂತ I can't tell here.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಅದೇ ಇದೆ, ಅವ್ರು ಹಾಸ್ಪಿಟಲ್ ಹೋಗಿ ಬಂದಿದ್ದಾರೆ, ಏನು
ಅದಕ್ಕೆಲ್ಲ.
ಆಗಿಲ್ಲ ಅವರಿಗೆ.
ಏ.
ನಾವು ಅಟ್ಯಾಕ್ ಮಾಡಕ್ ಹೇಳೇ ಇಲ್ಲ, ಮೈ ಲಾರ್ಡ್. ಅದು ಡಾಗ್ ನೇಚರ್. ಅವ್ರು ಹೊಡಿಯಕ್ ಬಂದಾಗ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡಿದೆ ಅಷ್ಟೇ ಓನರ್ಗೆ.
You should have at least seen his
holding
position
the
and
dog,
kept
my
quiet.
lord. When he is holding the dog, he has to have the control over the dog. Otherwise,
ಹಿಮ್ಸೆಲ್ಫ್ ಕೇಮ್ ಅವಾಗ ಅಪಾಲಜಿನೂ ಕೇಳಿದ್ರು, ಬಟ್ ವಿತ್ ದ ಇನ್ಫ್ಲೂಯೆನ್ಸ್, ಮೈ ಲಾರ್ಡ್, ಅಂಡ್ ಹಿ ಇಸ್ ದ ಒನ್ ಮೇಡ್ ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ಡ್. ಇವ್ರು ತುಂಬಾ ಹೆಂಗಿದ್ದಾರೆ, ಮತ್ತೆ ಅವ್ರ ಮದ್ವೆನೂ ಫಿಕ್ಸ್ ಆಗಿದೆ. ಮೀನ್ ವೈಲ್
ಯಾರಿಗ್ ಮದುವೆ ಫಿಕ್ಸ್ ಆಗಿದೆ?
ಪಿಟಿಷನರ್ಗೆ, ಮೈ ಲಾರ್ಡ್. ಅದ್ರ ಜೊತೆಗೆ ಇವರು ಡೈಲಿ ಪೊಲೀಸ್ ಅವ್ರು ಹೋಗ್ಬಿಟ್ಟು ನಿಮ್ ಸ್ವಂತ ಮನೇನ ಏನ್ ಬಾಡಿಗೆ ಬರುತ್ತೆ, ಏನ್ ಕೆಲಸ ಮಾಡ್ತೀರಾ ಅಂತ
ನಿಮ್ಗೆ
ಡೈಲಿ
ಯಾಕ್ರಿ
ಎಂಕ್ವೈರಿ
ಅದೆಲ್ಲ?
ಆಗ್ತಿದೆ.
Dog owner ಗೆ ನಿಮ್ಗೆ ಏನ್ problem? But why did you say attack?
ಅಟ್ಯಾಕ್ ಅಂತ ವರ್ಡ್ ಯೂಸೇ ಮಾಡಿಲ್ಲ. ಆ ನಾಯಿಗೆ ಅದ್ ಗೊತ್ತೂ ಇಲ್ಲ, ಮೈ ಲಾರ್ಡ್.
English ಗೊತ್ತಿಲ್ಲ.
ಸಾಫ್ಟ್ ಅಟ್ಯಾಕ್ ಅಂದ್ರೆ ಏನು ಅಂತಾನೆ ನಾಯಿಗೆ
ಅಯ್ಯೋ
ಗೊತ್ತಿಲ್ಲ.
ಕಲ್ಸೇ ಇಲ್ವಾ ಅಟ್ಯಾಕ್ ಅಂದ್ರೆ ನೀವ್ ಹಂಗೆಲ್ಲ?
ಇಲ್ಲ, ಮೈ ಲಾರ್ಡ್.
ಯಾವ breed?
ಇಲ್ಲ.
ಯಾವ ಬ್ರೀಡ್?
ರಾಟ್ ವೀಲರ್, ಮೈ ಲಾರ್ಡ್.
ಅಯ್ಯೋ ರಾಟ್ ವೀಲರ್ ನೀವು ಅಟ್ಯಾಕ್ ಅಂದ್ರೆ ಅದು
ಅವರು ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡಿ
it has the notoriety.
ಅವ್ರಿಗೂ ಈ ಯಾಕೆ ಪಬ್ಲಿಕ್ ಟಾಯ್ಲೆಟ್ ಯೂಸ್ ಮಾಡಲ್ಲ ಅಂತ ಒಂದ್ ವರ್ಡ್ಗೆನೆ ಯೂಸ್ ಸಮ್ ಸಚ್ ಅ ಬ್ಯಾಡ್ ವರ್ಡ್, ಮೈ ಲಾರ್ಡ್. ಅದಕ್ಕೆ ಪಿಟಿಷನರ್ ಕೋಪ ಬಂದು
Dog understood that word.
ಡಾಗ್ ಅಲ್ಲ, ಮೈ ಲಾರ್ಡ್. ಅದಕ್ಕೆ ಅದೇ ವರ್ಡ್ ನ ಪಿಟಿಷನರ್ ಯೂಸ್ ಮಾಡಿದ್ರು. ದಟ್ ಡ್ಯಾಶ್ ವರ್ಡ್ ಯೂಸ್ಡ್ ರಿಟರ್ನ್ ಬ್ಯಾಕ್ ಬೈ ದಿ ಪಿಟಿಷನರ್. ಅವಾಗ ಕಂಪ್ಲೇಂಟ್ ಗೆ ತುಂಬಾ ಕೋಪ ಬಂದು ಹೊಡಿಯಕ್ ಬಂದ್ರು. ಅವಾಗ ಹೋಲ್ಡ್ ಮಾಡಿದ್ರಲ್ಲ, ಅದು ಜಸ್ಟ್ ಅಟ್ಯಾಕ್ ಮಾಡಕ್ ಹೋಯ್ತು, ಬಟ್ ಈ ಕಂಟ್ರೋಲ್ ದಿ ಡಾಗ್, ಮೈ ಲಾರ್ಡ್. ಏನೂ ಆಗಿಲ್ಲ ಅವ್ರಿಗೆ. ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಅವ್ರು ಅದನ್ನೇ ಹೇಳ್ತಾರೆ, ಹಾಸ್ಪಿಟಲ್ಗೆ ಹೋಗಿ ಬಂದು ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಿದೀನಿ ಅಂತ. ಏನೇನೂ ಆಗಿಲ್ಲ, ಮೈ ಲಾರ್ಡ್. himself controlled it.
charge sheet is also ready.
Just abusing the process of law, my lord.
ನಿಮ್ದು
ಏನೂ
abuse
ಆಗಿಲ್ಲ. ಅದೇ just ನಾನು ವಾಕಿಂಗ್ ಹೋಗ್ತೆ ಡೈಲಿ ನಾನು
ನಿಮ್
ಅದೇ
ಪಾಡಿಗೆ ನೀವು ವಾಕ್ ಹೋಗ್ಬೇಕಾಗಿತ್ತು. Why did you want to disturb him?
ಅಲ್ಲ ಪಬ್ಲಿಕ್ ಅಲ್ಲಿ ಮಾಡಬೇಡಿ ಅಂತ ಒಂದ್ ವರ್ಡ್ ಹೇಳಿದಷ್ಟೇ.
ಹ್ಮ್.
ಅದಕ್ಕೆ ಅವರು ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್. ವಾಟ್ ಕಂಪ್ಲೇಂಟ್ ಇಸ್ ಡನ್ ಇಸ್ ರಾಂಗ್, ಮೈ ಲಾರ್ಡ್. ಯೂಸಿಂಗ್ ಪಬ್ಲಿಕ್ ಟಾಯ್ಲೆಟ್ ಪಕ್ಕದಲ್ಲೇ ಇತ್ತು, ಅದನ್ನ ಬಿಟ್ಬಿಟ್ಟು ರೋಡ್ ಅಲ್ಲಿ
ನೀವು ಹೇಳಿ ಮೇಡಮ್, ಪರವಾಗಿಲ್ಲ, ನಾಯಿ ಬಿಡೋ ಅವಶ್ಯಕತೆ ಇರ್ಲಿಲ್ಲ.
ನಾಯಿ ಬಿಟ್ಟಿಲ್ಲ, ಮೈ ಲಾರ್ಡ್.
ರಾಟ್ ವೀಲರ್ ಬಿಟ್ರೆ ನೀವು ಏನ್ ಅದು ಇನ್ ದಟ್ ಪೊಸಿಷನ್
ಏನಕ್ಕೆ ಹಿಂಗ್ ಪಬ್ಲಿಕ್ ಅಲ್ಲಿ ಮಾಡ್ತಿದ್ದೀರಾ ಅಂತ ಹೇಳಿದಕ್ಕೆ ನೀನ್ ಯಾರು ಕೇಳಕ್ಕೆ ಅಂತ
ಅದು ಹಂಗೆ ಡೆವಲಪ್ ಆಗುತ್ತೆ ಬಿಡಿ.
ಡ್ಯಾಶ್ ವರ್ಡ್ ಯೂಸ್ ಮಾಡಿದ್ರು. ಅದಕ್ಕೆ ಇವರು ಪಿಟಿಷನರ್ ಅದೇ ವರ್ಡ್ ನ ಯೂಸ್ ಮಾಡಿದ್ರು ಅಷ್ಟೇ, ಮೈ ಲಾರ್ಡ್. ಆಗಿದ್ದು ಅದು ಈಗೋ ಹರ್ಟ್ ಆಗಿ ಅವರು ಈ ತರ ಮಾಡಿದ್ದಾರೆ. ನಾಯಿಯಿಂದ ಅವ್ರಿಗೆ ಏನೂ ಆಗಿಲ್ಲ.
ನಾಯಿ ಕಚ್ಚಿದೆ?
ಇಲ್ಲ, ಕಚ್ಚಿಲ್ಲ, ಮೈ ಲಾರ್ಡ್. ಏನೂ ಮಾಡಿಲ್ಲ.
ಓದ್ಲಾ ಮೇಡಮ್, ಏನ್ ಮಾಡಿದೆ ನಾಯಿ?
ಮೆಡಿಕಲ್ ರಿಪೋರ್ಟ್ಸ್ ಮೇ ಬಿ ಕಾಲ್ ಫ್ರಮ್
ತೊಂದ್ರೆ ಇಲ್ಲ.
ಏನೂ ಆಗಿಲ್ಲ, ಅವ್ರಿಗೆ ಏನೂ ಆಗಿಲ್ಲ, ಮೈ ಲಾರ್ಡ್. ಕಂಪ್ಲೇಂಟ್ ಏನೂ ಆಗಿಲ್ಲ. ಜಸ್ಟ್
imagine the position of the man that he was standing and you let the Rottweiler.
ಅಲ್ಲ, ಅವರಿಗೆ ಏನಾಗಿದೆ, ಈಗೋ ಹರ್ಟ್ ಆಗಿದೆ, ಅದಕ್ಕೆ ಕಂಪ್ಲೇಂಟ್
Ego hurt ಆಗಿಲ್ಲ.
ವರ್ಡ್, ಮೈ ಲಾರ್ಡ್. ಡಾಗ್ ಇಂದ ಅವ್ರ ಮೆಡಿಕಲ್
ಬರೀ ಈಗೋ ಹರ್ಟ್ ಆಗಿದೆ, ಬೇರೆ
ಏನೂ ಆಗಿಲ್ಲ ಅವರಿಗೆ.
ಎಸ್, ನಥಿಂಗ್ ಡೂಯಿಂಗ್.
ಮೈ ಲಾರ್ಡ್, ಅವ್ರಿಗೆ ಏನೂ ಆಗಿಲ್ಲ.
ಬರ್ಲಿ, ಲೆಟ್ ದ ಕಂಪ್ಲೇನೆಂಟ್ ಕಮ್. ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲ, we will get the complainant.
Records is there.
One HCGP, 2 emergent notice returnable by the 5th of December. You should have hold on your dog.
I have holded, my lord. Nothing is happened to complainant, my lord. And my lord, meanwhile, they're not to go his house.
ಅವರೇನೋ
my
ಮದುವೆ
lord,
ಆಗ್ತಿದಾರಂತೆ, ನಿಮ್ಗೆ ಯಾಕೆ ಪ್ರಾಬ್ಲಮ್?
Inquiring every day ಹೋಗೋದು ಕೇಳೋದು ಎಲ್ಲಾ ಮಾಡ್ತಿದ್ದಾರೆ my lord.
ಮಾಯಿ ಅಲ್ಲೇ ಇದೆಯಾ?
ಮತ್ತೆ ನೀವ್ ಎಲ್ಲೂ
ಈಗ
ಹೋಗಿಲ್ಲ
ಒಂದ್ ನಿಮಿಷ.
ಅಲ್ಲಲ್ಲ, ಈಗೇನು ಹೋಗ್ತಾರೆ,
minute,
ಚಾರ್ಜ್ ಶೀಟ್ ರೆಡಿ ಆಗಿದೆ ಸ್ವಾಮಿ.
1 minute.
ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ, ಅವ್ರು ಫಸ್ಟ್ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ,
ಆಗಿದೆ ಈಗ.
ನಿಮ್ಮೇನ್ ಬರಲ್ಲ ಅವರು, ಆಯ್ತಾ? ಆಮೇಲೆ ನಾಯಿ ಇದೆಯಲ್ಲ ನಿಮ್ಮ ಹತ್ರ,
ಅಲ್ಲ ಅದಕ್ಕೆಲ್ಲ
ಇಲ್ವಾ ಈಗ ನಾಯಿ?
ಕಲ್ಸಿಲ್ಲ.
ನಾಯಿ ಇಲ್ವಾ ಈಗ?
ನಾಯಿ ಇದೆ.
ಮತ್ತೆ ಅವ್ರು ಬಂದಾಗ ನಾಯಿ ನೋಡ್ಕೊಳ್ಬಿಡಿ. Where both of you are fighting to come? Why?
14?
ಇಬ್ರದು ಒಂದೇ ಕೇಸ? ಇಬ್ರದು ಕೇಸ್ ಅಲ್ಲ. ಓಯ್ 1:30 ಆಗೋಯ್ತು, ಅದಕ್ಕೆ ಬಂದಿದ್ದ.
List 2, my lord. Serial ಅಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಲಿಸ್ಟ್ ಆಗಿದೆ. Another connected matter is listed on 6th, my lords. Both the matters may be taken on 6th. Serial number 12.
ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ.
Last list.
Serial number 131 and
Wait,
134, my lords.
2:30. You said you are not well. Why did you come?
My lords, because
Ma'am.
I am seeking stay of no, my lords, I am
Yes,
not
2:30.
keeping.
Madam, Which page is document of the commercial OS? You have produced. You have produced, but where is it? ಇದೆ ಎಲ್ಲ ಇದೆ. ಇನ್ವಾಯ್ಸ್ ಅಲ್ಲ, ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ, ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ, ಎಲ್ಲ ಇದೆ. ಎಲ್ಲ ಇದೆ. ಎಲ್ಲಿದೆ? ಯಾವ ಪೇಜಲ್ಲಿದೆ? ಅಲ್ಲ. ಎಲ್ಲಿದೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ? You should carry complete file and come. ಬರೀ you should not carry the plaint and the memorandum of the petition and come. ಎಲ್ಲ ಇದೆಯಾ? Yes. Heard the learned counsel. What's your name? Who is Abhishek? Heard the learned counsel so and so representing Abhishek NV. The petitioner, you have instituted or who has instituted? The petitioner institutes a proceeding for recovery of money against the complainant in Commercial OS 474 of 2021. The 2021. On 15/12/2022, after filing of the written statement in the Commercial OS, the complainant seeks to register a crime. The dispute between the two is for recovery of money for supply of stationery. Therefore, there shall be an interim order of stay of further proceedings, qua the petitioner till the next date of hearing, on the score that the criminal law is set into motion as a counterblast to what the petitioner has filed in to the suit that the petitioner has filed in Commercial OS 474 of 2021. Yes.
280.
7A, 27th. The counsel Baby Patil is directed to accept notice for the respondents, petitioner to serve set of papers upon the aforesaid counsel, list the matter on 27th. All other matters on that day.
119.
Heard the learned counsel, no case, sir. Heard the learned counsel appearing for the petitioners. The petitioners are accused 3 to 5, the petitioners, 1 minute, sir. The petitioners are accused 3 to 5 who are drawn into the web of proceedings at the time of conduct of trial. A perusal at the reason so rendered by the prosecution to bring the petitioners into the web of crime as accused 3 to 5 would not stand the scrutiny of the law laid down by the apex court and plethora of judgments with regard to the purport of section 319 of the CRPC. The apex court in 2024 SEC online SC page 730, Shankar versus State of Uttar Pradesh, holds that there should be evidence more than what was found during the investigation to draw other persons into the web of proceedings under section 319 of the CRPC. A perusal, as observed herein above, a perusal at the application would not indicate any such instance, as there is no evidence against these petitioners to be tried after bringing them in under section 319 of the CRPC. Therefore, there shall be an interim order of stay of the order dated 28/6/2024 till the next date of hearing. ಅಷ್ಟೇ ತಾನೆ? Yes. No ground for stay. You serve, I will give a date. ಹೇಳಿ. Page 33, para 1. They would say that they in the year 2020 July, I sought hand loan. But it is very vague. July 2020, I sought for 15 lakhs. They issue another notice. Page 36, para 2. My clients represent to be stayed in the month of June 2018. Your client have approached seeking an hand loan of ₹18. Idella, is it not a matter of evidence? It is not a legally enforceable debt. Have repaid the entire amount, paid 45, 3 lakhs, have paid to the complainant and the daughter. Well, see, you serve on the respondent. The petitioner to serve on the counsel who represents the respondent before the concerned court in CC 20632 of 2023. The learned counsel for the petitioner projects that the debt that is projected before the concerned court is not a legally enforceable debt and would seek to place reliance upon several judgments of the apex court pending consideration of the apex court. In that light, there shall be an interim order of stay of further proceedings quay the petitioner till the next date of hearing, 6th December in the fresh matters list. Next.
221.
ಎರಡು OS ನಂಬರ್ ಯಾವುದು? ಫಾಸ್ಟ್ ಹಾ ಮೇಡಮ್ ಬರ್ಕೊಂಬಿಡಿ. 55 ಆಮೇಲೆ ಎಲ್ಲ ನೋಡಿ ಇಟ್ಕೊಬೇಕು. ಹಾ ನಂಬರ್ ಇನ್ನೊಂದು ಹೇಳಿ ಕೋರ್ಟ್ ಕೇಳದ್ನ. The petitioners are before this, the petitioner is before this court. Petitioners are before this court calling in question registration of a crime in crime number 345 of 2024 registered for the following offences. The offenses punishable under section 406, 420 and 465 of the earlier regime, the IPC. On the same cause of action, the complainant has the complainant has instituted suit in OS 56 of 2024 and has also sought to set the criminal law into motion. Therefore, there shall be an interim order of stay of further proceedings till the appearance of the complainant. 1 HCGP, 2 emergent notice returnable by 10th December.
Two 22.
One HCGP, 2 emergent notice in the main returnable by the 11th of December. In the meantime, in the meantime. Yes, next.
223.
ಕೊಟ್ಟಾಯ್ತು ಸರ್. ಅಲೋ ಮಾಡ್ಬೇಕಾ? ಕೊಟ್ಟಾಯ್ತು. ಎಸ್. FSL ಏನು? FSL ಏನಿದೆ? It is proved that it is fake in the FSL. Produce. ತೊಂದ್ರೆ ನಿಮ್ಗೆ ಯಾವತ್ತು ಬೇಕು? ಆಯ್ತು. ಫ್ರೈಡೆ 8th ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ಯಾಕೆ ಅವತ್ತು ಒಳ್ಳೆ ದಿನ ಮತ್ತೆ ನೀ ಇರುವುದಿಲ್ವಾ? ಹಾಗಾದ್ರೆ ಮಂಡೇ ಹಾಕುವ. ಆಯ್ತು, ತರ್ಸ್ಡೇನೆ ಹಾಕಿ. ನೀವು ಇರೋದಿಲ್ಲ ಅಂದ್ರೆ ತರ್ಸ್ಡೇ ಹಾಕಿ. ಕೇಸಲ್ಲಿ ಏನಿಲ್ಲ. FSL ನಿಮ್ ಅಗೇನ್ಸ್ಟ್ ಇದೆ. ಪರವಾಗಿಲ್ಲ, ನೋಡೋಣ. We'll see. Yes. Get the investigation papers. Yes. Next.
24.
ಭಾರಿ ಕರೇಜಿಯಸ್ ಸರ್. 13 ವರ್ಷದ ಹುಡುಗಿದು ನೀವು ಹಾಕ್ತಾ ಇದ್ದೀರಾ ಕೇಸ್ ಅಂದ್ರೆ ವೆರಿ ಕರೇಜಿಯಸ್ ಪೆಟಿಷನ್. ವಾಟ್ ಮೆಡಿಕಲ್ ರಿಪೋರ್ಟ್ ಸರ್? ವಾಟ್ ಇಸ್ ಯುವರ್ ಏಜ್? ನಿಮ್ಮ ಏಜ್ ಎಷ್ಟು ಸರ್? 48. ಹುಡುಗಿ ಏಜ್, ಗರ್ಲ್ ಚೈಲ್ಡ್ ಏಜ್ ಎಷ್ಟು ಸರ್? ಏಜ್ ಎಷ್ಟು ಸರ್? 13 years. You are 48. Alleged of offense under POCSO. And you have filed a petition for quashing. And the girl is disabled. Yes. Mm. Hmm. 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 You seriously want an order on merits? You seriously want an order on merits? Hmm. Alright. If you want an order on merits, I will grant. Not necessary, sir. In POCSO, it is not necessary for penetration to be present. Anything else? Anything else? You want an order on merits, I am ordering, definitely. No problem. Heinous offense, 48-year-old man indulging in sexual assault on a 13-year-old child, and you have filed a petition for quashing. They're all a matter of evidence, sir. And you talk of penetration. What is this? No. If you have touched the child also, it's enough. In Muttailwa. Sir, medical report has to be tested in evidence. I cannot in 482 say straight away medical report is particularly in cases of POCSO and rape. Sir, and yeah. Is mentally disabled. A mentally retarded girl child. You have indulged in sexual assault. Are you a man? What is this? And you have filed for quashing. We'll pass an order. Come on, merits. Normal child also is an offense heinous. No, mentally retarded, sir. What are you trying to do? Such people should not be spared. Hele. Come on, merits. In 164 statement, 161 statement. What did you do with the child keeping her for 1 week? Tell me. For 1 week, you kept the child with you. What did you do? Sir, even if it is after 100 days, I would have said it is correct. Look at the heinous offense that you have indulged in and say 10 days complaint, 10 days delay. What? ಮನುಷ್ಯತ್ವ ಅನ್ನೋದಿಲ್ವಾ ಯಾವ mentally retarded child indulge in all these things? No, sir. ಅದಕ್ಕೆ ಹೇಳಿದ್ದು very courageous that you filed a quashing petition. Sir, what statement she will give? She is mentally retarded. ಏನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ತಗೊಂತಾ ಇದ್ದೀರಾ ಅವ್ರದ್ದು? You are talking of the statement of the girl who is mentally retarded. Mother has given a complaint. 75% mental disability. Sir, 75% mental disability. Then that is true. Then what is all this? Unpardonable. And ನೀವು ಒಂದು ಶಾರ್ಟಿ ಟ್ರಯಲ್ ನಡೆಸ್ಬಿಟ್ಟು ಬಿಟ್ಬಿಡ್ಬೇಡಿ. ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಮಾಡೋದೇ ಹಿಂಗೆ. ಎಸ್ ಜಗದೀಶ್, you should look at the offense, look at the child. ನೋಡಿ ಫೋಟೋಗ್ರಾಫ್ಸ್ ಇದೆ ನೋಡಿ child. 75% mental disability. He has kept her for 1 week. 1 week ಅಲ್ಲ ಏನದು ಮತ್ತೆ 2 ಗಂಟೆಗೆ ಮನೆಗೆ ನನ್ನ ಸೋಂಡ್ಸು ನಂತರ ಶರ್ಟ್ ಓದಕ್ಕಾಗಲ್ಲ, ಅಷ್ಟು ಅಸಹ್ಯವಾಗಿದೆ ಕಂಪ್ಲೇಂಟ್. ಯಾವ ಡಿಸ್ಪ್ಯೂಟ್? See the complaint. Complaint nodi, yes, it's so horrendous. Page 47, ಹೇಳಿಕೆ ನೋಡಿ. She belongs to scheduled caste but they have, this man is complaint is at page 15. Yes, sir, ಹೇಳಿ sir. ಮತ್ತೆ ಅಲ್ಲಿಗೆ ಹೋಗಿ. Not necessary, sir. Not necessary at all. ನಿಮಗೆ you are relying on the bail order. Bail is granted because it is complaint is registered after 10 days. ಅದಕ್ಕೆ bail ಕೊಟ್ಟಿದ್ದಾರೆ. Both. ಹಿಂಗೆ ಮಾಡೋದು. These people will walk away. We don't conduct a proper trial. He is won over the mother. Because they are abject poverty. ಇವರು ದುಡ್ಡು ಕೊಟ್ಟರೆ they will say.
Lordship, have it next week, my lord. I'll secure the records and see
It is not correct.
what can be done. We'll examine what can.
Such people, how can you? ಸುಮ್ನೆ ಯಾರು ಹೇಳ್ತಾರೆ to a mentally retarded child, this man is indulged in all these things.
That my complaint.
Mother has complained. Complaint is after 10 days. He has won over the mother later.
I'll get the records, my lord, the evidence. Your lordship, have it next week. We'll see what can be done.
No, let me see the evidence.
Needed can be ordered for re-examination.
That is why. No, such cases you should take it seriously. What? And bail you have not opposed at all. ನೋಡ್ದೇನೆ ಆರ್ಡರ್ ನೋಡಿದ್ದೀನಿ ಜಸ್ಟ್ ವಿಶ್ವೇಶ್ವರದಲ್ವಾ ಬೇಲ್ ಆರ್ಡರ್ ಅಲ್ಲ ಅದಾಯ್ತು. ನೋಡಿ ಏನಂತದ್ದೇನೂ ಆಗಿಲ್ಲ. Get all the records. The offense is so horrendous that you can't even read the complaint or contents. And he says nothing has happened.
We'll get the records.
Get the entire records. We'll see next week. I'll take it on next Tuesday. That is 12th. List on 12th in the fresh matters list.
$225.
KP Act 7980.
Yes, my lord.
Permission
obtained, my lord.
अंदर बार
Page number
अंदर बार
31.
statement on the ಕೊಡಿ. ಹಾ. Same covered. Madam, ಅದು beginning ಅಲ್ಲಿ ಹಂಗೆ ಮಾಡಿ. The petitioner is before this court calling in question so and so ಅಂತ ಹಾಕ್ಬಿಟ್ಟು ಆಮೇಲೆ both the learned counsel appearing for the petitioner and respondent in unison with content. Same copy paste ಮಾಡಿ. Close. Next.
26.
Krishnamurthy sir, I want to see the investigation papers. Friday ತಗೊಂತೀನಿ. It's all right. Correct. The learned HCGP to secure the investigation papers on the next date of hearing, list on 8th in the fresh matters list.
27.
NDPS.
My lord, I'm appearing for the applicant in this matter. I'm hitting upon two very important facts, my lord. The charge sheet has been submitted under section 20B, subclause 2, capital B. Whereas, my lord, the recovered quantity has been alleged as less than small quantity. So that is one important thing. And another important factor is, my lord, that the learned court below has also taken cognizance on the same sections.
Let's
So-
see, we'll direct notice and hear him and then pass orders.
Please.
Learned HCGP, what's your name, sir?
My lord, I'm Shivam Yadav, advocate, appearing.
Learned, heard the learned counsel Shivam Yadav appearing for the petitioner. The learned counsel would project two glaring lacunae in the case at hand and would seek quashment of the proceedings or interdiction as the case would be. The learned HCGP is directed to accept notice, go through the papers and make his submissions. List on 8th in the fresh matters list.
But there's an IA also, my lord.
The IA on that day, sir. Yes.
I'm deeply obliged, my lord, deeply
Yes.
obliged.
Next.
28.
Health officer. You are the health officer. The petitioner is before this court calling in question proceedings in CC 30 of 2024 registered for offences punishable under one ನಿಮಿಷ madam ಹೇಳ್ತೀನಿ.
465.
460, page
470.
32 alide madam. So and so. Learned counsel submits that the allegation against the petitioner which would touch upon the discharge of his official duty as health officer of the BBMP, health officer of the Mangalore City Corporation, for which sanction under section 197 of the CRPC was imperative to be obtained. Admittedly, there is no sanction at the time of taking of cognizance against the petitioner. In the light of him being a public servant and the admitted fact that no sanction is accorded for prosecution, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing. Next.
29.
The petitioner is the husband. The allegation against him is the offences punishable under section 498A, 504 and 506 of the IPC. A perusal at the complaint, which has now become a crime in crime number 70 of 2024, would not in the remotest sense touch upon the ingredients of 498A. All that is alleged against the husband is the minor skirmishes between the husband and the wife that would happen day to day. Finding no ingredient of section 498A against the husband, the further investigation shall remain stayed, failing which it would run foul of the judgment of the apex court in the case of Achin Gupta versus so-and-so 2024 SSC online SC page 759. Therefore, there shall be an interim order of stay. So post the matter for admission in its usual course. 1 HCGP, 2 emergent notice. They are the other members. Tag the petition along with so. Next.
130.
ಯಾಕೆ ವಾಯ್ಸ್ ಊಟ ಮಾಡಲಿಲ್ಲ? ಕೇಸ್ ಇಲ್ವಾ? ಮೈಕ್ ಆನ್ ಆಗಿಲ್ವಾ?
Petitioner running a Xerox shop, my lord.
ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರಿ? Fake voters list.
No,
color
my lord.
Xerox.
No, my lord. Kindly pay the page number 140. Police verified shop, my lord. No aggrieved party has given any complaint.
No problems. Second respondent, election squad has found it. Anything else, sir?
No, my lord.
ನಿಮ್ಮಿಂದಾನೆ ಹೇಳಾಗಿರೋದು. Fake voter ID ಮಾಡಿ.
No, my lord.
ಮತ್ತೆ ಅದೇ ಅಲಿಗೇಷನ್. ಎಸ್. ಹೌದಾ ಇಲ್ವಾ?
ಹೌದು.
ಮತ್ತೆ ಯು ಆರ್ ದಿ ಕ್ರಿಯೇಟರ್ ಆಫ್ ಆಲ್ ಪ್ರಾಬ್ಲಮ್ಸ್. ಅಂದ್ರೆ ನೀವಂದ್ರೆ ಪೆಟಿಷನರ್.
ಓನ್ಲಿ ಜೆರಾಕ್ಸ್ ಮಾಡಿ ಕೊಟ್ಟಿರೋದು ಅಷ್ಟೇ.
ಬರೀ ಜೆರಾಕ್ಸ್ ಮಾಡಿದ್ರೆ
ಕಲರ್ ಜೆರಾಕ್ಸ್
ಇದಲ್ಲ, ಫೋಟೋ ಕಾಪಿ
ಅಲ್ಲ, ಕಲರ್ ಜೆರಾಕ್ಸ್ ಇದೆ. ಕಲರ್ ಜೆರಾಕ್ಸ್ ಅಂಡ್ ಲ್ಯಾಮಿನೇಷನ್. ಐ ಆಮ್ ರನ್ನಿಂಗ್ ಎ ಬಿಸ್ನೆಸ್ ಇನ್ more than 30 years, my lord.
Correct.
That shop, my lord.
Fake voter IDs in color are generated. That's the allegation. I know the allegation.
ಕಲರ್ ಪ್ರಿಂಟ್ ಮಾಡಿ ಲ್ಯಾಮಿನೇಟ್ ಮಾಡಿ ಅನಧಿಕೃತ ಮತದಾರರ ಗುರುತಿನ ಚೀಟಿಗಳನ್ನು ಭಾರತ ಚುನಾವಣಾ ಆಯೋಗದ PVC ಮೂಲ ಎಪಿಕ್ ಕಾರ್ಡ್ ಮಾದರಿಯ ವಿರುದ್ಧವಾಗಿ ಮುದ್ರಿಸಿ ಸರ್ಕಾರಕ್ಕೆ ಮೋಸ ಮಾಡಿರುತ್ತಾನೆ.
ಆಯ್ತಾ?
That is all not belongs to me, my lord.
Anything else? Discharge ಹಾಕೊಳ್ಳಿ. I am not inclined to issue notice here.
Liberty may continue.
Liberty, yes. Madam, discharge on format ಇದೆ. Yes. Discharge format ಅದು. ಏನ್ doubt ಇದ್ರೆ chamber. Yes. Next.
231.
2015, what are you doing after 9 years, sir?
Let's,
I will direct expeditious conclusion of the trial.
no, my lords. This is a matter, my lords, where petitioner is the accused number 5. The only allegation against him is he made an application before the assistant register. That site has to be allotted in his favor. Now the suit, my lords, is compromised. The property is, my lords, sold. My lords may kindly see page 103. Suit itself is compromised. Then there's a sale deed executed by the complainant in favor of the third party.
Get the complainant.
Complainant, my lords, is not there.
Why?
Complainant and the GPA holder of the complainant both have passed away, my lords. They have sold the property. The sale deed, my lords, is also, my lords, there at annexure
Yes,
C,
sir,
page
one,
109.
Sarwan Latif. Please, counsel B Latif is directed, Latif. Counsel B Latif is directed to accept notice for the respondent. Petitioner to serve set of papers upon the aforesaid counsel. List on 12th in the fresh matters list. But please. Yes.
232.
Accused
Same,
number
same, accused different, same. Adu copy ಕೊಟ್ಬಿಡಿ ಅವ್ರು. Please.
33.
Plus 33, it's I appear for the petitioner.
7A,
7A,
27th. Counsel
Plus-
B.B. Patil is directed to accept notice for the respondent. Petitioner to serve set of papers upon the aforesaid counsel. List the matter on 27th.
plus in the meantime, my emergent notice for R2 minutes.
Emergent notice, madam, ಅದು B.B. Patil 1, no? 2 emergent notice returnable by 27th, list on 27th.
Please.
Yes, next.
234.
The petitioner is before this court calling in question so and so. The registration of the crime happens pursuant to the filing of a private complaint invoking section 200 of the CRPC. A perusal at the private complaint would clearly indicate that it is not in compliance with what the apex court has directed in Priyanka Srivatsava or Babu Venkatesh, reported in 2022 SSC Online SC page 200. In that light, there shall be an interim order of stay till the appearance of the complainant. 1 HCGP, 2 emergent notice returnable by 6th December. Next.
235.
petitioner.
Then it's jaldi ಬಂದ್ಬಿಟ್ಟಿದ್ದೀರಾ? 24/10/24 complaint.
2410.
ಇನ್ನು
My lords, I've misplaced my
just
file.
before Diwali,
If it could be,
or after Diwali.
could be relisted in the next week. I've misplaced my
Relisted,
file. I'll file.
Yes, and then ಈಗಲೇ ಏನ್ ಮಾಡಿ, let's get the investigation papers. List the matter on 5th December in the fresh matters list.
It could be next Monday.
No, sir. Good that you have lost your file. Search it by then. By then investigation baro.
Until then.
No,
In this case, my lord, through ABS corpus, my lord, he has secured the.
no question of stay in this. Yes.
Please.
236.
Again, what's the problem?
My lord,
ಇವೇನ್ ಬಿಡದೇ ಇಲ್ವಾ? ಅಲ್ಲಿ ಕನ್ಕ್ಲೂಡ್ ಆಗಕ್ ಬಿಡದೇ ಇಲ್ಲ ನೀವು ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇಲ್ಲಿ there are two
ಇದು
cases are pending, my lord.
Creative infotech.
Creative.
Very creative, both of you are.
No, my lord.
ಒಂದಲ್ಲ ಒಂದು ಪೆಟಿಷನ್ ಇದ್ದೇ ಇದ್ದೀರಾ ಇಲ್ಲಿ. ಈಗೇನು ಪ್ರಾಬ್ಲಮ್?
ಏನಿಲ್ಲ ಸ್ವಾಮಿ. There are two criminal cases pending before the trial court. With respect to 60105 of 2018, we had preferred a petition before this honorable court for CRT claims, which was been partly allowed by the trial court. Simultaneously, another case was also been taken up before the trial court. That's 50852 of 2019, my lord, which is with respect to the same transaction. And the cross was being taken as nil before the trial court, my lord. Hence, we preferred a petition before this honorable court. And
ನಾನೇ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡೋದು.
ಹೌದು ಸ್ವಾಮಿ.
Yes, sir.
So ಅದರಲ್ಲಿ the order which has been passed by this honorable court was on the same date which was been passed with respect to 6011052, my lord. So in the order, my lord, it was been observed that at annexure E, my lord, which was been numbered as criminal petition number
50339
Hmm.
as
Hmm.
at para number 3, my lord.
Hmm.
These very parties were before this court in criminal petition number 1031 of 2024 disposed on
Page
28/6/2024.
102. Page 102.
Page 102, my
Hmm.
lord. For the reasons rendered in the said petition, the subject petition also deserved to be disposed.
Hmm.
Only with a direction to the concerned court to conclude the proceedings within 6 months from the date of receipt of the copy of
ಆಯ್ತು.
this order.
ಆಮೇಲೆ
This petition was being filed seeking the relief of recall of the order dated
ಎಸ್ ಏನಿದೆ?
and the cross was taken as nil, my lord.
Was that not challenged earlier?
That was being challenged before this honorable court.
ಮತ್ತೆ ಇದು ಕ್ಲೋಸ್ ಮಾಡಿರೋದು ಯಾಕೆ? ರಿಸರ್ವ್ ಆಗೈತೆ ಇಲ್ಲಲ್ಲ?
ಇಲ್ಲ, ಸ್ವಾಮಿ.
Then ನಿಮ್
So
ಪ್ರೆಸೆನ್ಸ್ ಅಲ್ಲೇ ಆಗಿರೋ
we challenged the same before this honorable court, my lord, but the order
Sir,
which been passed in 1031 is being considered.
1031 is here.
Yes,
1031 I have passed the order.
Yes, my lord.
ಆಯ್ತಾ?
For the reasons stated,
Correct.
reasons
What is
rendered in the
wrong?
said petition.
What is wrong with this?
1031 ಇದು ಒಂದೇ ಅಂತ ಹೇಳ್ಕೊಂಡು the court has, this honorable court has passed.
Yes, ma'am. Cross examination my learning when he's speaking.
Sir, 1031 ಗೂ ಇದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ವಾ?
ಸಂಬಂಧ ಇದೆ. Both are connected.
ಅದು
There are two
ಗೊತ್ತು sir.
cases.
He is saying independent ಆಗಿ
relief is
ಹೇಳಿದ್ರು.
different.
They're connected. Both are, there are two cases.
ಕನೆಕ್ಟ್ ಆಗಿದ್ ಗೊತ್ತು. ಆ ರೀಸನ್ಸ್ಗೂ ಇದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ವಾ ಅಂತ ಕೇಳ್ತಾ ಇರೋದು.
ಅಲ್ಲ, ಅದನ್ನು both the
Relief
both the
sought in
cases
both the
have,
petitions are different, my lord.
both the cases have been clubbed and orders have been passed.
I know, sir, but this case challenge something else, is it?
But as on the date, there are the petitioner has not filed an application for recall of witness. But the trial
When
court,
did he file it?
but the trial court has closed the stage.
When did he file it?
He filed on
After the disposal of the petition?
2020.
ಯಾವತ್ತು ಹಾಕಿದ್ರಿ?
Subsequent to order.
After disposal.
So why are you pointing at the order then? If subsequent to this, you have filed an application.
Please,
For what purpose?
For recall of the order.
Which order? ನಿಲ್ ಅಂತ ತಗೊಂಡಿದ್ದ order.
ಹೌದು.
ಅದು ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರಾ?
This court has rejected that. This honorable court has rejected, by lord. In criminal petition number.
No, if he has
539.
challenged that order that has shown that the cross examination will be treated as nil, then
Nil.
this reason is wrong.
Yes, earlier order. And subsequently, after passing the order by this honorable court, they have filed a fresh application during 2024
Honorable
under
court has
311 of CRPC to recall the witness.
What has happened?
That application came to be dismissed.
Where is that? You have challenged that?
Yes, my lord. This in this
ಇದರಲ್ಲಿ
petition I
challenge
am
ಮಾಡಿರೋದು
challenged,
ಅದೇನಾ?
my lord, but the reason is the order which has been passed in 5339 was under the impression that the same relief is being sought in 1031 as well as in 5339, my lord.
If there is an error in considering that, then we may have to permit 311 application.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಏನಾಯ್ತು?
Recently, what has happened, one second. 21/10/22. Examination chief was conducted. 22.
ಆಯ್ತು ಹೇಳಿ.
Yeah, I mean, now he is coming forward with the application.
ಎಷ್ಟನೇ ಅಪ್ಲಿಕೇಶನ್ ಇದು?
First time, my lord.
First
The first time.
ನೀವು ಈ
taken as
ಕಡೆ
nil, my
ಇದ್ರೆ
lord.
ಕೊಡ್ತಾ ಇರ್ಲಿಲ್ವಾ?
ಮುಂಚೆ they have never pressed for the cross examination
ಕೆಲ್ಸ
in
ಮಾಡಿ.
this case.
ನೀವು ಈ ಕಡೆ ಇದ್ರೆ ಕೊಡ್ತಾ ಇರ್ಲಿಲ್ವಾ? I'll fix a date for further examination. On that day, he will conclude. I will direct conclusion of the trial within 3 months.
ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ
ಇಲ್ಲರೆ ಸುಮ್ಮನೆ ಇಲ್ಲಿ ಸ್ಟೇ ಕೊಟ್ರೆ ಇನ್ನು 6 ತಿಂಗಳಿರುತ್ತೆ.
ಕೇಸಲ್ಲಿ 35 pages.
Cross examination. Last 5 years.
Cross examination is already over, my lord. Now the
ಈಗ
defense evidence
311
is going
application ಯಾಕೆ ನೀವು ಹಾಕಿದ್ದು? Why did you file 311 application?
for recall of the order, my lord.
Recall of what orders?
Which wherein the cross has been taken as nil, my lord.
ಈ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಎಷ್ಟು ಮಾಡಿದ್ರಿ ನೀವು?
ಈಗ ಮುಗ್ದಿದೆ ಸ್ವಾಮಿ. ಇದ್ರಲ್ಲಿ ಮಾಡೇ ಇಲ್ಲ ಸ್ವಾಮಿ. Never we have done any cross examination in 50852, my lord.
ಯಾವ್ದ್ರಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿ?
601052, my lord, which is
ಅದಕ್ಕೂ
where
ಇದಕ್ಕೂ ಆ ಕೇಸ್ಗೂ ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ?
they are related to the same transactions, my lord.
Both are.
One is
Then
the principal amount.
If you have cross examined 35 pages in that, what is that you are left in
Only
this?
only half an hour we will conclude the cross examination.
For the satisfaction of the petitioner.
No, my lord, there are few questions are left, your honor. Only few questions are left. In one day, hearing date itself, we will conclude it.
ಅವತ್ತೇ ಕನ್ಕ್ಲೂಡ್ ಮಾಡಿ ಕ್ಲೋಸ್ ಮಾಡಕ್ ಹೇಳ್ತೀನಿ. ಇಲ್ಲದ್ರೆ ಸುಮ್ಮನೆ it will be languishing here. That's
A date
better.
may be fixed under that day.
I'll fix
And
the
that date
date.
has to be.
ಅವತ್ತು ಅದೇನ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ತಾರೆ ಅದನ್ನ ಕನ್ಕ್ಲೂಡ್ ಮಾಡಿ ಅದಾದ್ಮೇಲೆ 2 months ಅಲ್ಲಿ ಎಂಟೈರ್ ಟ್ರಯಲ್ ಮುಗಿಬೇಕು ಅಂತ
6 months ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಆಗ್ಲೇ?
ಕೊಟ್ಟಿದ್ದೀನಿ. ಹಂಗಾರೆ
ಕೊಟ್ಟಿದ್ದೀನಿ.
1 month ಅಲ್ಲಿ ಮುಗ್ಸಕ್ ಹೇಳಿ.
Please, ma'am.
ದಟ್ಸ್ ಬೆಟರ್. ಇಲ್ಲದ್ರೆ ಇಲ್ಲಿ ಇಟ್ಕೊಂಡ್ರೆ ಮತ್ತೆ ಏನೋ ಪ್ರಾಬ್ಲಮ್. ಏನಂತ? Sir, if it is repeatedly sought, it's a different thing. This is this first application is what he says. ಆಯ್ತು ಗೊತ್ತು ಒಂದೇ ಒಂದು ನಾನೇ ಮೊನ್ನೆ ಬರ್ದಿದ್ದೀನಿ ಬಟ್ ಒನ್ಸ್ ವಿ ವಿಲ್ ಸಿ ದಿ ಪೆಟಿಷನರ್
Respondent ವಕಾಲತ್ file, ಇವತ್ತು file.
learned counsel separate order sheet madam.
Madam.
Learned counsel MRC Manohar accepts enters appearance for the respondent. Registry to print the name of so and so is appearing for the respondent. Heard the learned counsel for the petitioner and the learned senior counsel MT Nanaya appearing along with MRC Manohar for the respondent. The petitioner is before this court calling in question an order dated 4/10/2024 passed by the concerned court by which an application under section 311 filed by the petitioner comes to be rejected. The order of rejection of the application is ostensibly on the score of an order passed by this court in criminal petition 5339 of 2024. While disposing the said petition, this court has ordered as follows, page 101, 102 matra.
102.
102. For the reasons indicated in criminal petition 1031 of 24, which was disposed on the same day, i.e. 28/6/24, this court disposed criminal petition 5339 of 24, directing the concerned court to conclude the proceedings within an outer limit of 6 months. The petitioner, after the disposal of the petition, files an application under section 311 seeking recall of the respondent for further cross-examination.
For cross-examination.
For cross-examination. The learned counsel for the petitioner would submit that the respondent was not completely cross-examined. Further, agilva. The respondent has not been cross-examined at all in CC 50852 of 2019, and therefore it cannot be a case where there is no cross-examination of the respondent. The learned senior counsel for the respondent would refute the submission in contending that in another proceeding arising out of the same cause of action, the respondent has been cross-examined at length which runs close to 40 pages. And would seek dismissal of the petition. Be those submissions as they are. Merely because the petitioner has cross-examined the respondent in another analogous criminal case, which is connected to the connected to CC 50852 of 2019, arising out of an identical transaction, would not mean that the petitioner would have no opportunity of cross-examining the respondent in CC 50852 of 2019. It cannot be a case where there is no cross-examination of the respondent at all. Therefore, I deem it appropriate to grant the petitioner one opportunity to cross-examine the respondent. The learned counsel for the petitioner submits there are only a few questions and the cross-examination would not last more than 30 minutes. The submission is placed on record. Therefore, the concerned court shall fix a date for such cross-examination of the respondent and the petitioner shall conclude the cross-examination on the same date. It is made clear no further opportunity of the kind that is now granted shall be sought by the petitioner at any cost. This court earlier had directed disposal of the petition within 6 months from the date of receipt of the copy of the order. I therefore deem it appropriate to reiterate the same and direct the concerned court to conclude the proceedings within an outer limit of 1 month from the date of completion of cross-examination of the respondent in CC 50852 of 2019. Ordered accordingly. For the aforesaid reasons, the following order. The ordered impugned order, nodi madam. Order dated so and so stands quashed. The matter stands remitted back to the hands of the concerned court to regulate its procedure in terms of the observations made in the course of this order. Ordered accord. ಆಯ್ತು ಒಂದ್ ತಿಂಗಳಲ್ಲಿ ಮುಗಿಸ್ತಾರೆ ಈಗ ನಾ ಸ್ಟೇ ಕೊಟ್ಟು 2 ತಿಂಗಳು ಬಿಟ್ಟು ಕರೆದ್ರೆ ಅದೇ ಆಗಲ್ಲ.
37.
Serial number 172, Lordship, state the
Ninja
investigation.
cart.
Please. And now.
ಇದು ನಿಂಜಾ ಕಾರ್ಟ್ ತಾನೆ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ವಾ?
May not survive.
ಯಾಕೆ ಬಿ ರಿಪೋರ್ಟ್
ಅಲ್ಲ, ರಿಲ್ಯಾಕ್ಸೇಷನ್ ಆಫ್ ಕಂಡೀಷನ್ ಹಾಕಿಲ್ಲ.
ಬೇಲ್ ಕಂಡೀಷನ್ ರಿಲ್ಯಾಕ್ಸ್
Please relax. They asked me to every 15 days, my lord, to mark the presence.
ಮಾಡಿ
But serial number 172, Lordship, state the
Stay ಮಾಡಿದ್ರಿ.
investigation.
ಸೇಮ್ ಪೆಟಿಷನರ್.
Same petition, sir, same crime.
But very interesting condition imposed. Sessions court does not impose the condition, magistrate has imposed the condition.
ನಿಂಜಾ ಕಾರ್ಟ್ ದಟ್ಸ್ ವಾಟ್.
The,
ಈಗೇನ್ ಎಂಟ್ರಿ ಮಾಡಿರ್ಬೇಕಾ?
please, my lord.
ಅಲ್ಲ, that will
Be
not survive.
connected.
ಯಾಕೆ ಸರ್ವೈವ್ ಆಗಲ್ಲ?
Stay
ಸ್ಟೇ ಕೊಟ್ಟಾಗಿದೆಯಲ್ಲ ಮತ್ತೆ ಯಾಕೆ ಸರ್ವೈವ್ ಆಗ?
It could be connected with it.
ಟ್ಯಾಗ್ ದಿಸ್ ಇಲ್ಲ ವಿಲ್ ಕ್ಲೋಸ್ ದಿಸ್.
Close.
Where the same petition, the petitioner is before this court seeking the following prayer. The petitioner seeks modification of the conditions imposed by the learned magistrate, which directs, magistrate directs the petitioner to mark his attendance before the jurisdictional police 15 days once. The condition was not imposed by the sessions court while granting bail, but the magistrate appears to have overstepped its jurisdiction in directing and imposing such a condition. This court, concerning the very petitioner, has granted an interim order of stay in criminal petition 10146 of 2024. In that light, in the light of the stay being granted, the petition is rendered infructuous. All the contentions that are advanced here are permitted to be advanced in criminal petition 10138 of 24. With the aforesaid observations, the petition stands disposed.
38.
Charge sheet has been filed.
My lord, charge is not filed, man. ಇಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಇಸ್ ಪರ್ಟೈನಿಂಗ್ ಟು ಮೈ ಕಂಪ್ಲೇಂಟ್ ಅಗೇನ್ಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 1 year ago.
ಫೈಲ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾ
ಇಲ್ಲ
ಇದ್ದಾರೆ.
ಇಲ್ಲ ಅದು ಚಾರ್ಜ್ ಶೀಟ್ ಇದರಲ್ಲಿ ಇರೋದು. ಐ ಹ್ಯಾಡ್ ಲಾಡ್ಜ್ ಕಂಪ್ಲೇಂಟ್ ಅಗೇನ್ಸ್ಟ್ R2, my lord. In that charge sheet was filed. After 1 year, just as a counter blast, my lord, he has filed another complaint.
After 1 year?
Yes, my lord, almost 1 year, my lord.
Almost.
Their brothers, my
Where?
lord. My brother, my own brother.
But page 25 ಅಲ್ಲಿ ಎಲ್ಲ ingredients ಇದೆ.
25, your lordship may kindly see.
ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Charge sheet ಇದರಲ್ಲಿ ಯಾವಾಗ?
Filed.
ಇದೀಗ ತಾನೇ ಆಗಿದೆ.
Maybe I have no.
ಈಗ ಚಾಲೆಂಜ್
My submission, my lord.
Charge sheet challenge
Ingredients
ಮಾಡ.
of 109, my lord.
ಎಲ್ಲ ಇದೆ ಇಲ್ಲಿ.
109 is, your lordship may kindly see page number 15, my lord. 15.
ಅಲ್ಲ 307 ಇದೆ.
ಹೌದು. ಈ ingredients of 307 is not at all found, my lord.
ಆಯ್ತು ನೀವೇ ಹೇಳಿ ಬನ್ನಿ. ಪೇಜ್ 26 ಬನ್ನಿ ಸರ್. 25 ಬನ್ನಿ. 26 is typed copy.
25, my lord.
ಕೈಗಳಿಂದ ಮೈ ಕೈಗೆ ಹೊಡೆದು ನೋವುಂಟು ಮಾಡಿರುತ್ತಾರೆ ಅಲ್ಲದೆ ಎಲ್ಲರಿಗೂ ತಲೆ.
That is my charge sheet against R2, my lord.
ವಿಚ್ ಇಸ್ ಯುವರ್ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ವಾ ಇನ್ನು?
No, no charge
24 ಗೆ
sheet.
charge sheet ಆಗಿದೆ.
ಸರಿ ನಂಬರ್ ಕೊಡಿ. CC
TC number is awaited, my lord. Charge sheet is filed.
ಚಾಲೆಂಜ್ ಮಾಡ್ಬಿಡಿ.
Yes, ma'am. Yes.
239.
ಲಿಬರ್ಟ್ ಅದೊಂದು ಫಾರ್ಮ್ಯಾಟ್. ಲಿಬರ್ಟಿ ಟು ಚಾಲೆಂಜ್ ಚಾರ್ಜ್ ಶೀಟ್ ಫಾರ್ಮ್ಯಾಟ್.
Petitioners.
Who is the purchaser in this?
Lord, the
A1 A4?
Lord, A1 and A6, my lord.
A1 A6?
A6, both, my lord. Petitioners, both are purchased.
Both are purchasers.
Please, my lord. One property, my lord, they purchased in the sense, my lord, the petitioner, number 1, my lord, has purchased the property.
ಏನ್
Then he
ಬ್ರದರ್ಸ್ ನೀವು?
Please, my lord.
Huh?
Lord, then he gifted to the petition number 2, who is a wife, my lord.
Sir, first accused number 1 is Veerabhadre Gowda TH.
TH, please. He is the
Complainant is Veerabhadre Gowda TV.
T.
TV no TH ಏನಿದು?
And now TH,
ನೀವು TH.
please. He
What is the problem?
ಕಂಪ್ಲೇನೆಂಟ್ ತಾಯಿ ಹೆಸರಿರೋ ಜಂಟಿ ಖಾತ್ರಿ ಇರೋದನ್ನ ಜಮೀನ ಸೇಲ್ ಮಾಡಿ.
Family problem?
They say it's a impersonation, my lord. The
Correct, no doubt about it.
who has done it, my lord, is the accused number.
That is the matter of evidence.
Please, my lord, the offenses, my lord, all person who has done it, will not on.
Yes, get the records. List on 15th in the fresh matters list. Petitioner to secure the investigation papers by the next date. Next.
40.
7A, list on 27th.
It's not just 7A, my lord.
7A, 7B, 12.
12.
ಎಲ್ಲ ಒಂದೇ. List on 27th, Learned Counsel B. Latif is directed to accept notice for the respondent Lokayukta petitioner to serve set of papers upon the aforesaid counsel.
Lords, the charge sheet has not been filed yet, my lords. And
Charge sheet
also-
file madilva.
Charge sheet file.
In the event charge sheet is not filed as on today, the same shall not be filed without the leave of the court. Yes. List on 27. Copy kudi.
241.
ಏನ್ ಮೂರ್ ಕೇಸ್ ಮೂರ ನಾಲ್ಕು
Commercial suits are
241,
pending.
242, 244, 245.
Complaint is not against petition number 2 in the initial stage. Then.
ನಾಲ್ಕ್ ಪಿಟಿಷನ್ ಹೆಂಗ್ ಮೂವ್ ಮಾಡಿದ್ರಿ ನೀವು?
Please not.
4 ಪಿಟಿಷನ್ ಒಬ್ಬರದೇ ಹೆಂಗ್?
So filing ಮಾಡಿ
ಅಲ್ಲ ಫೈಲ್ ಮಾಡಿ ಆಯ್ತು ಎಲ್ಲ CH ಮೂಡಿದ್ 4 ಮೆಮೊ ಹೆಂಗ್ ಕೊಟ್ರು?
ಬೇರೆ petitioners ಅಲ್ಲಿ
ಪರವಾಗಿಲ್ಲ ಆದ್ರೂ 4 ಒಂದೇ ಹೆಂಗ್ ಸಾಧ್ಯ? ಎಷ್ಟೋ ಜನ ಬಂದೇ ಇಲ್ಲ ಮ್ಯಾಟರ್ ಅಂತ
ಅಕ್ಟೋಬರ್ 1ರಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ವಿ. ಅಕ್ಟೋಬರ್ 1ರಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ವಿ.
4 ಪಿಟಿಷನ್ ಒಂದ್ರಲ್ಲಿ ಸ್ಟೇ ಆಗಿದ್ರೆ ಎಲ್ಲಾದ್ರೂ ಆಗ್ತಾ ಇತ್ತು. ಎಸ್ ಈಗ ಒಂದ್ರಲ್ಲಿ ಸ್ಟೇ ಕೊಡ್ತೀನಿ, 3 ಅಡ್ಜನ್ ಮಾಡ್ತೀನಿ.
Lord, the first respondent not filed a complaint initially against the second petitioner before the jurisdictional police, alleging that during the year 2017-18, some documents have been manipulated so as to show that the first respondent has taken the premises as well as service of the petition number 1 in the first petition for the benefit of the first respondent. The complainant entered the first respondent as a director only in the year 2022. Then the publication police issued an endorsement by considering the documents that the suits are pending, commercial suits are pending based on the documents. Therefore, it is a civil in nature. Then he filed a complaint before the commissioner against the second petition alone. Then commission transferred the petition to RMCR police station where the endorsement came to be issued. Then while fighting private complaint,
PC has referred to page 31 ಅಲ್ಲಿ
31 ಅಲ್ಲೇ ನಾನು
para 7
ಪ್ಯಾರಾ 7 ಅಲ್ಲೇ ಇದೆ.
purchase orders have been created without.
ಅಷ್ಟೇ ಇರುತ್ತೆ. ಪ್ಯಾರಾ 7 is the allegation against you.
that is of the year 2017-18. Commercial suits have been filed in the year 2022. They have been participating in the civil proceedings.
Let the complainant come.
Till then, let me kindly see
You serve on the counsel who represents them in the trial court, in the commercial OS or whatever. The petitioner, the learned additional SPP is directed to accept notice for the second respondent state. Madam, ಇದು 241, 242, 243 and 245. 4 ಅಲ್ಲ?
ಹೌದು.
So and so. The learned additional SPP is directed to accept notice for the second respondent in all these cases. The petitioner is at liberty to serve on the counsel who represents the respondent complainant in the commercial OS or any other proceeding and file an acknowledgement in the next 3 days. List the matter on 12th in the fresh matters list.
Yes.
Yes. All the 4, tag them all. Yes. Who is in possession, Sampath?
46.
Regarding the possession, but in the suit we filed is not a possession. Now, my lord, this there is a similar complaint, my lord. They also filed another FIR by
44.
the another landowners. My lord, they don't even mention the date and time when we have
244 in the meantime.
246.
OS number or writ petition number in?
OS number 855 of 24, my lord.
ಆಮೇಲೆ
And WP number 18945 of 24, my lord.
ಅದು OS instituted by you?
By me, petition.
The petitioner is before this court calling in question proceedings in so and so. Calling in question crime number 377 of 2024 registered for prayer, madam. The learned counsel with the petitioner would take this court through the documents appended to the petition to demonstrate that the petitioners have instituted OS in OS number
855 of 24, annexure F page 98, my lord.
855 of 24 against the complainant and have also sought police protection for as the interference by the complainant had become Aura Niva.
Now.
Police protection against the complainant. After these proceedings emerges the impugned complaint as a counterblast to what the petitioners have registered against the complainant. Therefore, there shall be an interim order of stay of further proceedings where the petitioners till the next date of hearing. One HCGP, additional SPP, two emergent notice, post the matter in the, in admission in usual course.
247.
Please, my lords.
Oh, sorry.
Please, my lords.
Ah.
Herein, there is no authorization to make an entry.
204 violation.
And take notice for 1 and 6, my lord.
Tagoli, there is no application of mind as is necessary for 204 order that is passed. Heard the learned senior counsel R.J. Kolle appearing for the petitioner. The learned additional SPP is directed to accept notice for respondents.
1 and 6.
1 and 6 emergent notice to the remaining respondents. A perusal at the order of issuance of summons under section 204 of the CRPC of the learned of the concerned court would run foul of plethora of judgments rendered by the apex court, as sufficient cause to issue process is what is required, and that is what is missing in the order of in the impugned order. Therefore, there shall be an interim order of stay till the next date of hearing. List the matter on 5th December.
Please, ma'am.
Yes, sir.
248.
240?
8 lords.
7 a.m. 27th.
There is no charge sheet is filed no so far.
Already filed and then madaka.
Not filed.
Not filed.
Not
Not filed andre. OKL madam. ಅವ್ರ ಹೆಸರೇನ್ ಮೇಡಮ್ ಅಲ್ಲಿ ಕೂತ್ಕೊಳ್ಳಿ. ಒಂದು ಈಗ 7A ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ನಲ್ಲ
Not the file.
240 ಸೇಮ್ ಆರ್ಡರ್. ಅದು ಲತೀಫ್ ಬಿಬಿ ಪಾಟೀಲ್ ಯಾರಿಗೋ ಕೊಟ್ಟಿದ್ದೀನಿ, ಅದೇ ಮಾಡಿ.
Second respondent, emergent notice.
Emergent notice to the second respondent. Yes, next.
49.
447, my lord, 504.
Tell me all the pending proceedings.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ
ಯಾವ್ದಿದೆ?
Your Honor, I am a contractor. I was putting up construction of the compound, my lord.
I have
for
it
the
next
direction
week,
of-
my lord. Next week.
Yeah.
E-report has been sent to DYSP. It has been with the pending with the DYSP, I have it next week.
Should I record that? Beda. List on 15th in the fresh matters. ಅಷ್ಟರಲ್ಲಿ ಹಾಕಿರ್ತಾರೆ.
250.
Offense is 504 and 506.
ಏನ್ ನೋ heinous offenses. ಬೇಡ ಬಿಡಿ, ನೀವು ಹೇಳ್ಕೊಡಿ. Heinous offense. 504, 506, no.
The present complaint is given only, my lords, because earlier the complainant has.
In the meantime, one additional SPP, two emergent notice in the meantime. 504, 506. Yes. ಪಾಸ್ವರ್ಡ್ ತಗೊಂಡ್ಬಿಡಿ ಮೇಡಮ್.
Passed over matter. 61.
ಲತೀಫ್ ದಾ ಕವರ್ಡಾ ಪೇಜ್ ಲತೀಫ್, ಅದು ನಾವೇ ಹೇಳ್ಬೇಕು ಇವ್ರಿಗೆ. ಪೇಜ್ 54, 54 and 61. ಮೇಡಮ್ ಎರಡನ್ನೂ ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡಿ ಕ್ಲೋಸ್ ಗೊತ್ತಾತಲ್ಲ.
One 31.
31.
131
The
and
petitioners are the family members of the accused number 1 and are alleged of the offences punishable 131, madam, and are alleged of the offence punishable under section 498A inter-alia. Finding no ingredients that would touch upon the offences, finding no offence that would touch upon the ingredients of the offence under section 498A, permitting further proceedings where these petitioners would run foul of the judgment of the apex court in the case of Kailas Ben so and so 2024 SSC online SC page 2621. Therefore, there shall be an interim order of stay where these petitioners till the next date of hearing. Next husband adralilla. That's only emergent notice.
134.
134, one additional SPP, 2 emergent notice returnable by the 12th of December.
In that petition,
Ah.
her specific allegation is he has He is demanding for dowry, my lords.
Correct.
He himself has taken a insurance in her name, my lords. He has taken care.
Oh,
There
ಅದೆಲ್ಲ
is no evidence, even in
ಏನ್
complaint
ಪರವಾಗಿಲ್ಲ.
also page 17, my
ಏನ್
lords.
ತೊಂದ್ರೆ ಇಲ್ಲ. He is the husband.
Forthcoming, my
He is the
lords.
husband.
My lords.
Yes.
Lords,
One
at
additional
least till
SPP to emergent notice. ಒಂದ್ರಲ್ಲಿ ಕೊಟ್ಟನಲ್ಲ ಮೇಡಮ್ ಈಗ. ಹಸ್ಬೆಂಡ್ ಬೇಡ. ಅದು ಇಲ್ದೇ ನಾನೇ ಕೊಡ್ತೀನಿ ಹಸ್ಬೆಂಡ್ ಕೂಡ. But there are allegations here. Yes.
emergent notice to respond.
ಅದು ಮಾಡಿ. 233 ಬಂದಿದೆಯಾ? ತಗೊಂಡ್ಬಿಡಿ.
30 more match.
ಎಷ್ಟಿದೆ?
Hariprasad MB, fresh matters.
In terms of memo ಹಾಕಿದಾರ? The petitioner has moved the matter seeking withdrawal of the petition. The submission is placed on record. The petition is disposed as withdrawn. Next.
Number 2, Sridhara K.
Petition. The offense section 498 AML.
ಈಗ ಮೂವ್ ಮಾಡಿದ್ದೆ 230ಗೆ?
Sir?
230ಗೆ ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ?
ಅದರಲ್ಲಿ 6th ಇದೆ ಮೊದಲು ಚಾರ್ಜ್ ಶೀಟ್ FIR ಇದು ಸ್ಟೇಜ್ ಅಲ್ಲಿ ವಿತ್ಡ್ರಾ
ಅದು
ಮಾಡ್ಬೋದು.
ಎಸ್. ಹಸ್ಬೆಂಡಾ?
ಹಸ್ಬೆಂಡ್ ಅಂಡ್ ಇನ್-ಲಾಸ್ ಮೇಲೆ.
ಹಸ್ಬೆಂಡ್ ಬೇಡ, ಇನ್ಲಾಸ್ ಕೊಡೋಣ.
Even the husband ಮೇಲೆ sir there is no allegation, entire allegation, general allegation.
General?
Yes, ma'am.
Where is the, come to
Complaint.
page 31.
Yes, ma'am. Column number 17.
ಡೈಮಂಡ್, ಚಿನ್ನ, ಬೆಳ್ಳಿ ಎಲ್ಲ ಏನೇನೋ ಕಾಟ
ಎಲ್ಲ
ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
2016 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅವ್ರ ತಂದೆ ಹೇಳ್ತಕ್ಕಂಥದ್ದು ನನ್ನ ಮಗಳು ಚೆನ್ನಾಗಿರ್ಲಿ ಅಂತ ಅವ್ರು ವರದಕ್ಷಿಣೆ ಮೀಟ್
ಓಹೋ.
ಮಾಡೋದಿಲ್ಲ. ನನ್ನ ಮಗ ಇದು 161 ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಮೇಲೆ. ಕೈಂಡ್ಲಿ ಪೇಜ್ ನಂಬರ್ 40 ಮೇಲೆ.
ಜಗದೀಶ್,
ಪೇಜ್ ನಂಬರ್ 40
ಟ್ಯಾಕ್ಸ್ ಶೀಟ್ ಹಾಕುವಂತ ಕೇಸೇ ಅಲ್ಲ
ಅದೇ.
ಅದು, ಎಲ್ಲರ ಮೇಲೂ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Yes.
ಇದು 2621 498 ಹಸ್ಬೆಂಡ್ಗೂ ಸೇರಿಸ್ಕೊಡ್ಬೇಕು. 2621 ಜೊತೆ 759 ಹೇಳಲೇಬೇಕಾಗಿದೆ.
First 3, move for withdrawal.
ಮೂಡ್ ಫಾರ್ ವಿಡ್ರಾವಲ್ or ಮೆಮೋ ಫಾರ್ ವಿಡ್ರಾವಲ್ ಹಾಕಿದ್ದಾರೆ. ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಿ ಮೆಮೋ ನೆಕ್ಸ್ಟ್ 4 ಅಷ್ಟೇ. ರಾಹುಲ್ ರೆಡ್ಡಿ
4, move for withdrawal.
5 also same.
Number
4 withdrawal.
Rahul Reddy.
Memo for withdrawal for Rahul Reddy.
Withdrawal. Memo.
You are Rahul Reddy?
I'm for all.
For Rahul. Yes, memo for withdrawal in terms of memo.
Number 5, Jayalakshmama KB, move for.
Mood for withdrawal. ಯಾರು ಜಯಲಕ್ಷ್ಮಮ್ಮ?
For withdrawal.
Withdrawal. Memo ಇದೆಯಾ? Mood for withdrawal. Yes.
Bill number 6.
Yes, Veerbhadra sir.
Veerabhadraya.
Counter complaint and counter complaint is there. As well, the first complaint is concerned, the case was registered. My complaint is.
Which is first? ಎಲ್ಲ 2008 ದಿನನೇ ಹೇಳಿದಿರಾ?
2000 in the have filed the suit for the performance that came to be decreed.
One ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ ಜಗದೀಶ್ ಸರ್? ಯಾವುದು? ಜಗದೀಶ್ ಅವರೇ, ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ ಯಾವ್ದ್ರದ್ದು? 230 ಮೂವ್ ಮಾಡೋದಲ್ಲ, ಕಾಪಿ ಕೊಡೋದು.
ಅಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ, ಮೊದಲು ಕೊಟ್ಟಿದ್ದೀನಿ.
ಇದು ಅರ್ಲಿಯರ್ ಮ್ಯಾಟರ್, ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಕ್ ವಿಡ್ರಾ ಮಾಡಿ. ಇನ್ ದ ಮೇನ್ ಟೈಮ್ ಬೇಸಿಕ್ ನಾರಾಯಣ್ ಸ್ವಾಮಿ ಇದು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ? ಈಗ ಕೊಡ್ತಾ ಇದ್ದೀರಾ? ಎಂಟ್ರಿ ಮಾಡೋ ನಾಳೆ ಕೊಡ್ತೀನಿ.
ನೈನ್ತ್ಗೆ PCR ಇದ್ರಲ್ಲಿ ಸ್ಟೇ ಆಗುತ್ತೆ ಸರ್.
ಆಮೇಲೆ ರೆಫರ್ ಆಗಿದೆ
ಇಲ್ಲಿ ಸ್ಟೇ ಆಗಿದ್ದನ್ನ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದ್ಮೇಲೆ 29th FIR ಮಾಡಿ.
ಅಲ್ಲ, FIR after reference.
They receives the copy from the court on 29th.
Communicated, my lord, that they will not invest.
ನೀವು ಸುಮ್ನೆ ಬ್ಯಾಂಕ್ ಇದು?
ಇದು ಬ್ಯಾಂಕ್ ಇದಲ್ಲ ಸರ್. The first petitioner is the general manager of the bank. ಅವ್ರ ಪರ್ಸನಲ್ ಇದಕ್ಕೆ ಅಂತ ಹೇಳಿ ಸೈಟ್
ಪರವಾಗಿಲ್ಲ. ಈಗ ಇಲ್ಲಿ ಕಮ್ಯುನಿಕೇಟ್ ಆಗೋದ್ರೊಳಗೆ FIR ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ. Because magistrate has referred it, I have stayed it. They have no choice but to register the FIR.
You have communicated not to any further investigation.
This ಎಲ್ಲಿ ಸ್ಟೇ ಕೊಟ್ಟಿರೋದು? ಆರ್ಡರ್ ಅಲ್ಲಿ ಸ್ಟೇ ಕೊಟ್ಟಿರೋದು ಪೇಜ್ ಯಾವುದು?
ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದು ಪೇಜ್ ನಂಬರ್ 76 ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. 76 ಪೇಜ್ ನಂಬರ್ 76.
1 minute. This court on 28/10/2024 grants an interim order of stay of further proceedings in PCR 6/26 of 2024. It transpires that by then the private complaint was referred for investigation under section 156(3) of the CRPC. The resultant action is registration of a crime in crime number 369 of 2024. On the next day, i.e. 29/10/2024, the second petition is preferred on the score that the FIR is registered, notwithstanding the stay granted. There appears to be a communication gap as the interim order and the registration of FIR have happened in quick succession. Therefore, further investigation in 369 of 2024 shall remain stay. ಮತ್ತೆ ಇನ್ನೊಂದು ಹಾಕೊಂಡ್ಬರ್ಬೇಡಿ. Yes.
Number 8, Gauravan.
ಯಾರಿಲ್ವಾ? ಗೌರವ್. ಹೂ ಮಾಡಿದ್ದೆ ಯಾಕೆ ಮತ್ತೆ? No representation. List on Monday in the fresh matters list. Next. Saran.
Petition may be permitted to withdraw this petition.
Withdraw withdraw ಮಾಡಕ್ ಮೂವ್ ಮಾಡಿದ್ರ ಅಷ್ಟು ಗಲಾಟೆ ಮಾಡಿ ಬೆಳಿಗ್ಗೆ.
ಅಲ್ಲ ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ನಾಳೆಗೆ ತಗೊಂಡ್ರಿ. This matters.
Number 9,
ಇನ್ಮೇಲೆ ತಗೊಳ್ಳೋದೇ ಇಲ್ಲ 2:30ಗೆ. Yes. Learned counsel for the petitioner seeks leave of this court to withdraw the petition. Petition is disposed as withdrawn in terms of the statement made by the petitioner. Next. Kiran.
10, Kiran, yes.
The case of causing voluntary hurt and unlawful assembly mischief and criminal intimidation and breach of public.
2:30ಗೆ ಮೂವ್ ಮಾಡಿದ್ದು ಯಾಕೆ ಸರ್?
Only thing is, my lord, they have issued a notice to appear before them for the investigation. My lord.
Appear.
Copy of the notice.
Appear.
The only thing is, my lord, they are, it is my private car. He has trespassed into my car and tried to rob my proceedings.
Sir, You are sitting in the driver's seat.
No, my lord.
Then
Driver seat ಅಲ್ಲಿ ಇಲ್ಲ,
ಎಲ್ಲಿದ್ರಿ ನೀವು?
ಹೊರಗಡೆ ಇದ್ದೆ.
ಹೊರಗಡೆ ಇದ್ರಾ?
One of my person was counting the money in the car.
Oh.
He straight away came into my car and sitting and.
If you count money in the car, somebody will come in like this only.
I am a tea shop runner, my lord. I collect the proceeds of the tea shop in the morning, and I was collecting the change and
change.
Something coins and.
ಅದನ್ನು ಬಿಟ್ಟಿಲ್ವಾ?
Suddenly he came and he asked me to get out of the car, my lord. My friend.
Your friend. ಆಮೇಲೆ.
ಅದಾದ್ಮೇಲೆ my lord, nearby my tea shop servant and nearby neighbors came to the car and he convinced that so and so trespasser. He claims to be a software engineer.
ನಿಮ್ಮ friend, your friend.
No, my lord, that the complainant, sorry.
Who is he?
Respondent number 2.
Who is he?
He is a nearby apartment resident. My lord.
What is the problem of him with you?
My lord, the only thing is my car was parked in front of his house.
ಅವ್ರಿಗೂ ನಿಮ್ಗೂ ಏನು animosity?
ಕ್ಯಾಬ್ ಅಂತ ಹೇಳಿ ಅಂಡರ್ ದ ಮಿಸ್ಕನ್ಸೆಪ್ಷನ್ ಕ್ಯಾಬ್ ಅಂತ ನಮ್ ಕಾರಲ್ಲಿ ಬಂದು ಕೂತ್ರಂತೆ.
ಸರಿ, ನೀವು ತಳ್ಳಿದ್ರ ಆಮೇಲೆ ಆಚೆ?
Suddenly I got astonished that I was counting the money and I thought he was a rob. He was trying to rob me. That is the issue, my lord. In order to protect my car and my money, I have retaliated him. That's it, my lord. There was no intention for anything.
The respondent is the complainant.
Follow up ಮಾಡ್ತಾರೆ.
ಏನ್ ಸುಯೋಗ್? ಅವ್ರಿಗೆ ಯಾವ್ದು ಎಂಟ್ರಿ ಮಾಡ್ರಿಲ್ಲ ಅವ್ರಿಗೆ?
4 ದಿವಸ ಅಂತ ಕೊಟ್ಟಿದ್ರಿ ಅದು.
ಹಾ?
4 ದಿವಸ ಅಂತ ಕೊಟ್ಟಿದ್ರಿ, 4 ವಾರ ಆಗ್ಬೇಕಾಗಿತ್ತು. ಹಿಂಗ್ ಸ್ಪೋಕನ್.
4 ವಾರ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ತೀನಿ. Talking on the phone.
My apologies, my lord.
Yes. The respondent is the complainant. Appears to have booked a cab and was frantically waiting for the cab. The petitioner was sitting in his car, counting money. He is said to be a tea seller who is counting the proceeds of the day. The second respondent, thinking that it is the cab that he has booked, enters into the car. The petitioner, out of the apprehension that he has come to steal his money, pushes the respondent out of the car. The result is the impugned crime. and the section for crime in 505 of 2024 for offences punishable under so and so. Again, wrongful restraint, assault, ಆಮೇಲೆ
mischief and criminal intimidation. and breach of
mischief,
public-
criminal intimidation, so and so. A perusal at the complaint would indicate that the petitioner the allegation in the complaint is that the petitioner was in a drunken state and has abused and hit the complainant. A large cut has happened in ಎಲ್ಲಿ ಏನ್ ಅಷ್ಟೊಂದು ಹೊಡೆದ್ರ ಅವ್ರಿಗೆ?
Incident
No,
happened in the morning.
nothing has been happened.
9 AM. Incident is 9 AM.
9 AM.
ಬೆಳಿಗ್ಗೆ
ಯಾರು ಇರಲ್ವಾ ಅಲ್ಲಿ?
Fire says 9 to
main
10.
road ಮೇಲೆ.
ಹಾ ನೋಡೋಣ ಬರ್ಲಿ. ನಿಮ್ ಟೀ ದುಡ್ಡೆಲ್ಲ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ, ಕಾಂಪನ್ಸೇಟ್ ಮಾಡಿ.
ಅಲ್ಲಿ ಏನೋ ತಳ್ಳಾಟ ಆಗಿದೆ.
ಗಿಫ್ಟ್ ಹ್ಯಾಂಪರ್ ಕೊಡಿ, 365 days free tea.
Some ತಳ್ಳಾಟ ಆಗಿರ್ಬೋದು ಅಷ್ಟೇ ಸ್ವಾಮಿ. We are not caused anything
Yes,
to him.
will you get the complainant? 1 year free tea.
I find the RC book ಮೇಲೆ. It is a white board vehicle ಮೇಲೆ.
ಅದು ಗೊತ್ತಾಯ್ತು ಸರಿ.
ಸಾಫ್ಟ್ವೇರ್ ಇಂಜಿನಿಯರ್ ವೈಟ್ ಬೋರ್ಡ್ ಎಲ್ಲೋ ಬೋರ್ಡ್.
ಸರ್ ಅವರು ಫೋನ್ ಇಟ್ಕೊಂಡು ಬಂದಿರ್ತಾರೆ ಮಾತಾಡ್ಕೊಂಡು, ಅವ್ರು ಯಾವ ಕಾರ್ ಅಂತ ಗೊತ್ತಿಲ್ಲ, ಕಾರ್ ಇತ್ತು ಹತ್ತದ್ರು ಅಷ್ಟೇ. Yes. Therefore, there shall be an interim order of stay till the next date of hearing. 1 additional SPP, 2 emergent notice returnable by the 29th of November. ಅಲ್ಲಿ ಒಂದು ಅಪಾಲಜಿ ಎಲ್ಲ ಹೇಳಿದ್ರ ಅವ್ರಿಗೆ?
ಅವರು ನಮ್ಮನ್ನ ಕೇಳಿದ್ರು, ನಾವು ಅವ್ರನ್ನ ಕೇಳಿದ್ವಿ ಸ್ವಾಮಿ. He said he will come back with more men and
More men.
he will evict my tea shop.
ಅದಕ್ಕೆ ಎಲ್ಲಿದೆ ಟೀ ಶಾಪ್? ಅವ್ರ ಮನೆ ಎದುರುಗಡೆ
ಅವ್ರ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಅಪೋಸಿಟ್ ಅಲ್ಲಿ.
ಅಪೋಸಿಟ್. 365 days free. ಅದೇ ಪೆನಲ್ಟಿ. ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್ ವಿತ್ ದಟ್ ಗಿಫ್ಟ್ ಹ್ಯಾಂಪರ್ ಟು ಹಿಮ್. 1 ವರ್ಷ ಫ್ರೀ ಟೀ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ.
When for his family we will.
ಫ್ಯಾಮಿಲಿಗೂ ಕೊಡ್ತೀರಿ? ವೆರಿ ಗುಡ್, ನೋ ಪ್ರಾಬ್ಲಮ್. ಫ್ರೀ ಟೀ ಫಾರ್ ಹಿಮ್ ಅಂಡ್ ಹಿಸ್ ಫ್ಯಾಮಿಲಿ. ಎಸ್.
11.
ಅಲ್ಲ ಅದು ಬರಿಬೇಡಿ. ಆಮೇಲೆ ಇಂಟರ್ ಮಾಡಲ್. ಎಸ್.
11.
ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ಡ್, ಚಾರ್ಜ್ ಶೀಟ್ ಫಾರ್ಮ್ಯಾಟ್. ಎಸ್.
14
Settlement.
settlement 12 Vinod Kumar.
ವಿನೋದ್ ಕುಮಾರ್ ಅವರೆಲ್ಲ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಸಿಗ್ಲಿಲ್ಲ ಅಂತ ಹೋಗೇ ಬಿಟ್ರೆ. ನೆಕ್ಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಹೋಗಿ ಮೇಡಮ್.
Number 2.
Being spoken to list after 4 weeks.
My lords, my apologies, my lords.
List after 4 weeks.
My lords, interim order will kindly be extended, my lords.
Yes. ಏನ್ being spoken to ಯಾಕೆ?
ಅದು 4 days ಅಂತ ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ. Your lords was pleased to grant 4 weeks, my lords.
ಎಂಟ್ರಿ ಮಾಡ್ರೆ ನೋಡಿ ಎಷ್ಟಕ್ಕೆ ಅದರಲ್ಲಿ 4 days ಅಂತ ಆಗಿದೆ. ಎಂಟ್ರಿ ಮಾಡಿ 4 days ಯಾವತ್ತೂ ಕೊಟ್ಟಿಲ್ಲ, 4 weeks. ಎಸ್. ಜೇವಾಯ್ತು. There shall be an interim order of stay for the proceedings for 4 days ಅಂತಿದೆ. 4 weeks ಮಾಡಿ from today. Being spoken to out of inadvertence language ಗೊತ್ತಾಗ.
Grateful, my lords.
Yes, sir. Prakash.
Matters number 2.
The grounds in the earlier writ petition and the present writ petition are totally different, my lord. Permitted to pass on the writ petition and the order, my lord.
Yes.
Copy ಅದು.
230 ಇದಲ್ಲ, ಲಿಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಇದು.
They have not served a copy.
ಒಂದು ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬಿಡಿ. I'll take it.
Last time it's.
ಮಾಡಿದ್ದೀರಾ?
Oh, last time I made.
I'll take it day after tomorrow in the fresh matters list.
Marriage ಇದೆ, ಗುರುವಾರ ಆಗ್ಬೇಕು.
ಆಯ್ತು, ಗುರುವಾರ fresh matters list.
Great.
Number 3.
Oh, this is that day's matter where Manjula Tejaswi met.
Yes,
Yes,
yes.
It took time. ಇದು ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. Yes, sir.
Lord, FIR, first FIR was 27/1/2024. we got an order, my lord, of anticipatory bail on 27/1.
Ah.
Immediately second FIR is filed, my lord. Couldn't even, my lord, do anything.
Hmm.
Then, my lord, I got, on the same day, my lord, I got a regular bail also.
Ah.
Anticipatory bail, my lord, specifically directed me to, my lord, take a regular bail.
Hmm.
Then, my lord, I filed a suit.
Hmm.
Third FIR is filed. That was dismissed, my lord. We filed an appeal before the Honorable Supreme Court. And, my lord, the Supreme Court has stayed, my lord, both the
Supreme Court has stayed in which crime?
first two. my lord.
number
Last
28.
28, all right. Ah, yes,
Second
sir.
one. Second one.
Second crime.
And third FIR is stayed, my lord, next page only. Stayed by this Honorable Court.
That is 183 of
Correct,
2024.
Correct. Now, my lord, the bail is, anticipatory bail is cancelled.
Reason for cancellation?
My lord, on the ground that, my lord, I did not comply with those, my lord, requirements of the anticipatory bail. What happened was, I must tell your lordships,
Ah.
moment, my lord, anticipatory bail was granted, my lord, immediately, my lord, they filed the second FIR. I, my lord, could not even, my lord, go near the police station because I was required to go to the police station.
Hmm.
I filed, my lord, the requirement was that I must, my lord, give, my lord, take a regular bail. I took the regular bail. Regular bail does not have any condition. Then, my lord, second FIR is filed. Second FIR, my lord, that's when, my lord, I couldn't go. This is the main thing, my lord. Your lordsman can impose any condition, I'll, my lord, comply with them.
So
It's
where is the order granting bail?
My lord, please come to, my lord, running page. First two, please come to, my lord, page 45 of the petition.
Ah.
At page, my lord, 59.
Fifty-nine.
59. my lord.
Oh, ಕನ್ನಡದಲ್ಲ?
ಕನ್ನಡದಲ್ಲಿ
All right.
ಫಸ್ಟ್ ಸಾಕ್ಷಿಗಳನ್ನ ನಾಶ ಮಾಡಬಾರದು.
I had not to threaten the witness.
Correct. Second is, my lord, that I must immediately, my lord, get a regular bail.
ಆಯ್ತು.
Then passport, my lord, to be given.
All right.
And, my lord, ಪ್ರಕರಣವನ್ನು ದೋಷಾರೋಪಣ ಸಲ್ಲಿಸುವವರಿಗೆ ಆರೋಪಿಗಳು we had to, my lord, appear before the police.
All right. Now which condition is violated?
My lord, none of the conditions. All
Huh?
four. All the conditions.
All the conditions?
Four, my lord.
Ah.
ಭಾನುವಾರ
I'll
we
get
should
back to you. sir. ಒಂದು ನಿಮಿಷ.
do passport.
ಪ್ರತಿ ತಿಂಗಳ 1 ಮತ್ತು 4ನೇ ಭಾನುವಾರದಂದು ಎದುರುದಾರರ ಠಾಣಾಧಿಕಾರಿಗಳ ಮುಂದೆ
9
ಬೆಳಗ್ಗೆ 9ರಿಂದ ಸಂಜೆ 6 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಹಾಜರಾಗಿ ಹಾಜರಾತಿ ಹಾಕತಕ್ಕದ್ದು. ಸದರಿ ಅರ್ಜಿದಾರ ನ್ಯಾಯಾಲಯದ ಯಾವುದೇ ಷರತ್ತುಗಳನ್ನು ಉಲ್ಲಂಘಿಸಿ ಎಸ್.
Correct. I agree. But what happened was, anticipatory bail was granted. Immediately.
ಇದು ಬೇಲ್ ಆರ್ಡರ್ ರೆಗ್ಯುಲರ್ ಬೇಲ್ ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್?
Anticipatory bail. Regular bail, my lord, your lords may come to, my lord, page
No,
61.
this is anticipatory bail order.
Correct. Page 61, my lord, is the regular bail.
61 ಕಂಡೀಷನ್ಸ್ ಅದರಲ್ಲಿ
ಅದರಲ್ಲಿ ಏನಿಲ್ಲ.
ಏನಿಲ್ವಾ?
Please come to, my lord, page 63. Sureties are accepted.
Surety. Like some.
But what happened was,
ಏನು
my lord,
ಕಂಡೀಷನ್ ಇಲ್ಲ ಇದರಲ್ಲಿ?
ಇಲ್ಲ. What happened is, my lord, I must bring this to your lordship's notice. He couldn't, my lord, go to the police station because immediately, my lord, second FIR was filed. And, my lord, thereafter, my lord, third FIR. That's my, whatever condition, my lord, if your lordship, my lord, direct me to, my lord, appear before the police in every second week, my lord, I'll appear. No difficulty about it. Then,
Now where is the order cancelling bail?
my lord, please come to, my lord, Annexure A,
Page
33. ಕಾರಣಗಳು is 38 onwards. ಅದು ಕನ್ನಡದಲ್ಲೇ ಇದೆ.
ಗೊತ್ತಾಯ್ತು.
ಇಂಗ್ಲಿಷ್ ಆದ್ರೆ ಓದೋ ಸ್ವಲ್ಪ ಬೇಗ ಆಗತ್ತೆ.
ಇದು
ಕನ್ನಡದಲ್ಲಿ ಸ್ವಲ್ಪ
ಇರ್ಲಿ.
ಪ್ಲೀಸ್ ಕಮ್ ಟು my lord, page 42, serial number 21 ಅಷ್ಟೇ.
ಅಲ್ಲದೆ ಸದರಿ ಅರ್ಜಿ ಪುರಸ್ಕರಿಸಲು ಮತ್ತು ನ್ಯಾಯಾಲಯವು ಅರ್ಹತೆ ಆಧಾರದಲ್ಲಿ ಆರೋಪಿಯು ಸಲ್ಲಿಸಿರುವ ಈ ಅರ್ಜಿ ಸೋಮವಾರದಂದು ಪುರಸ್ಕರಿಸಿ ಅಂತಿಮ ನಿರೀಕ್ಷಣಾ ಜಾಮೀನು ಆದೇಶ ನೀಡಿದ್ದು, ಈವರೆಗೂ ತನಿಖಾಧಿಕಾರಿಗಳ ಮುಂದೆ ಹಾಜರಾಗಿ ಆರೋಪಿಯು ತನಿಖೆಗೆ ಸಹಕರಿಸಿರುವುದಿಲ್ಲ ಮತ್ತು ಸಹಕರಿಸಲು ಪ್ರಯತ್ನಿಸುತ್ತಾರೆಂಬ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸುವುದಿಲ್ಲ. ಅಲ್ಲದೆ ತನಿಖಾಧಿಕಾರಿಗಳ ಮುಂದೆ ಹಾಜರಾಗಲು ಮತ್ತು ತನಿಖೆಗೆ ಸಹಕರಿಸಲು ಕಾಲಾವಧಿಯನ್ನು ನೀಡುವಂತೆ ಕೋರಿ ದಿನಾಂಕ 21 ಆದೇಶವನ್ನು ಮುಂದುವರಿಸಲು ಕೋರಿ ಈವರೆಗೂ ಯಾವುದೇ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. You have not appeared before the investigating officer at all?
No, my lord.
Why?
Because, my lord, immediately, my lord, second FIR was filed.
So?
I came before your lordships. Then, my lord, lord, what happened is, please look at it.
No. Is the bail cancelled in the stay that I have granted?
I'm sorry, my lord, I didn't.
No, is the bail cancelled in the crime of which stay I have granted? Or any other crime?
The first FIR, my lord.
Then I have not stayed the first FIR.
No, my lord.
Then how did you not appear before the investigating officer?
My lord, what happened was, that's what I am trying to submit before your lordship. Please look at, my lord, the dates that I have given to your lordships.
Yes, sir.
27/1, my lord, order is passed by the anticipatory bail. 1/2, I get a regular bail. 1/2, my lord, the second FIR is filed, my lord, they want me
No,
to
no,
arrest
one
me.
moment, sir. First is 27/1/24,
Yes, ma'am.
crime number 6 of 24
Correct.
is registered.
Correct.
Yes, sir.
Anticipatory bail, my lord.
Allah, crime number 6.
First,
Crime number 6 in 6, sorry,
Correct,
first crime 6 of 24.
correct, my lord.
Then Sessions Court grants
Grants an
anticipatory bail. Anticipatory bail. 437.
Correct.
Yes.
Then, my lord,
Then 1 minute. 27/1/24 is that order.
yes,
All right.
2/1.
First February, second
FIR.
FIR, 28 of 24. Then regular bail is granted in what? In 6 of 24, first crime.
Yes.
So this is regular bail.
Correct.
What happened to 28 of 24?
28 of 24, my lord, came to be rejected by this honorable court. I went before the Supreme Court. Supreme Court granted an order of stay. Page, please come to my lord, in July 2020.
So crime number 28, Supreme Court grants stay. That is pending.
Then, my lord.
Now
the
third
FIR.
FIR in crime number 183 of 24. Now bail is cancelled in what? I have stayed 183 of 24.
First one.
I have stayed 183 of 24. First one
Six,
is, no, first one is 6 of 24.
6.
Because you have violated the conditions in the
Correct.
order.
That's the, my lord, anticipatory bail order is cancelled. My submission to your lordship is when a
Anticipatory bail is cancelled. Regular bail is always there.
ಅದಕ್ಕೆ
ಮತ್ತೆ ಯಾಕೆ?
only difficulty is, my lord, police are saying now, my lord, coming near the door and they're saying,
ಅಲ್ಲ regular bail ಇಲ್ವಾ?
ಇದೆ.
No, so far as not 6 is concerned.
ಈಗ ನೀವು 1 by 1 ಹೇಳಿ sir.
But
ಈಗ
so far as
senior
not-
counsel says 6 of 24 was the first crime. Anticipatory bail granted. Anticipatory bail condition was that he should seek regular bail. He seeks regular bail. That is also granted on 1/2/24. By then, second crime is registered in 28 of 24. That second crime is, bail is granted by the Supreme Court.
Stay is granted.
Stay is granted. Stay is granted of what? Further proceedings.
Yes,
No,
Stay, bail ಕೊಟ್ಟಿದಾರಾ? Stay ಮಾಡಿದಾರಾ?
stay ಮಾಡಿ.
not a
Stay
stay
ಮಾಡಿದ್ದಾರೆ.
not 482 petition, not that is.
Oh, that is
concerned.
stayed.
482
So
petition.
now two things are over.
Yes.
One is 183, I have stayed. 28, Supreme Court has stayed. Now what remains is 6 of 20.
6 of 24. Not so far as 6 of 24 is concerned, but anticipated bail was granted. Not thereafter, but he did not comply any of the conditions, so not it came to be cancelled. But simultaneously, not he had also filed 482 petition that came to be rejected by this honorable court.
In 6 of 24.
How,
All
no,
right.
this honorable court.
That's
was-
Justice Natarajan or order.
Yes,
ಹಾ.
but thereafter that was.
ಪ್ರೊಡ್ಯೂಸ್
challenged,
ಮಾಡಿದ್ದಾರೆ,
but-
ಇಲ್ಲೇ ಇದೆ.
But now,
Page 77.
but subsequently today. it's-
ಇಲ್ಲ, ಇದು 28 of 24 ಇದು.
But that is different, but this is 28.
6 of 24 ಎಲ್ಲಿದೆ order?
That they have not do.
Please come to, my lord, my list of additional documents that I have filed.
We have been served with a copy at 2:43 PM today, your lordship.
ಏನು ಪೆಟಿಷನ್ ಕಾಪಿನ?
ಅಲ್ಲ, additional documents.
Additional 243.
At
ಈಗ
2:43 PM.
All right. ಅದರಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ?
ಇದು sir.
Why Ajay, what
One
stopped you
four
from serving them earlier?
ಏನ್ ಮುಂಚೆ ಯಾಕೆ ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
All these are on record, in the other 482, they are all.
Same documents.
Same documents which are in other 482, they are appearing.
That's all right. Now, where is the
Page
order
14,
rejecting crime,
Page
6 of 24?
14, 14.
But 6 of 24, that is not.
631. Page 482 to 631. Criminal petition number 631.
Yes, but that is produced now, God.
Sir, 6 ವಜಾ ಆಗಿದೆ 482 ಅಂದ್ರೆ
ಅಲ್ಲ, ಇವಾಗ
ಎಲ್ಲಿದೆ?
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
631 ಕೊಡ್ತೀನಿ sir.
Additional documents 14 ನೋಡಿ.
But
First
that is not
February
on page
24 order.
14. Page 14 of the present
Crime number
additional
6.
document.
Criminal petition is dismissed.
Yes,
Is this dismissal has become final?
Yes, yes.
yes.
Supreme Court.
Not honorable Supreme Court not also dismissed.
ಓ SLP ಹೋಗಿದ್ದಾರೆ ಇದ್ರ ಮೇಲೆ?
Not under similar circumstances, not He had also filed not an application seeking anticipatory bail. But this on report not by considered order not was pleased to reject the same.
Anticipatory bail.
Yes, yes,
ಎಲ್ಲಿದೆ?
Crime number
Page.
28.
in crime number 28 of 24.
Sir, 28 Supreme Court has stayed, forget it.
But that is 482. And not with regard to anticipatory bail, but this on report was pleased to reject the.
Sir, 482 stay ಮಾಡಿದ್ಮೇಲೆ bail ಇದ್ರೇನು ಇಲ್ದೇ ಇದ್ರೆ.
I understand, but not that is the order
It's all right.
rejecting
Now we are concerned with 6 of 2024.
24.
Everything now has happened in 6 of 2024. Now 6 of 2024 ಅಲ್ಲಿ 482 is rejected. Supreme Court has turned down the SLP. So this has become final.
Yes.
Now 6 of 24 anticipatory bail was granted. He has, then one condition was regular bail should be taken. He has violated the conditions in anticipatory bail anta you tell. Why he did not appear before the investigating officer. So bail is cancelled.
But it is cancelled not by the order not now under challenge. But he is not, Lord, he is a habitual offender. But apart from these 2-3 cases, there are another 8 or 9 cases not registered against him.
Different topic.
By different parties.
FIR ಮಾಡಿದ್ರು, ಇನ್ನೊಂದ್ ನಾಲ್ಕು
But in fact, not, I want to bring to your lordship's notice,
ಕೊಡಿ.
because of short of time, today not we got these.
Madam said she will get all the papers today.
But they produced not additional documents now.
ಅದೆಲ್ಲ ನಿಮ್ದೇ ಸರ್. ಒಂದು objection ಹಾಕ್ಬೇಕಾಗಿತ್ತಾನೆ ಇಲ್ಲಿವರೆಗೆ. I granted time only to file objections, not to go through the papers.
Your lordship, true, your lordship.
Because the question of bail,
Because of the continuous holidays, it was difficult.
that is the right time to
File
prepare objections.
True, your lordship, to talk to the senior counsel, designated counsel and get his appointment.
You
and
ಊರಲ್ಲಿ
wait
ಇರ್ಲಿಲ್ವಾ?
some time.
Yes. Tomorrow?
Day after tomorrow.
Why day after tomorrow?
ಆಗ್ಬೋದು.
ಈಗ regular bail ಇದಿರಲ್ವಾ? Any threat of arrest? Why?
My lord, that is why we came before your lordship. That is what, my lord.
ಅಲ್ಲ
in fact,
regular
my lord,
bail ಇದೆಯಲ್ಲ ಈಗ. Anticipatory bail ತಾನೇ
Lord, the
reject ಆಗಿದೆ.
order itself says cancelled and police are near my, they are coming near the. this thing.
ಅದು ಇನ್ನೊಂದು crime ಇಂದ ಇರ್ಬೇಕು.
But he has managed for 1 year. There is no difficulty threat.
Yes.
I will file.
I-
not,
I'll-
This day after tomorrow in the fresh heard senior counsel so on.
This,
ಆಗ್ಬೋದು.
List day after tomorrow in the fresh
ಆಗ್ಬೋದು.
matters. All right.
this,
No, I don't want to show indulgence to a person who has not appeared before the
No,
investigating
I
officer.
understand.
That's all.
I understand.
Otherwise,
That's why,
bail I would
that
have,
is why I said,
yes.
whatever condition your lordship, my lord, I couldn't, my lord, go before the police because of this reason.
Let's
They
see.
kept on filing, my lord, 3 FIRs on the same this.
All is all right, you produce everything, sir.
Yes. Yes.
Now don't again, madam, don't come again with
Yes, your lordship. Yes. Yes.
short of material.
Yes, your lordship.
Jagdish, ಅವರೇ, you also get whatever is to be got. Yes.
Let me give some, ನಾಳೆನೇ ಕೊಟ್ಬಿಡ್ಲಿ ಒಂದು copy so that now.
Copy ನಾಳೆನೆ ಕೊಟ್ಬಿಡಿ. Yes.
Number 4.
For the petitioners only, 498A.
Why is it listed? for?
Except A1.
Husband.
Except A1 ಗೆ stay.
Correct, ಅದೇನ್ ಯಾಕೆ ಇವತ್ತು ಬಂದಿದೆ ಅಂತ ಅಷ್ಟೇ ಅಲ್ಲ.
Date
Fresh mat. 2621. Husband ಇಲ್ಲ.
ಅದು ಆಯ್ತು.
Yes. All other state.
Thank you.
ಕೊಟ್ಟಿದ್ದೀನ?
ಹೌದು.
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ ಅಷ್ಟೇ.
ಆರ್ಡರ್ಸ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನ್ ಹಾಕಿರ್ಲಿಲ್ಲ.
ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಇರ್ಲಿ. ಇವಾಗ್ಲೂ ಇಲ್ವಾ?
ಇಲ್ಲ ಹಾಕಿದೀನಿ.
ಕಾಪಿಯಲ್ಲಿ ಕೊಡಿ.
ಕಾಪಿ ಇಲ್ಲ ಇದೆ. ಕೊಟ್ಟಿದ್ದೀನಿ ಮಾ.
5.
ಇದ್ರೆ ಸ್ಟೇ ಇಲ್ಲದೇ ಇಲ್ಲ ಅಷ್ಟೇ. Yes. ಸುಹಾಸ್ R1 ಸರ್ವ್ ಮಾಡಿದೆ.
I'm for the petitioner. They have settled amicably before the mediation.
498 ಏನ?
Both the husband and wife are present.
Where is the memorandum of settlement?
It is already been filed, my lords.
1 minute. ಎಲ್ಲಿದೆ?
Page number 19.
Page 19. ಅದ್ರಲ್ಲಿ ಕಂಡೀಷನ್ ಒಂದು ಪ್ಯಾರ ಮಾತ್ರ expect. 498 dispose. Signature.
I'm filing a memo, my lords. In this, the court has been transferred, my lords, from 6th additional
Case has been transferred. sir.
cases.
Court has been transferred.
Files.
Yes. ಇದರಲ್ಲಿ ಏನ್ ಯಾವ ಕೋರ್ಟ್ ಅಂತ ನೋಡ್ಬಿಟ್ಟು ಅದೇ ಕೋರ್ಟ್ ಕ್ವಾಷನ್. ನೆಕ್ಸ್ಟ್.
Orders Number 6, withdrawn.
in terms of the memo. Non-compliance of
7.
office objection.
My lord, I appear for the petitioner in this matter, my lord. The
What
matter,
What office objection?
my lord, offers objections with regard to the probably the disposal of the matter, my lord.
Disposal.
My lord, the matter was disposed of on 4th of September.
What
20
happened? Which is that matter?
My lord, item 7 of list 2.
Criminal petition number 13850
But
of 2020.
It was dismissed, it was disposed of in the absence of counsel for the petitioner, and there was no representation on behalf of the petitioner, my lord. I have been subsequently engaged in the matter, my lord, after procuring NOC.
CGP,
That it counts.
and submit charge. Madam, charges are framed. I will not even interfere even otherwise.
My lord, my lord, in that case, my lord, I will press for specifically with regard to the SC/ST Act provisions, my lord. With respect to that, my lord, the matter may kindly be heard.
Charge frame, no, even if you submit also, I will again follow Meenakshi Bala and close it.
My lord,
All contentions before the concerned court.
my lord, that opportunity may kindly be given, my lord. I beg
That
for
I
that.
will do. That's not a problem. This order I will recall
My lord.
and pass that order and give you liberty to urge all contentions before the concerned court.
My lord, I respectfully submit that the provisions of SC/ST Act cannot be invoked against the person who himself belongs to the SC/ST community, my lord. And the petition.
That is the one that is invoked against you?
Yes, my lord. So
Complainant, you are the only accused?
I am the accused number 5. Supplementary charge sheet was filed against me after 11 months of the first charge sheet based on a hearsay evidence incriminating me into the matter, my lord.
No, that is an application under 319 was filed.
No, my lord, it was based on the supplementary charge sheet, my lord.
Supplementary charge sheet,
My lord.
173.8.
My lord,
There
as-
appears to be something in what she says.
my lord,
If he also belongs to the same community, where is the atrocity case against him?
He belongs to scheduled tribe.
I thought whatever, SC or ST,
should we try?
then this is application ಹಾಕಿದ್ದೀರಾ recalling ಗೆ?
Yes, my lord.
Really?
The application is there, my lord. The
Yes,
application is there.
There are two applications.
Nandish, why were you not present that day then?
I was present, my lord. In fact, I requested your lordships to show my name also. Inadvertently, my lord, does not shown. I will find an IA to that effect, my lord, along with my own affidavit, my lord.
You should have told what she's telling now. It cuts at the root of the matter.
Please, my lord.
Person belongs to tribe.
If check ಮಾಡಿ, if accused number 5 is also belonging to scheduled tribe, where is the atrocity offense against him? Why should I permit trial for that? Except that others we will see, other offenses.
My lord, I may be permitted to advance submissions on the merits as well.
Yes,
If
wait. This court on order on IA 3 of 20, what is 2 and what is 3?
My lord, there was an application for condonation of delay as well, my lord.
For the reasons indicated in the affidavit accompanying the application, so and so, the order stands satisfied with the same order stands recalled. Heard the learned counsel, Nisha Tiwari, appearing for the petitioner. The petitioner is accused number 5. He is charged of offences punishable under so and so, alli prayer lida. The offences include the offence punishable under the provisions of the Atrocities Act. The learned counsel for the petitioner submits that the accused number 5, the present petitioner, also belongs to scheduled tribe. If that be so, it is impermissible to lay offence under the Atrocities Act against the petitioner. The learned additional SPP on instructions would submit that the charges have been framed. In the light of the charges being framed, generally if the charges are framed, generally this court would not interfere at the stage of evidence. But the submission made by the learned counsel for the petitioner merits acceptance, qua the Atrocities Act, as it cuts at the root of the matter. Therefore, I deem it appropriate to stay further proceedings, qua the petitioner till the next date of hearing. List the matter on 29th November.
Great, my lord. I'm obliged.
Next.
My lordship, on submission. Morning, not related. Morning 170 serial number, we have submitted the.
IA ಹಾಕಿದ್ದೀರಾ?
My lord, that has been filed.
Yes.
I'm grateful.
Same. I've already granted an order in the morning, same
Please.
order. That will remain. ಅದನ್ನ ಆರ್ಡರ್ ಆನ್ IA ಅಂತ ಮಾಡಕ್ ಹೇಳಿ.
It is filed in the registry.
Obliged.
Next.
Please.
ಏನಿದೆ?
N. Ravishankar, office objections.
Number eight.
Office objections, I had to attest the typed copies I've attested. I've done
Ready
them. I've done them.
Office objections, Learned Council submits office objections have been complied with. Nadithavalla, fresh matters. Day after tomorrow in the fresh matters.
Order of not to take, they are in order of not to take any coercive step.
Idea.
Okay.
Oh, you, stone, detail order have passed.
This is the case where
Oh, squabble between two wives.
squabble between two wives and the doctors of the rehabilitation center were alleged of wrongful restraint and kidnap.
The second wife alleging first husband.
Second
The
wife
only
alleging
husband.
against the third husband.
Third husband,
The detenue in the rehab was.
complicated relationship, Nadit Kirana.
Please.
Day after tomorrow in the fresh matters list. Yes.
Number nine.
Non-compliance of office objection.
Sorry,
in-
I found that some objections are there. Perhaps earlier FIR was questioned in the earlier petition. Perhaps
Charge sheet file madidra.
charge sheet file, now in this charge sheet is questioned.
Eh.
The seizure of 6 liters of whiskey, foreign whiskey,
ಯಾವ whiskey?
foreign whiskey,
Foreign ಅಂದ್ರೆ
foreign ಮಾಡಿದ್ದು, imported.
ಅದು ಯಾವ್ದು?
That is, I have mentioned in the, my lord's,
ಮಾತ್ರ ಹೇಳ್ತಾ ಇಲ್ವಲ್ಲ.
I have, page, I'll read, at
Oh.
least for my,
Yes, sir, please.
yes. Page number 5, para 3, that on.
ಎಲ್ಲ within the permissible limit under the
Permissible limits.
notification. How could you charge, sir?
Permissible limits.
Correct? 18 liters.
9.1 liters.
9.1 whiskey. ಬೇರೆ ರಮ್ ಎಲ್ಲ ಇದೆಯಲ್ಲ.
ಇಲ್ಲ ಇಲ್ಲ ಎಲ್ಲವೂ
ಏನಿಲ್ವಾ?
foreigner. ಎಲ್ಲವೂ whiskey-ನೇ ಇದ್ರೊಳಗೆ. I will read it now.
Sir, I have told you, if you are caught with this whiskey, it is very risky.
It is, the place is also, my lords may kindly see.
Place,
On the way to airport, there are certain places. Either from the airport, what you call, that some shop, duty-free shop, or Air Force station. These are the prone areas. I have come across one peon in Syndicate Bank, my lord. He was a peon Syndicate Bank Air Force Training Command. The person became millionaire.
Oh, whiskey.
That is all Air Force quota.
Correct.
Here, my lords,
ಇದು ಯಾವ quota?
this is, my lord, imported bought from airport
Duty free shop.
duty-free shop. That's what my instructions are. Even otherwise, under the
ಅಲ್ಲ,
possession,
how many liters were you carrying, sir?
6.1 liters.
9.1, ಇನ್ನೊಂದೆರಡು ತಗೊಂಡ್ಬಿಡ್ಬೋದು.
ಅದು ತಂದಿಲ್ಲ, ತರಕ್ ಆಗಲ್ಲ ಅಂತಾನೆ ಹಿಡ್ದಿಲ್ಲ, ಹಿಡಿಯಕ್ may not say. Even otherwise, my lord, under section 43, in 24 hours, like production of an accused, the confiscation proceeding should start.
That is 43A.
43A. Now the car, I am told that he is not the owner of the car also. No case against the owner of the car. It has become an iron ash.
ಯಾವಾಗ 22.
No, I have filed.
ಎರಡು ವರ್ಷ ಏನ್ ಮಾಡಿದ್ರಿ ಕಾರ್ನ?
No, sir, not a single.
Why you did not file an application seeking release of the vehicle?
It is, my lord, prayer.
ಇಲ್ಲಿ ಯಾಕೆ ಮಾಡ್ಲಿಲ್ಲ?
What happened was.
This is why I release the vehicle immediately. Police station ಮುಂದೆ it will be
Yes, earlier.
rain and
Now the.
both under shower and sun, it will go.
Now the judgment has come from Kalburgi bench. Otherwise, bank guarantee is mandatory for an interim custody. My lords, in the Kalburgi bench have now declared that it is not necessary that.
Bank guarantee is not mandatory, sir.
Yes, before that.
Indemnity is what is mandatory. ಇಲ್ದರ್ vehicle ತಗೊಳಕ್ಕೆ ಆಗಲ್ಲ ಯಾರಿಗೂ bank guarantee ಆದ್ರೆ.
That's why, on that ground, my lord, only proceeding stay I had asked for.
So now I will stay everything. But what happens to your vehicle?
My lord, I have.
ಹಿಂದಲ್ವಲ್ಲ car ಅದು.
My prayer is on the same condition as it was seized. Perhaps the officer will be caught. He has to be, in it happened before this honorable court about 20 years, they were directed to give a new vehicle.
We will also, but ಅಲ್ಲಿ ಏನಾಗಿದೆ, in the case that you would say that they were directed to give a new vehicle, there was an order to release the vehicle, they had not released.
The officer was at 2:30 from Mandya.
No, that is why there was a direction to release, he had not released. ಇಲ್ಲಿ ಎಲ್ಲಿ ಕೇಳಿದಿರಾ?
The FIR.
ಹೇಳಿಲ್ದೆ new vehicle ಬರಲ್ಲ.
Lord, the branch, so rush. I will submit, I had, other day, I may not be mistaken for making the same submission. FIR was questioned in the earlier petition. I mentioned.
No, that is only
Yes,
last
yes,
week, sir.
yes, I
I
submitted.
will grant you a stay, that's not a problem.
Please.
22 in the vehicle ಅಲ್ಲಿ ನಿಂತಿರೋದು ಯಾಕೆ release of vehicle ಕೇಳಿಲ್ಲ?
Bank guarantee, oh, only.
Your Lordship,
ಇಲ್ಲ, ಅದಾದ್ರೆ ಕೇಳ್ಬೇಕು. ನಮ್ಮ ಮುಂದೆ ಬಂದ್ರೆ ಏನಾದ್ರು ಒಂದು ಆರ್ಡರ್ ಕೊಡ್ತೀವಿ.
Stay of
Your Lordship has passed
proceedings,
multiple orders.
Multiple orders, bank guarantee, wherever I find, I quash it.
Yes, my lord, sir, I have. seen
Because
the
ಇವರು
Judgment also.
ಲಾರಿ ವ್ಯಾಲ್ಯೂ 3 ಲಕ್ಷ, ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿ 10 ಲಕ್ಷ ಕೇಳ್ತಾರೆ.
Because RTO valuation, when the earlier petition was filed, I did not have my lord's judgment on that.
I have rendered so many judgments on
Yes, I-
release of vehicle. I take the memo immediately and post it next day and release it.
Lords may kindly direct the release of the vehicle. So we may have to spend some money for it, sir. And he has to answer for his friend, who is the
The
owner.
petitioner heard the learned senior counsel J.K. Bhatt appearing for the petitioner. The petitioner calls in question registration of proceedings in CC 16924 of 24 registered for offence punishable under section ಏನಿದು
11, 40, 32, 34 and 38. A are
of the Karnataka Excise Act 1965. The allegation against the petitioner when the vehicle was intercepted was that he was carrying IMFL, Indian made foreign liquor, of 6.1 liters. The learned senior counsel would take this court through the rules framed under the Excise Act with particular reference to Rule 21 of the Karnataka Excise Rules 1967, which permits carrying of liquor, whiskey in particular, up to 9.1 liters. The petitioner admittedly was caught when the vehicle was intercepted with 6.1 liters of whiskey, which the petitioner substantiates that he had purchased it from the duty-free shop at the international airport. Be that as it may, since it was in permissible limit of what a person can carry under Rule 21 of the Excise Rules 1967, no crime itself could have been registered against the petitioner. The learned counsel submits that just notwithstanding the crime being registered, the vehicle that was seized is now kept in a dilapidated condition in front of the police station. Therefore seeks release of the vehicle. The vehicle in the condition that it is shall be released forthwith. Forthwith, there shall be an interim order of stay of all further proceedings in CC so and so till the next date of hearing.
Rule is possession, transport, etc. of the rules 1960.
Rule 21 alva.
Rule 21.
Ah.
Correct.
Correct.
Rule 21.
Rule 21 of the Karnataka Excise Possession so and so nodi.
Transport, code of rules, intoxicant rules.
Rule 21 correct?
Yes, please. Schedule Kutia.
Yes.
Great.
Yes, sir.
What time?
Speedy trial,
Really type.
needy trial. ಅವರು ಒಂದು ಸ್ಪೀಡಿ ಟ್ರಯಲ್ ಅಂತ 3 ದಿವಸ ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಕೇಳಿ. Yes, sir. What is this?
Office objection, my lord, is to produce entire charge sheet, my lord. We are
Hakilva.
ready with the charge sheet.
No,
But,
if it can wait till day after tomorrow.
But there is some
Urgency,
urgency
ಹೇಳಿ.
matter is, my lord, here. May kindly see, this is a case of murder, my lord. Charge sheet was filed against 19 accused, your lordship. Lord, one of the accused, my lord, accused number 16, my lord. A wrong person was arrested and produced and got remanded to judicial custody.
Wrong person.
The wrong person, my lord. Real person, my lord, who is involved, my lord, in the commission of the offense is still away. He has not been arrested. My lord, to his place, my lord, an innocent person has been produced, got remanded to judicial custody. He was there in custody, my lord, for a long time. We approached, my lord, this honorable court, my lord, in the revision petition. My lord, this court directed, my lord, to conduct further investigation. Kindly see, my lord, this order, my lord, page 27, your lord. Kindly see, my lord, page 31, my lord, the last part of the order, paragraph number 5, your lord. Is, I feel that the matter is of a serious nature which requires further investigation by the investigation agency to search the real accused person, so as to bring home the guilt of the real culprit before the court for trial. My lord, in pursuance of this order, my lord, an application under 173(8) was filed before the trial court to direct the investigation officer to conduct further investigation. My lord, in pursuance of that order, my lord, the concerned police, my lord, they secured the real person to the police station.
All right.
My lord, they did not array him as an accused, but he was sent away
How do you demonstrate that the real person was brought to
We
the?
have stated, my lord, we have an information, we could not get any document, your lordship, one thing it is, my lord, after this, my lord, they asserted, my lord, that this person himself is called, here two names, your lordship.
Salman.
Salman is the person, my lord, who requires in this case. The present accused, my lord, his name is Abdul Munaf. Abdul Munaf. My lord, all, my lord, election card, ID card, ration card from his birth, my lord, his name is Abdul Munaf.
Then why was he in place of Salman?
He was wrongly arrested by the police and made to appear, my lord, as Salman. But the real person, my lord, who required, my lord, to be, who involved in the commission of the offense is still away, who is Salman, son of Suhail Ahmad. Now, my lord, that in the virtue of direction for further investigation, the police, my lord, cleverly what they say, this Abdul Munaf is also called as Salman. His name is also Salman. Like that, my lord, they prepared a report and filed before the court. We raise an objection. The investigation, which was directed for identification of a real Salman, that has not been done. My lord, whatever now the report is filed is not effective, is not a correct report. Therefore, direct for further investigation, at least to a CID police. My lord, the trial court observed in the order dated 2/9 that this court has no power to direct for investigation.
No,
by
that
CID.
court has no power.
No
correct.
power, my lord. Therefore, we have filed this writ petition, my lord, that when our information is a definite information, your lordship, still this real Salman is available, he is alive, he has been brought to police station. My lord, the police authorities consulted the legal department and the commissioner. Thereafter, they felt that if we say now, it will be a remark against us. My lord, that concerned police, my lord, they did not file him or produce him before the court.
Yes, let's
Well,
see.
this is very serious allegation.
I know,
my lord,
correct.
that-
What you say is
my lord,
serious.
law is very my lord, certain that real culprit should not escape punishment.
Correct.
My
That
lord,
is
innocent also should not get
So
some.
that
This
is
is the law, my lord.
the salutary principle
Yes,
of criminal
salutary principle of
jurisprudence.
criminal law.
Yes.
Page
This,
140, man.
No, but what the senior counsel is saying is correct.
No. Your lordship, if you page 140, man. In fact, the submission was investigated and witness's statement was recorded to that extent.
No, this real man is still at large.
No, it's same person. In order to evade the delay the process of trial, he is making these kind of allegation is what the finding of the report, my lord. Second, next page, page 114, second para.
this is the supplementary report they have prepared like that.
No, how do we now demonstrate
But that
further
person is
investigation has to be
that
ordered?
person is still available, your
This is
lordship.
the further investigation report.
And my lord, here your lordship may kindly see, this man is not Salman. He is not the son of Suhail Ahmad. That is definite. No, we are claiming, my lord, only in respect of this. And also real culprit is there. They have traced it. My lord, the information is definite. They have traced. But we are not concerned. The applicant is, my lord.
Where
before
is the order passed by the court now?
Page
Now, my
94,
lord, your lordship, kindly, the order, my lord, is at page kindly 95, your lordship. And page 97, my lord, that this court has no power to direct for CID investigation. Para 6, your lordship.
That's
Page
what your lordship
97.
judgment, my lord.
No, that is correct. That's no doubt. That court has no power to direct investigation to some other agency.
Lord, in the revision petition, my lord, this honorable court has verified and then directed, my lord, for further investigation. Entire records was summoned and it was verified and order was passed. It requires further investigation. Matter is very serious.
We
in
will
nature.
direct further investigation by a different agency. That could, I think.
Sir, in fact, one of the reports says, my lord, in order to delay the trial,
No,
this kind of application was
No,
filed.
that's all right. That if we take it so easily, it's not. If somebody, the real culprit is at bay and others are being, we'll say, I'll pass orders tomorrow. I'll go through the file.
But our prayer is that, my lord,
Further investigation.
independent agency by
That is. We'll direct the, then CID, na?
we have sought for CID, my lord.
Crime Investigation Department, we will send it. Tomorrow I'll pass. Second list ಆಗುತ್ತೆ madam. ನಾಳೆ second list ಆಗುತ್ತಾ? ಆಗುತ್ತಾ?
The fresh matter, lord.
I'll dictate tomorrow. I'll go through the file and judgments ಯಾವ್ದಾರು ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ.
Lord, it is there, my lord, I will produce, my lord, I could not locate it.
ನಾಳೆ ಓದ್ಕೊಂಡ್
Decision of
ಬರಕ್ಕಾಗಲ್ಲ.
Supreme Court, my lord, that one guilty person should not
Sir,
escape.
that
innocent.
that
This is, my
principle I
lord,
know, that's all right.
the-
Other bit on the issue, if you have
On the
some,
issue, my lord, further investigation. my
that also I know, sir.
lord. Yes.
Other than that,
Recent issue, my lord, is also that.
further investigation I know, sir.
Yes.
Other than that,
No other point, my lord. Only these two
Ah,
points are
all
involved in this.
tomorrow.
Office objection, my lord.
ಅದೆಲ್ಲ ನಾಳೆ ನೋಡೋಣ. Yes.
Public-
11.
ನಾಳೆ first issue.
The petitioner is convicted under the 138 of Negotiable Instruments Act. my lord.
Jambu
He's facing-
Bhandari'na? 20%.
No, my lord.
Asking
I am already concurrent
sentence.
findings, my lord. I'm already in prison, my lord. I was convicted for 6 months along with 30 days.
ಎಲ್ಲ covered ಅಲ್ಲ
finding.
judgment ಅಲ್ಲಿ.
Please, my lord. VK Bansal was his
Bansal ಕೊಡಿ.
state of Haryana, my lord. There's a single arising out of a single transaction, my lord.
ಕೊಡಿ ಇದು day after tomorrow ಹಾಕಿ. List day after tomorrow in the fresh matters list. ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. It's covered.
Only this judgment says if it is only single transaction.
Yes,
We'll see.
single transaction.
It's single transaction ಅಂತ ಇದ್ದಾರೆ.
Oh, this one, page number 18, my lord. The judgment
Notice
itself
may-
starts stating
Yes.
that due to technical
Next,
issues.
next.
Notice may have to go to the complaint.
We'll see first. Complainant ಗೂ ಇದಕ್ಕೆ ಏನ್ ಸಂಬಂಧ? is already convicted.
Party
Then-
I've
ಮಾಡಿದ್ದಾರೆ.
undergone additionally 2 months also.
Party ಮಾಡಿದ್ದಾರೆ.
Yes. It was not necessary to be, it's not necessary to hear him. Yes, next.
Hearing on IS number 12.
Adjournment. Friday na? Thursday. ಯಾವತ್ ಹಾಕಿ, ಯಾವತ್ ಕೇಳಿದರು. Next, Sarvana.
Just day after tomorrow in the fresh list. In the meantime, I will secure the certificate copies also of the FIR and complaint.
List day after tomorrow.
The fresh.
ಇಲ್ಲ, ಏನೋ dispensation ಇದೆ.
ಅದಕ್ಕೆ FIR.
IA 1 of 2024 for the reasons dispensed ಅಂತ ಮಾಡಿ. List day after tomorrow in the fresh matters.
Admission 14.
Due to inadvertence, the matter has
Wrongly connected.
it is wrongly connected. The matter has to get connected with criminal appeal 180.
ಯಾಕೆ criminal appeal ಇಲ್ಲಿ connect ಆಗಿದೆ?
They're not connected to each other.
It should go before the other bench.
Please, my lord, the matter has to get connected
See.
along with criminal appeal 180.
Tag the D-link, criminal appeal 1739 of 2024. And list it before the bench having appropriate roster. ಮಿಕ್ಕಿದೆಲ್ಲ ಟ್ಯಾಗ್ ಆಗಿರೋದು ಕರೆಕ್ಟ್ ಆಗಿದೆಯಾ? ಇನ್ನೊಂದು ಅದೇ ಒಂದೇ ತಾನೇ ಇರೋದು.
ಒಂದೇ.
So 15 for withdrawal in term counsel with the petitioner ಯಾರು ಮೂರ್ತಿ withdrawal
I will petition in 14.1, criminal petition 18-0.
ಅದಾಯ್ತು ಸರ್. 15
Or maybe extend.
extended. 15
15.
withdrawal
For
second respondent ಈ ಕಡೆ ಬನ್ನಿ. Learned counsel for the petitioner seeks leave of this court to withdraw the petition. The submission is placed on record. Petition is disposed as withdrawn. Next.
Hearing for the petitioners in this case, my lord. This is the case, my lord, wherein the FIR has been lodged against the petitioners, my lord, at 26/5/6/2022, my lord, at around about 17.
After 4 weeks, entry order subsisting shall continue till the next date.
My lord, there is no interim order in this case, my lord. Yeah, connected matter, there is interim. This is a counter case, my lord. This is
Counter.
case, sorry, my lord.
Companion petition is the interim order ಇದೆ ಈ petition.
Much obliged.
Yes. 17.
11 application filed by the came to be rejected. The accused is in JC, my lord.
Accused is in JC. Any
Yes, my
offense?
POCSO Act, my lord. They, after completion of the arguments from the accused side, the public prosecutor filed the application on section 311, my lord.
Dictate day after tomorrow in the fresh matters list. Allow ಮಾಡೋಣ.
After hearing the arguments.
ಏನ್ ಪರವಾಗಿಲ್ಲ. ಯಾರನ್ನ
DNA,
ಯಾರನ್ನ
FSL.
POCSO, sir, if he gets convicted more than 10 years.
No, even after completion, after raise the objection and furnish the,
Sir, I will permit. Day after tomorrow I will permit. And I will fix a date, avat close ಮಾಡ್ಬೇಕಷ್ಟೆ.
please.
Yes, next.
18.
Settlements ಇದೆ madam. Yeah. Settlement ಕರ್ಬಿಡಿ. Settlement ಕರ್.
Voting settlement 24.
24. Wait. Settlement ಕರ್ಬಿಟ್ಟು ತಗೊಂತೀನಿ.
24.
Offense.
My lord, in this, it's a defamation.
Defamation.
Yes, it is, as per the mediation report in OAS, 61/19, between the daughter of the petitioner and son of the respondent. They were husband and wife. After that, in the mediation,
ಅಷ್ಟ್ ಹೇಳಿದ್ರೆ ಸರಿ ಇರುತ್ತೆ ಡಾಕ್ಟರ್ ಅದೆಲ್ಲ.
the matter got settled.
Defamation between husband and the wife.
ಅಲ್ಲ ಇದು
Already settle ಆಗಿದೆಯಾ?
settle ಆಗಿದೆ sir. As per the mediation report, I filed.
Flag ಹಾಕಿದ್ದೀನಿ.
They are present.
ಈ ಕೇಸ್ ಬಗ್ಗೆ ಎಲ್ಲಿದೆ?
CC
ಇದರಲ್ಲೇ ಆಗಿರೋದ?
2182.
ಆಲ್ರೈಟ್. ಫ್ಲಾಗ್ ಹಾಕಿದ್ದೀನಿ. ಎಸ್. ನೆಕ್ಸ್ಟ್.
Party sign. Signature.
ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ? ಎಸ್.
25.
False promise to marriage, my lord.
Offense.
False promise to marriage, my lord. 376.
Promise to marriage.
Yes, my lord.
No settlement. Come on, merits.
Please, my lord. My lord,
ಎಷ್ಟು ವರ್ಷ ರಿಲೇಶನ್ಶಿಪ್?
4 years, my lord.
ಎಲ್ಲಿಂದ ಎಲ್ಲಿವರೆಗೆ?
My lord, 22, 23, my lord. 19 ಇಂದ 23 ತಕ, my lord.
Day after tomorrow in the fresh matters.
Public.
We'll pass orders on merits. Settlement is dangerous in this. Yes. ಅವ್ರು ಯಾರು ಬರೋದ್ ಬೇಡ. Let not the parties come. Yes.
26.
The petitioner. Foxo. But marriage ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೆ.
ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ. ಯಾಕೆ?
The girl was aged about 17 years, 3 months as on the date of the alleged incident.
All right.
Guy was 20 years.
Ah.
Love affair.
Who was 20 years?
Boy.
Boy, not guy.
No.
Yes.
Now both of them families have decided to perform the marriage. He is in JC. The child was born, my lord.
Child?
ಹೌದು. But 6 months ಆದ್ಮೇಲೆ due to the health problems, the child expired.
Where are the reports? ಎಲ್ಲ?
Reports, medical reports are there
Complete medical reports.
of the child, my lord.
I'll secure.
Secure complete medical reports.
Victim and mother is
Victim
present.
and what he says is correct or not.
Him and
Age of the victim as on the date of the incident.
17 year, 1 month.
17 years, 3 months.
1 month.
ಆಯ್ತು. Anyway, get all the details and you are in custody since when?
From fifth January 2024.
24.
Complainant is also present.
Victim and mother is present. Filing wakalat and affidavits, sir.
ಅದು ರಿಜಿಸ್ಟ್ರಿಯಲ್ಲಿ ಹಾಕಿ ತೊಂದ್ರೆ ಇಲ್ಲ. You get everything. ಯಾವತ್ತು ಹಾಕಿದ್ದೀನಿ ಮಾಡಿ? ಇಲ್ಲ ಇನ್ನೊಂದು. Yes. We'll take it on 15th, Jagdish. Foxo cases ಹಾಕ್ತೀನಿ.
Evidence is started before trial court. Let them, the lordship can direct the dispose of within a month.
Acquit ಆಗ್ತಿರುತ್ತೆ.
evidence
ಅಲ್ಲ, anyway she is going to turn hostile.
Allah turn hostile, but based on the medical reports, my lord, the judge has said that I'm going to convict.
ಏನೇ
Please approach this court. ಅಂತ.
ಅವರು ಪ್ರಾಬ್ಲಮ್
ಏನೇ ರಿಪೋರ್ಟ್ ಇರ್ತದೆ.
ಏನೇ ರಿಪೋರ್ಟ್ ಇದ್ದೇ ಇರುತ್ತೆ.
ಅದಕ್ಕೋಸ್ಕರ based on that it has to be approached.
Oral instinct.
Child birth ಅಂದ್ರೆ DNA ರಿಪೋರ್ಟ್ ಇದ್ದೇ ಇರುತ್ತೆ, whether it is still born or born.
That itself is that.
ಮತ್ತೆ ಅದಕ್ಕೆ witnesses turned hostile ಅಂದ್ರೆ ಮತ್ತೆ get all the records.
Yes.
On 15th we'll pass orders on merits.
Yes.
ಎಲ್ಲ ಟ್ರಯಲ್ ಎಲ್ಲ ತಗೊಂಡ್ಬನ್ನಿ. Jagdish, look into it.
Yes, sir.
I want DNA report of the
Yes.
fetus. ಮಾಡಿರ್ತಾರೆ.
ಮಾಡಿರ್ತಾರೆ.
Yes. 15th ಮಾಡಿ.
27.
Petition in this case, pray for 1 week time, my lords.
Why, sir?
First petition is pending, my lords. ಅದು maintainability ಮೇಲೆ ಇತ್ತು.
ಒಂದು
Petitioner
ಹಾಕಿದ್ದೀರಾ ಆಲ್ರೆಡಿ, ಯಾಕೆ?
ಆ ಫಸ್ಟ್ ಪಿಟಿಷನ್ ಬೇರೆ ಕೌನ್ಸಿಲ್ ಹಾಕಿದ್ರು, ಅದನ್ನ ವಿತ್ಡ್ರಾ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು.
ಎಲ್ಲಿದೆ ವಿಡ್ರಾ ಮಾಡೋದು? ವಿಡ್ರಾ ಮಾಡಿದ್ರೆ ಇದನ್ನ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ.
ಇಲ್ಲ my lords, ಅರ್ಲಿಯರ್ ಕೌನ್ಸಿಲ್ ಬೇರೆಯವರು ಇದ್ದಾರೆ, ನಾವು ಆನ್ ರೆಕಾರ್ಡ್ ಇಲ್ಲ.
At the request of the council appearing for the petitioner list on 15th.
ಹೌದು.
I continue ಮಾಡಿ ಮೇಡಮ್ ಲಿಸ್ಟ್. ಟ್ಯಾಗ್ ಮಾಡಿ. ಕರೆದ್ಬಿಡಿ. ಇನ್ನೂ ಇದೆಯಾ? ವೆರಿ ಗುಡ್.
33 matters, Suyog Herle, withdrawal.
In terms of the information, want to withdraw, please. Yake?
To file fresh petition, my lords, challenging the charge sheet.
Charge sheet, perfect.
Arun Govindraj.
No, I appear for the. Where is Arun?
No, I'm sorry, my lord. There was a matter at Dharwad, therefore I had to attend on VC.
You're in the office, sir.
I'm sorry, my lord. Dharwad was matter, I had to argue with VC. Therefore, I could not come to the court in person. Kindly pardon me for that.
I think you should adjust your camera, sir. Yes. Ee
I'm
office
sorry.
tara
Sorry. Lord, the first petitioner and the second respondent are husband and wife. There are matrimonial and custody proceedings pending before the Bangalore Family Court. Lord, both these proceedings have sought to be transferred to Gwalior by the wife. She has filed transfer petitions.
That is rejected.
Transfer petitions are pending. The Honorable Supreme Court stays the matrimonial proceedings, but not the custody proceedings. Custody proceedings are allowed to go on. Thereafter, the family court passes an order granting interim visitation to the father in Bangalore to pick up his child from Gwalior.
I'm sorry, my lord.
Well, its transfer petition is filed, seeking transfer of writ petition of habeas corpus to courts in Gwalior. That was dismissed. Subsequently, my lords, the writ petition also, my lords, the writ petition habeas corpus order, my lords, will file.
Mike. Mike on
Might.
Ready.
Final order, my lords, writ petition habeas corpus, page number 141. It came to be dismissed, my lords, on the with the direction to the family court. Since it is brought to the notice that an application for visitation rights is pending in GNWC 58 of 24 before 6th additional family court, we direct the family court to decide the application expeditiously. Thereafter, my lords, she files transfer petition seeking transfer of custody petition as well as the divorce proceedings from the family court Bangalore to the courts in Gwalior. That, my lords, the transfer petition order my lord will find it at page number 175.
What happened to that?
My lords, only divorce proceedings were stayed. In view of the order passed by the division bench of this honorable court in the writ petition habeas corpus, the custody proceedings were not stayed. Thereafter, my lords, an order on IA number 5, which my lord will find it at page number 176. I file an application before the family court seeking interim custody of my son to celebrate his birthday in Bangalore. That application came to be allowed. Subsequently, my lord, that order was challenged before this honorable.
Now, what is the problem, sir?
Thereafter, my lords, my lords, now and in pursuant to the final order passed in the writ petition, which was challenged by the respondent number 2, challenging the order of the family court, she had come down to Bangalore on 11/10/2024. That day, my lord, she created ruckus in the house and then she leaves. Photos, my lords, my lord will find it at.
Then photos of ruckus, huh?
ಇಲ್ಲ ಇಲ್ಲ ಅವತ್ತು ಆಯ್ತು ಪೂಜೆ ಎಲ್ಲ ಇದು ಸೆಲೆಬ್ರೇಟ್ ಮಾಡಿದ್ದಾರೆ ಮಕ್ಕಳು ಮಗು ಜೊತೆ. Then she on 21st, 10 days thereafter, she comes and files a complaint saying that I was assaulted, the child was assaulted. That is what has been impugned, my lords, before this honorable court. That, my lords, page number 192 for a moment. Sorry, page number 218 for a moment. 218. ಮಗುಗೆ ಅಸಾಲ್ಟ್ ಆಗಿದೆ, ನನಗೆ ಅಸಾಲ್ಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. Kindly look at the photographs, my lords. He has enjoyed the time with the father and the grandparents. Only to circumvent, my lords, the visitation orders and, my lords, the transfer petition is listed tomorrow before the Supreme Court. She has filed an affidavit, my lords, saying that my life is at threat because of the complaint that was filed before the Sadashiv Nagar on 21st, the impugned FIR. Page number 220, 221 onwards. And more so, page number 224, my lords, 224 and 225. She repeatedly called me, my lords, video call and voice call. She has had interactions with me. 10 days thereafter, she comes and she files the impugned.
What is the date of this video call?
Everything is on 11th of October, page number 225.
Complaint is also on 11th of October?
21st. She travels back to Gwalior and then comes back on 21st, files a complaint. And which are, in fact, my lords, the Honorable High Court page number 197, observes the bond that the child has with the grandparents.
The petitioner is the husband, first petitioner is the husband of the second respondent. The second respondent and the husband have plethora of proceedings pending against each other. The present issue brought up by the husband
16.
is a crime registered against him by the second respondent wife. On 21/10/2024, alleging a particular incident that happens on 11/10/2024. The complaint is registered after 10 days. The learned counsel for the petitioner takes this court through the documents appended to the petition to demonstrate that the wife comes down to Bangalore on 11/10/2024, celebrates and takes part in all the festivities along with the son,
Only
and
child.
has produced
Only child.
along with the
Magu
child, all right.
ಅವ್ರು ಬಂದಿರ್ಲಿಲ್ಲ. It was
Only
only
child.
Only
Ah.
child celebrated with father and grandparents.
Also, ಹಿಂಗ್ ಮಾಡಿ ಬನ್ನಿ. On 11/10/2024, it transpires that the child has celebrated the festivities with the father and has produced certain photographs to demonstrate that the child was happy spending those festivities with the father and the grandparents. The complaint is registered, custody order ಯಾವಾಗ ಆಗಿರೋದು?
Custody 15/7/2024, final
The
by consent
learned
of both
counsel for the
parties.
petitioner submits that the wife has registered the subject complaint only to overcome the order of custody that was passed on 15/7/2024. What is pending before the Supreme Court?
Transfer petitions.
The learned counsel would further submit that the wife has preferred transfer petition before the apex court, seeking transfer of the proceedings to the court at Gwalior, where the wife resides. The matter is pending consideration before the apex court. The prima facie, the wife registration of the complaint by the wife appears to be to get over the custody that is directed by the division bench,
Single bench.
by a coordinate bench of this court.
I filed
A
contempt.
perusal at the complaint dated 21/10/2024 would in no way indicate that there is threat to the life of the child. If that be so, the complaint ought to have been registered that very day or the next day at best, not after 10 days after the alleged incident that has happened, on 21st October 24.
11th October.
11th October 24. Therefore, there shall be an interim order of stay of further investigation in crime number so and so till the appearance of the wife. 1 additional SPP, 2 emergent notice.
It's hand delivery of,
Return of
because matter is listed tomorrow before the
Supreme Court. ಇದು ಮುಗಿಸಿದ ತಕ್ಷಣ ಹೊರಟ್ಬಿಡಿ, ಆಮೇಲೆ ಯಾವುದೋ ಒಂದು ಟೈಪ್ ಮಾಡಿ ಇಟ್ಬಿಟ್ಟಿದೆ, ಅಪ್ಲೋಡ್ ಮಾಡಿಸ್ತೀನಿ.
grateful.
Number 2, Shimeuddin
Arun,
Obliged.
you are not audible at all.
Yes, my lord. I'm sorry, Lord. I will.
ಅದಕ್ಕೆ
I'm just
ಆಫೀಸಿಂದ
trying.
ಅಪಿಯರ್ ಆಗಬಾರ್ದು.
Sorry.
Yes.
Grateful.
Mayur D. Banu.
To the petitioner. My lord, FIR comes to be registered under the NDPS Act.
NDPS.
Yes, my lord.
ಈಗೇನು ಅರ್ಜೆನ್ಸಿ 2ವರೆಗೆ?
My lord, the issue here is, my lord, the FIR comes to be registered against 8 persons, my lord. Under the 8,
Accused 23.
23 and 69, my lord, my lord, the charge against me is only for consumption. My lord, the test is conducted during the investigation. I have assisted the investigation, my lord. The investigating agency chooses not to arrest me, my lord. Subsequent to that, after the charge sheet is filed, my lord,
Charges consumption ಅಂದ್ರೆ 6 months.
Allah, only is asking for quashing of NBW.
only the NBW, my lord, nothing else.
NBW,
Matter is covered
But
by,
what they have done, my lord, is that without issuing summons, my lord, warrant comes to
matter
be
is
issued.
covered by Satyendra Kumar Attorney case, where summons should have been issued.
My lord, and in fact, I approached the trial court, my lord, under an 88 application under
All right.
Tahsildar's judgment.
Additional SPP is directed to accept notice for the respondent. We will dispose it next time. I'll list it on Friday. List the matter on Friday in the fresh matters list. Till such time, warrant of any kind hanging on the head of the petitioners shall remain stayed.
Lord, a humble request next Friday, my lord, kindly. I'm not in town this week.
It can be disposed of.
Family emergency, man.
Dispose ಮಾಡ್ಬೋದಾ? ಏನಿದೆ?
out from it.
Until judgmental.
2021, 10 SCC 7.
My lord, I've even enclosed the judgment of Tarsem Lal. Tarsem Lal of
Same
2024.
following until,
Yes, my
yes. Dispose on the
Grateful, my lord.
Lord cost,
Grateful.
yes. Next to the madam. Karpudi. 7 ಆಮೇಲೆ 17 ಇಂದಲ್ಲ.
Continue. Number 2. 18.
Humble submission, my lord. Apologies, my lord. I'm off a hand delivery, my lord. Kindly, my lord. Warrant is pending.
Yes.
Grateful.
A disposal and hand delivery illa.
Please, the order may be uploaded so that. the
Not
police are-
today, tomorrow.
Grateful. Grateful.
Yes. In disposal you hand delivery start maಡು. Yes, next.
Number 18.
Sushil Shankar.
My lord, I appear for the respondent number 1, my
Interim
lord.
order idea, madam. Just after 4 weeks, interim order stands extended to the next date of hearing. Next.
Obliged.
19, interim order idea.
Applying for the petitioner.
19.
Interim order idea.
Interim order in respect of the 1 and 3 is there, my lord. In respect of the 2, my lord. Is
Interim
the
order-
delay in complaint, my lord, or SC/HT Act, my lord, they have invoked.
Interim
my
order
lord,
stands extended till the next date of hearing.
Kindly, your lordship, because
Just
in
after
respect
2
of the
weeks. Yes, next.
respondent number 2, petition number 2, my lord, because delay in complaint, my lord.
All right. Yes.
Initially 3 to, day after
Yes, Monica,
tomorrow, my
madam.
lord, I will convince your lordship, because regarding the, my lord,
2 weeks bit early, yes.
kindly date may be, my lord, otherwise it won't.
5th
Kindly,
December. Yes, next.
kindly, your lordship, because 28/11 is next date is there, my lord, in the plea it is on
27/11.
15/11. yeah.
27/11.
Ma-
Next. Vacating stay.
20 for the petitioner, my lord.
I am for the respondent number 2, my lord.
ಇಷ್ಟೊತ್ತಲ್ಲಾಗಲ್ಲ.
ಅದೇ.
ನಾಡಿದ್ದು ತಗೊಂಡು ನಾಡಿದ್ದೆಲ್ಲ ಗುರುವಾರ ತಗೊಂಡು
Please, my lord.
list on Thursday under the caption hearing on interlocutory application.
Please, may I request for
Interim order
extension.
subsisting shall continue to the next date.
Grateful.
So in this case, they have not filed the entire charge sheet, my lord. Only head of the charge sheet they filed.
We
Hidden
have
charge
filed
sheet.
the entire charge sheet.
Yes, my lord.
What charge sheet?
Entire papers they have not filed, my lord.
The hidden charge sheet.
Head of the charge sheet.
Head of the charge.
One sheet they have filed.
ಆಯ್ತು ಸರಿ. ಯಾಕೆ ಮೇಡಮ್?
My lord, we have filed it. It appears compliance set may not be served. I'll have it served.
Thursday.
Please.
21.
Filling a memo for withdrawal, my lord.
Thank you, sir.
Reserve the
Before
liberty
we
to
take
file a
it.
fresh petition, my lord. Reserve the liberty to file a fresh petition, my lord.
Why? Charge sheet
Charge sheet has been filed.
same format. Yes, next.
Okay.
Ravindranath.
22.
But in this case, my
Goka.
lord, is doctor, my lord, by profession is a my lord, a liver transplant surgeon.
Liver transplant.
Yes, my lord.
ಸರಿ ಏನೀಗ?
My lord, there is the complainant is also my lord a partner of this one Dara Health Hospital in running in Yelahanka, my lord. There is a partnership deed has been
This day
distributed.
after tomorrow in the fresh matters list.
There is a threat of my lord, filing the charge sheet, my lord.
Don't worry about
No, no, my lord. Till
Don't worry about that, sir.
Sorry.
Day after tomorrow in the fresh matters list.
Obliged.
Submission not in the serial number 22. Not the, in respect of the second respondent, the notice not yet ordered,
Not yet ordered.
not yet ordered.
ಮಾಡ್ಬೇಕಾ?
I may be permitted to take out notice and
Take out notice ಯಾರ ಮೇಲೆ?
second respondent.
Sir, you may be permitted to appear for the second respondent. Take out notice and then. Yes. Learned counsel so and so undertakes to enter appearance for the second respondent registry to print so and so. List the matter day after tomorrow in the fresh matters list.
Copy is also been served.
Yes.
But in this matter, my lord, may make a small submission.
ಈಗಿಲ್ಲ.
All
ನಾಡಿ
our doctors,
Thursday.
they collected the.
Sir, all our doctors, Wednesday. Yes.
They have,
All our doctors.
no, no, no. Matter.
Matter Wednesday.
Wednesday. Please.
Wednesday and Thursday ಯಾವತ್ತು ಮಾಡಿ? Wednesday. All right, Wednesday. Yes.
Obliged.
23.
For the petitioners, my lord.
ಏನಿದು? Further investigation.
Further investigation.
Criminal petition forwarded to ಇದೆ ಇಲ್ಲಿ. It's a very peculiar case where the petitioner has, the complainant has filed a civil suit and then she files a complaint after the mediation fails.
Yes.
Kindly have the matter on Monday or Tuesday, my lord. Monday or Tuesday.
Another day. List the matter on Tuesday, 12th.
Much obliged.
My lords, in the connected matter 482 petition, I have filed NOC Wakalat for respondent number 2.
Registry to print the name of Preeti, right?
Please.
Preeti is appearing for the second respondent in place of Beena PK. Yes.
That's only your lordship has last occasion. The freezing of the account has been.
Correct, both stayed.
That is.
Madam, ಅದು 22 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಏನಿದೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ ನೀವು ಹೊರಡಿ. ಹ್ಯಾಂಡ್ ಡೆಲಿವರೀಸ್ ಟೈಪ್. Madam, don't call further hearing. Take that Sandesh Chowta mat 7A. 7A. Sandesh Chowta ಹೋದ್ರಾ? Yes. Others need not wait. ಎಲ್ಲ 7A ಇರೋದು. Hear ಮಾಡ್ತಾ. If you want to stay, you stay.
I will stay.
My lords, number 16.
ಏನು
I am appearing for R2, my lord.
ನೀವು ಲೋಕಾಯುಕ್ತಕ್ಕೆ ಅಪೇರ್ ಆಗ್ತಿದ್ದೀರಿ.
ಇಲ್ಲ 16 second list.
ಏನು ಏನಾಗ್ಬೇಕು?
The first matter, my lordship, the crime taken place by my lordship Majar was conducted.
ಯಾವತ್ತಿಗೂ ಹಾಕಿದ್ದೀನಿ. ಸ್ಟೇ ಕೊಡಬಾರ್ದಾಗಿದೆ. ನೀವೆಲ್ಲಿ ಮತ್ತೆ ಇರ್ಲೇ ಇಲ್ಲ.
Total 1
ಕಾಂಟೆಂಪ್ಸ್. ನೀವಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡಕ್ಕಲ್ಲ, ಈಗ ಅವ್ರು ಇಲ್ವಲ್ಲ. ಕಂಪ್ಲೇನೆಂಟ್ ಪ್ರೆಸೆಂಟ್ ಅಂತ ಬೇಡವಾ? ನೀವು ಹೊರಡಿ. ಇಲ್ಲ ಇವ್ನು ತೋರಿಸ್ಬಿಟ್ಟು
a date will fix.
ಯಾವತ್ತ ಕೊಟ್ಟಿದ್ದೀನಿ ನಿಲ್ಸಿ.
Because police officers themselves are the eyewitness.
ಅದೊಂದು ಯಾವತ್ತು 4 weeks ಆದ್ಮೇಲೆ ಒಂದು ಡೇಟ್ ಕೊಟ್ಟಿರಿ ಮೇಡಮ್. ಡೇಟ್ ಕೊಡುತ್ತೆ. ಎಸ್ ಚೋಟಾ ಸರ್.
With my lord's permission, serial number 23, there's an interim order which has.
That will continue. ನೀವು ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಮಾಡ್ಬಿಡಿ.
Yes.
5:30. All right.
Well, it's before I commence with the reply to what has been contended. My lords, the comparison which I had
PV
given.
Patil is complete. Latif, ನೀವು ಮುಗಿಸಿದಿರಲ್ಲ? ಇಲ್ಲ. ನೀವು ಮುಗಿಸಿದಿರಾ? ನೀವು ಮಾಡಿಲ್ವಾ?
ಮಾಡಿ.
ಮಾಡ್ಬೇಕಾ?
The same lord, I'll give the replies.
ಭಗವತ್ ಸರ್ ನಿಮ್ದು? ಅವ್ರದಾದ್ಮೇಲೆ ಮಾಡ್ತೀರಾ?
So my lords, I had given a comparison and synopsis, my lords, comparison of 7. My lords, just have that for a minute, my lords. One aspect, probably.
Points for consideration.
Just before the points for consideration, one comparison of section 7 is there, my lords. In that, the comparison, I'd put 4 points for comparison between the old act and new act. One aspect which I have left out is, my lords, under the old act, the usage of the word was gratification, my lords. Whereas under the new act, the usage of the word is undue advantage. This is the 5th difference that we get between those two. And points for consideration.
1 second. Madam, settlement ಯಾವ್ದ್ರ ಬಾಕಿ ಇದೆಯಾ? Waiting. Settlement ಯಾವ್ದಿಲ್ಲಲ್ಲ? Settlement ಯಾವ್ದಾರು ಬಾಕಿ ಇದೆಯಾ? ಯಾವ್ದು?
End of the list.
ನೀವೆಲ್ಲಿದ್ರಿ? ಕರ್ದಾಯ್ತು. Parties are there?
Yes, ma'am.
Doctor sir, 1 ನಿಮಿಷ.
Yes, please.
Parties are there. Why should they wait? Offense ಏನು?
498, ma'am.
Complainant?
Yes, my lord. Present, my lord.
For the respondent, my lord.
What's your
I
name?
need to wakalat for the respondent.
What's your name?
Tejashwini.
So and so. Undertakes.
Hello. Settlement only against accused number 2, 3, and 4, my lord.
2, 3, and
4. Except husband, my lord.
Husband, all right.
Don't have any objection to them.
Yes. Learned counsel appearing with complainant. So and so appears with the complainant registry to print the name of so and so. The the settlement deed.
Minus, sorry, ma'am. I mean,
ಕೊಡಿಯದು.
joint affidavit.
Except husband. Matter is settled quay all other accused except accused number 1 husband. ಅಂತ ಕ್ಲೋಸ್ ಮಾಡಿ. ನೀವ್ಯಾಕೆ ಹೋಗಿಲ್ಲ ಇನ್ನು? ನೀವ್ಯಾಕೆ ಹೋಗಿಲ್ಲ ಇನ್ನು? All right.
Much.
Husband is not party.
No, husband is
Only
not.
accused number 2. Yes.
Order sheet signature.
Yes. Yes, sir.
Well, it's in that points for consideration, my lords.
Vice Prasanth Kumar sir.
About
ಬೇರೆ ಇದೆಯಾ? ಇದರಲ್ಲೇನಾ? Yes.
in that points for consideration, my lords. My lords should notice the points for consideration out of the 9 points that we had pointed out. Probably, my lords, reply had not been given for the second point, proof of demand at this spot. Then, my lords, no post-paid concept under section 7. They didn't touch upon that. Then can there be an offense under 7A on a failed trap? This third one. And the fourth is, my lords, reverse trap. Offense under 7A under the reverse trap. And finally, trap laying officer to ascertain alleged demand before he commences the proceedings.
Sir, one clarification.
Yes.
All these points that you have said, you give me those petition numbers which have each of these issues.
With each of this.
Each of these, ಎಲ್ಲ ಒಂದರಲ್ಲಿ ಇರಲ್ಲ.
In my understanding of the 60 matters that are there in the batch, my lords.
No, ಅದರಲ್ಲಿ ಒಂದೊಂದು ಕೊಡಿ.
ಹೌದು.
ಅವಾಗ ಏನಾಗುತ್ತೆ,
It
I can
becomes-
tag them all and write all this and then say if it is covered, not
Because I think
covered,
my lords is
whether I
consider-
accept your
Yes, my lords.
submission.
My lords is considering all these legal submissions in 20793.
20793 ಆಯ್ತು. But
Lead case.
ಅದೆಲ್ಲ ಇದೆಯಾ ಇದರಲ್ಲಿ?
ಇಲ್ಲ.
Ah,
ಎಲ್ಲ ಇಲ್ಲ. ಎಲ್ಲ ಇಲ್ಲ.
See, ಒಂದರಲ್ಲಿ failed trap ಇದೆ.
ಹೌದು.
You choose one petition.
No demand in one, no
One.
acceptance,
In one.
failed trap,
Failed trap, returning of the amount,
reverse trap.
the reverse trap,
Yes.
ಅದೆಲ್ಲ ಯಾವ್ಯಾವ್ದ್ರಲ್ಲಿದೆ,
ಅದ್ ಮಾಡಿ.
ಒಂದೊಂದು petition each.
It becomes easier, I get.
ಅವಾಗ ಏನಾಗುತ್ತೆ, if I tag them, I can answer them together.
Please.
Whether I accept it or
Or
not
no.
is a
Yes,
different
I
thing.
do it.
Got it, madam? Give the numbers, ಆ ತರ. Yes. ಆ numbers ಕೊಟ್ರೆ, then each of the issues, just a sheet I'll prepare.
Yes,
ಮಾಡ್ತಾರೆ. That's
I will give it. I will.
I'll tag them. Yes.
Because I think so far as we are concerned, about 7 matters we have.
ಅದ್ರಲ್ಲಿ ಏನೇನಿದೆ ನೋಡಿ.
I can.
ಅದ್ರಲ್ಲಿ ಕೊಡಿ. ಇಲ್ಲ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಯಾವ್ದ್ರಲ್ಲ ಇದ್ರೆ, in which this, if you have seen the synopsis of Sandesh Chowta, ಅದರಲ್ಲಿ ನಿಮ್ದು ಯಾವ ಇಶ್ಯೂ ಕವರ್ ಆಗುತ್ತೆ, ಒಂದು petition number ಕೊಡಿ ಸರ್.
Failed trap, serial number 34.
ಆ failed trap ಅವ್ರದ್ದು
Failed
ಇದೆ ಒಂದು.
Then Nandu.
So we'll, yes, my lords, we'll just call it.
That's all. Yes, now you can carry on.
Now, my lords, both Mr. B.B. Patil and Arbati have elaborately argued, my lords, on their contentions. Initially, my
B.B.
lords,
Patil, yes. Arbatti has some point.
very interesting point. my
Very
lords. That's why, my lords,
important point Arbatti has put forward.
what I intend doing is, my lords, first I'll
You
give
may
my,
have to get over that.
I'll first give my
Yes.
reply,
Ah.
Mr. Arbati's argument,
Yes.
and then I will come to the reply to Mr. B.B.
Those
Patil's
are
argument.
formidable objections.
My lords, my understanding of the 4 points raised, my lords, 4 important points raised by Mr. Arbati is, first one is regarding the object of 2018 amendment
Yes,
and the illustration under section 7,
yes,
which was not there in the old act.
yes,
How should it be construed?
yes.
This is point number 1, my lords.
Yes.
Secondly, my lords, this particular illustration which is there in the amended act, it is below an explanation, my lords. So how should the illustration be read in terms of the explanation? Third aspect, my lords, whether the acceptance has to be necessarily by the public servant or can it be through another third party? And the last, my lords, which is a common submission of both Mr. B. Patil and Arbati is, demand by itself can constitute an offense and there need not be acceptance. These are the 4 points, as I understand, of what Mr. Arbati has argued.
Yes.
My lords, the very first aspect is, now under an interpretation of a statute, how would illustrations and explanations be construed? That will be the most important aspect
Yes.
because their reliance.
No, that is an aid if there is any ambiguity about the statute.
So normally, my lords.
Note, footnote, explanation, illustration, all are subservient to the statute. If
So,
the
my
statute
lords-
generates any ambiguity, then
Then we
those
fall
things.
back on that. They are aids for the purpose of construing a statute, but they are not part of the statute.
But they are internal aids.
Internal aids, but
Yes.
they are not part of the statutes. That will
Two.
be most
See,
important.
there are two in interpretation, one internal aids and external aids.
Yes, my lords.
Now, these are internal aids in an interpretation of a statute where you can fall back upon if there is
If there is ambiguity.
slight ambiguity,
lords.
even in the slight ambiguity in the statute.
So normally, my lords, my understanding of a statute would be,
Yes.
there'll be 7 essential aspects to it, my lords. Starting with the heading.
Yes,
The heading, the actual statute itself,
yes,
the punctuations in that statute,
yes,
the proviso therein, and then we have the explanations, we would have the illustrations, we have a marginal note.
Hmm.
So, my lords, these are 7 things normally we get in a statute.
yes.
Also, my lords, there are other things like saving clause and interpretation clause,
That's
which we need
later.
not worry. Of these 7, my lords, in my respectful submission, when we say what is a statute, it would be the actual section plus the proviso and punctuations. The remaining, my lords, whether be the heading, the explanation, the illustration or marginal notes, they're going to be aids, as my lords put it. If there's going to be any ambiguity to the section itself, then we fall back on the aids to see what exactly is the object behind it.
But all these internal aids or external aids, they can't control the statute.
They don't. They can't control the statute. That's
That statute, the purport of the statute would run. Only if, only as we said, only if there is ambiguity, then these things would stand.
absolutely.
Yes.
Similarly, my lords, when we also look into an object, now, my lords, we look into the object to see what the legislator intended. Now, if the object is not going to be definite, my lords, but is going to be general in nature, I will just point out the difference between the two, my lords. When we say, if it is for the purpose of...
If you're falling back upon the intent of the statute, then that also will not take you far because the content of the statute is important.
Absolutely. So here, my lords, when we say 2018 amendment which took place, because little emphasis was given to say what is the object behind that amendment, mainly to say eradication of corruption. But my lords, if the actual object was touching upon section 7 to say we are doing this for the reason that we want to make demand by itself an offense or acceptance by itself an offense, then my lords, we can fall back to that object to say this should be read in furtherance of section 7.
Checks and reasons he has said, but they may not have complete bearing on the purport of the statute. It is only the intent to bring in that amendment.
Yes, my lords. Here the intent seems to be a further eradication of corruption. That appears to be the intent, but the intent is not to undo an interpretation given to section 7. That is where I will have to come down to, because, my lords, the difference between what we get in section 7 as it stood under the old act and how we see it under the new act is not great, my lords. What was a consolidated section 7 is broken up to 7 ABC. Now the addition is that illustration. Now, as we have discussed, my lords, illustration part of it doesn't form part of the statute to that extent, my lords. So it doesn't control the statute. At any point of time, then it is going to be ambiguity, you fall back on illustration, because a lot of emphasis was given on that illustration, my lords. So, my lords, I'm relying on two decisions. One on the aspect of saying illustration is not part of the statute when you are going to take aid of illustration. Second is explanation itself is not part of the statute. These two, my lords, only the relevant paragraph. I'll just, I'll not, give it. Please notice only that relevant paragraph, my lords. The first is Lalit Mohan Pandey versus Puran Singh. The relevant paragraph is paragraph 75. My lords, it's flagged in this side, my lords, relevant paragraph 75. So this judgment deals with illustration, my lords. Paragraph 75, page 20. Only paragraph 75 and 76 deals with that.
Yes.
So, my lords, it says illustration appended to the rules does not envisage such a situation. Illustrations, although are of relevance and have some value in the construction of the text of this section, but cannot have the effect of modifying the language of the statute, and they cannot either curtail or expand the ambit of the statute. This would be it, my lords. So now if the illustration is sought to be used to say, read the illustration in such a way to make demand by itself an offense, that cannot be done would be my respectful submission, my lords. Now, my lords, insofar as explanation, the next judgment, my lords, which is at page 24, 2023 SCC Online, Supreme Court 640, the relevant paragraph, my lords, is paragraph 50, which we get at page 39. 50 to 52. I've just highlighted, my lords. Ultimately, at page 43 and 4, what an explanation and clarification would be. Now, in my respectful submission, this illustration that we see here is neither going to be an explanation, nor is it going to be a clarification to take away the effect of what the old section 7 was. So, my lords, with these two aspects, my lords, 1 minute, my lord, sorry, 52.
51, 50, 50 to 52.
52.
Yes.
So if the illustration, my lords, is going to be below an explanation, if my lords would now kindly notice the section itself as to how the illustration has come in this section. This illustration is going to be restrictive to that explanation under which it has come. If my lords would kindly have the act for a minute, my lords.
Yes.
My lords would notice that two explanations given below A, B, C. Now, explanation one, which is most relevant for our purpose, my lords. For the purpose of this section, the obtaining, accepting, or the attempting to obtain an undue advantage shall itself constitute an offense, even if the performance of a public duty is not done. Sita Soren, 7 judgments.
That's one thing. This explanation has some importance. It cannot be read in isolation. It has to be read in tandem with A, B, and C.
Absolutely. So, my lords, demand.
Like every other explanation which would not aid the main statute, here it does aid.
So, my lords, what this explanation does is, irrespective to whether the public duty is done or not, if the ingredients are there of demand and acceptance, it's an offense. This is what this explanation does. And this is exactly, my lords.
No, the Sita Soren says that performance of due for work pending or performance of particular work is immaterial.
7 judgments based on this explanation. Please notice, my lords, that's why this explanation, it doesn't take away the need of the ingredients of the offense of demand and acceptance, but takes away the effect of a public duty not being done. Exactly what Sita Soren says. Now, below this explanation comes this illustration, my lords. Now, this because, my lords, we have another explanation after that.
Yes.
So, each illustration that comes is to be read in accordance to what it's trying to illustrate, my lords.
No, that is qua the explanation.
Qua the explanation. Please now, my lords, what was
So
read?
every illustration that is appended to an explanation is qua that explanation.
My lords, that is the illustration which they're relying on. That illustration which they're relying on, my lords, now saying in this illustration, it makes demand by itself an offense. This is how the interpretation is sought to be made, which, my lords, in my respectful submission, would not be the actual interpretation of this explanation. The explanation says, an illustration is given. Explanation says public duty, irrespective of it, the ingredients, if it's there, he is liable to be punished. The illustration should be read in accordance with that. You can't now take that illustration, read it a little out of context to the main section of 7A, B, C. My lords, what here becomes most relevant is, my lords, 7A, B, C also uses the word attempt. The old section 7 used the word attempt. My lords, old section 7 on its interpretation, my lords, whether it is going to be Niradatta 1, 2, Shantama, they say on the reading of section 7, the essential ingredient or what is required as sine qua non would be demand and acceptance. So as it stands, my lords, demand and acceptance are two essential ingredients to constitute the offense. Now the new section 7, my lords, post-amendment does not take this away. It remains the same. So this is where, my lords, if the intention is to undo an interpretation given by the apex court or to redo a statute from how it stood, then, my lords, the foundation has to go. The whole reading of that section will have to be to the nature of saying demand by itself is an offense punishable under so-and-so. Acceptance by itself is punishable by so-and-so. Now, on this aspect, my lords, how it is to be interpreted, if the legislation wanted to take away the effect of both section 7 and that of interpretation, my lords, one judgment, my lords, which in this compilation, the third of the judgments, how you will have to go and take away the base of the judgment. Otherwise, it would not aid them at all. Now, kindly notice page 42, my lords. Word element. And then the intention also wasn't so. Hag madidre. My lords, kindly notice, my lords, page 42 only, when they want to do it. If the legislature really felt that we'll make demand by itself an offense or acceptance by itself an offense, page 42, how do you take away the base of an offense? Page 42, relevant portion, my lords, paragraph 77.
Barul Islam.
I'm sorry.
Barul Islam.
77 page 114 only, my lords. That one paragraph may be noticed. Now, whether is this what has been done in the present amendment to section 7? Absolutely not, my lords. They have retained what the original 7 is. The intention is never to take away the effect.
Post-amendment, Supreme Court has interpreted 7 ABC.
Because the four judgments that we have,
All are pre-amendment.
all but post-amendment are coordinate
No,
benches.
post-amendment, amendments are delivered, facts are pre-amendment.
Pre-amendment, correct, my lord. So that's why they saw and they also in the judgment say how the present section reads, though they didn't interpret it. They say how it reads to that extent. But all the coordinate bench judgment and my lord's judgment is on 7A. Now, my lords, one aspect is very clear, my lords. Both old 7 and 7A does not read differently, my lords, except for that breakup of A, B, C. And these 5 differences which I have called out to say what are those minor differences. But I think the most important aspect is attempt was there, attempt is there here. Interpretation is, though it is there, demand and acceptance sine qua non. This would be the interpretation, my lords.
So the sine qua non has not changed.
No, it has to be read like that unless it's taken away, my lords. If legislature in clear terms had said demand by itself is an offense, then you can say the base goes. But this is not so. Now, if it remains like how it was earlier, the interpretation has already been done by a constitution bench, my lords. 88.1, though, my lords, they were pointing out 88.4.
No, that Neeraj Datta has clarified.
Both ways, even 88.1, the constitution bench first starts by saying both for section 7 and 13, demand and acceptance are sine qua non. In Neeraj Datta 1, the constitution bench. Then little more clarification given in Neeraj Datta 2. So, my lords, this is insofar as the interpretation is concerned, my lords. So, my lords, probably the two very vital contentions of Mr. Arbatti on the aspect of illustration, this would be my answer to it, my lords. It would not aid him at all, would be my respectful submission. Now, coming to his third submission, my lords, he would say whether the acceptance has to necessarily be by the public servant himself or by the third party.
Somebody else.
My lords, in my 9 points, I have not raised this at all. The section itself makes it clear it could be through a third party. Old section 7, my lords, they use the word for himself or for any other person. Old section 7. Post amendment, again, explanation 2:1 says for himself or for another person. And explanation 2 there says obtains advantage directly or through a third party. So, my lords,
So that's
it is not my contention at all. The last of it would be, my lords, demand by itself whether it constitutes an offense punishable under section 7. This is a common argument on behalf of both B.B. Patil as well as Mr. Arbatti. So, my lords, this is where I made a submission. If at all, my lords, the legislature thought it fit that they would make demand by itself an offense, then the whole section 7 had to be redone, which is not their intention and which is not their intention to undo an interpretation given by the Apex Code. Now, if that is so, my lords, at present, as it stands from the various interpretations, demand and acceptance remains sine qua non for an offense to be committed. These are the basic ingredients that are required for it. So, my lords, otherwise we'll virtually be undoing Neeraj Datta 1, 2, Shantama and Soundarajan. We'll be undoing all the 4 decisions other than the coordinate bench rulings, including my lord's ruling where my lords has held it sine qua non. My lords, I think these are the 4 submissions of Mr. Arbatti. B.B. Patil, our submissions I'll deal with. My lords, 7 submissions that he made, 2 of which are common. The first submission would be, when would court exercise its powers under 482 CRPC or 528 of BNSS?
You want to labor on that?
Very elementary, my lords. I would say, ultimately, the main judgment when it comes to interpretation of either 561A, which was R.P. Kapoor versus State of Punjab, 1960, when it comes to 482, Bhajan Lal. So we always call it as locus classicus, my lords. We can't get a judgment better than Bhajan Lal when it comes to an interpretation of the inherent powers of the court. So, my lords, the reliance placed to counter these judgments is Neharika. Now, my lords,
Para 82 of Niharika was 15 postulates. Again, in reiteration of Bhajan Lal and nothing.
Totally, my lords, all that Neharika says is consideration of an interim order. Well,
no, that is 15 postulates at para 82. Yes.
My lords, in fact, my lords, in the compilation given by Mr. B.B. Patil, my lords, paragraph 22, page 67 may be noticed, my lords. They reiterate Bhajan Lal, R.P. Kapoor, Janta Dal versus Chowdhury, and all other judgments to say inherent powers are this. Neharika said interim orders when it can be granted or not. That's all there is to Neharika.
Repetition of earlier. It is not that rarest of the rare cases what is said.
So on that point, my lords, inherent powers, 4 judgments are relied on. All the 4 judgments, my lords, I'll be able to demonstrate would fall back on what Bhajan Lal says. So Bhajan Lal is accepted.
Muhammad Ali follows Bhajan Lal and says.
So my lords, to say that the court yavaga 482 exercise madbek, I won't labor too much, my lords, whether it's 528 of BNSS, 561. So that contention, my lords, according to me, whenever there's an abuse of process and to meet the ends of justice, and how the court would weigh it, reading of, in a trap case, my lords, reading of a complaint, reading of the entrustment and reading of trap mazer, if it does not have either of the elements of demand or acceptance, we would say, my lords, it's a case where interference under 482 is called for. This would be the submission. My lords, the next one, a very interesting submission made on foundational facts, my lords. The submission made is...
The POCSO and NDPS.
My lords, in the first place, what are foundational facts? My understanding of foundational facts are the ingredients of the offense constituting it is foundational facts. Now, when we talk about cheating, my lords, court will look at dishonest intention. Then on the basis of dishonest intention, the entrustment on the basis
from the inception.
Yes, my lords. And basis of entrustment, is there an element of deceiving a person, wrongful loss, wrongful gain? This is cheating. In breach of trust, it need not be from the inception. It can be from later, entrustment onwards. Similarly, my lords, when it comes to section 7, the basic ingredient to constitute the offense has been held to be demand and acceptance. That is the foundational fact. Now, if there's no demand and acceptance, my submission would be there's no foundational fact. The interpretation which is sought to be given is, no, foundational facts means even if he's present, that is foundational fact. No, a person's presence anywhere is not a foundational fact.
No, it's only a foundation, fact illa.
So that was the example given in saying, if he is there, ashtu sakagutte, baki the interference agbar 482 ali. No, my lords, that is not what it is. What element has to be seen is ingredient idya ilva, demand idya ilva. See the 3 documents, see your complaint, see your entrustment, see your trap master. If you are able to show that all demand is there, acceptance is there, then if it is not there, it's like...
Later on you see my judgment. Ella irutte. Ashte. Sakala.
Idರಲ್ಲಿ
ಮುಗಿತಾ?
ಇಲ್ಲ ಸ್ವಲ್ಪ ಅವರು ಹೇಳಿದನ್ನ ಒಂದು ಕೌಂಟರ್ ಒಂದು my lords, what is the effect now if you don't have an essential ingredient, my lords? Let's take for example there was no demand, but he gets arrested. Please look at the consequence of a person getting arrested without the ingredient being satisfied. One is his arrest, my lords. Then immediately what happens? Social stigma, not just for himself, family members also.
Suspension.
Suspension amele. Because they write, suspend madiyada ivaru bariyudu. So first what happens?
Aa jurisdiction el bantu ivarige.
Many of it are quashed, my lords, unless there's application of mind by the competent authority, independent application of mind. But I'm saying, my lords, in a
Bhagwat
case...
sir, the main argument adu. Lokayukta has no jurisdiction to recommend suspension.
My lords, probably even if they recommend independent application of mind to see whether it's a fit case for suspension, that is how the...
10-3, sir. KCSCCA 10-3, yes.
No, my lords would be aware of those rules much better than me, my lords. But anyway, my lords, when they said foundational facts, my lords, they relied on one judgment. With this judgment, my lords, in their compilation 2024 latest, Just Rights for Children Alliance versus S. Harish.
Sir, this is Abhay Hokar's.
No, my lords, this was by His Lordship Justice Chandrachud.
No, that is in re, is it?
My lords,
no, that is where the Chief Justice, the Honorable Chief Justice says, matters should not be settled, Child Marriage Restraint Act and all other...
Here what happened was
no, that
POCSO.
Is that the judgment?
My lords, this was on POCSO. My lords had last time pointed it out. Adರಲ್ಲಿ
POCSO settlement ಮಾಡಬಾರದು ಅಂತ
settlement ಇದಲ್ಲ. What happened is, my lords, foundational, ಇದರಲ್ಲಿ ಏನಾಗಿತ್ತಂದ್ರೆ pornography he had with him. The question was
Madras High Court judgment reverse murder.
Having child pornography.
67(2) of the IT Act.
My lords, when they say having pornography, that by itself does not become an offense under the POCSO Act, because POCSO Act's 3 very distinct penetrative section.
I had also written the same thing like following Madras High Court. I recalled my order and
then yes,
dismissed the petition.
I think Mr. Jagdish appeared in that.
2 days afterwards, I recalled my order.
Yes, my lords, this judgment deals with foundational facts. And this judgment makes it very clear what foundational fact is. Because, my lords, they said just having that pornography is not a foundational fact. It should be ingredient of the offense. My lords, in this judgment, paragraph
No, that is
171.
on a different footing that you can't. Foundational facts to that case, yes, is a different aspect.
My lords, foundational.
There, if having pornographic material in the mobile phone or viewing the pornographic material, not circulating it, would also amount to an offense, is what is said.
My lords, no, I'm sorry, my lords, subject to correction. In this, my lords, they said that having that material would not be an offense under the POCSO Act.
Under 67(2), it's an offense.
That's different.
Yes.
POCSO Act alli, they say, my lords.
POCSO Act baralla.
But adike, if my lords has this
No, it's
compilation.
all right. Look at section 11 of POCSO. There are 5 ingredients of section 11 in
Where
POCSO.
even you circulate it.
Circulated.
Circulator, I think they use the word.
You see clause 4 of section 11 of POCSO.
POCSO. I think they.
When you're referring to
virtually
POCSO,
my lords even felt viewing it.
POCSO could.
They use the word.
Madam.
Not circulation.
Sandesh sir, POCSO
I think Mr. Jagdish, which is that word used in that section? Other than circulation, even if you have it with you.
67(2) alli. POCSO la.
Which is that word?
Section.
Broadcast la.
Section 11 alla. See section 11, there are 5 subsections in that.
Watches at 4.
Ah.
Repeatedly and consistently follows and watches.
Watches.
Watches. My lords, or contacts a
If
girl,
you are
either
having that material with you, you are presumed to be watching it.
I get it, my lords. My lords recalled the order on that basis. So, my lords, in this case, my lords, they dealt with this foundational facts. Paragraph 171 to 175. Just, my lords, they deal with what is considered as foundational facts. So, in my respectful submission.
Next point.
One more judgment which they relied also, my lords, which makes it even more clear that foundational facts are the basic ingredients constituting the offense. My lords, in Rajiv
No, that is rudimentaries. Foundational facts, there should be basic ingredients that would constitute the ingredients of a particular offense.
My lords, to that extent, if I'm able to convince the court, because that is not their argument. Their argument is whatever we say is foundational fact. Then 482 ಅಲ್ಲಿ interfere ಮಾಡಬೇಡಿ. That is not how it is viewed. You show how the ingredient is there, then you can say no interference. But not by saying a person was there. That is my foundational fact, and you. So that is the aspect on the foundational fact, my lords. My lords, we have also produced as our 4th judgment, Prem Prakash versus Union of India 2024 SCC online. In today's compilation, my lords, I have marked it also and kept. Same on foundational fact.
Yes.
My lords, next argument was demand by itself. Same argument as done in the other one. My lords, it will run afoul to all the various decisions, 4 decisions of the Supreme Court. Similarly, my lords, they also say a mere attempt. Attempt again, my lords, we fall back on the 4 judgments because they dealt with it. Then, my lords, section 20, legal presumption. My lords wanted to know the difference between rebuttal to a legal presumption and reverse burden.
No, that is when you are returning the amount.
Allah, presumption. My lords, they use section 20 as a presumption to say because of a legal presumption, interference should not be there. My lords, this was the argument. So my lords also pointed out.
Reverse burden here.
My lord says there would be, in my respectful submission, between these two, what we get as a legal presumption and a rebuttable reverse burden, there's no much change, my lords. It all comes out of the statute. Now, under section 20 of the POCSO, or my lords, section 20 of this act, which we are now PC Act. My lords, when we talk about a reverse burden, it means the foundational facts you lay, burden comes to me. On the basis of preponderance of probability, I give a probable defense. The burden shifts back to you. You prove it beyond reasonable doubt. This is how legal presumption is taken. And for that, foundational fact will be demand and acceptance. That's the first aspect. You do it, I may give a defense, then the burden shifts. So we don't need a full-fledged trial to go into the aspect of section 20. And sorry, my lords, one more aspect about section 20. One more important aspect of section 20 here is that legal presumption, the presumption is once the offense is complete, the presumption is it was towards reward. That's the presumption.
No, that goes now. No, reward or to work done is not there now.
My lords, 20, just for my own understanding, because legal presumption doesn't come at the starting point at all, my lords, in this. In this case, presumption comes, my lords, under 20. Please notice, my lords, initial portion they say, where in a trial of an offense under so and so, what is the presumption that has to be raised? The presumption is if the basic ingredients are pointed out, then it's presumed it is towards motive or reward. That's the presumption. Not an initial burden of presumption at all, my lords. Similarly,
Like POCSO or NDPS.
and NDPS
PM.
and 139 of Negotiable Instruments Act, same thing, including 106 of the Evidence Act. Facts within my personal knowledge, my lords, when they say they have to first prove that I was the only person with the deceased in that room. That's the first fact. Once they show it, then under 106, I have to give an explanation. Because, and then, my lords,
Mugita idea.
I think Mugita bantu, my lords. And my lords, judgments I've given on 20 also. My lords, this trap having no statutory flavor. Very interesting. Trap has no statutory flavor was Mr. B.B. Patil's argument. So, my lords, if it has no statutory flavor, what's your power and jurisdiction to do it?
ನೀವು ಮಾಡಿದ್ದಲ್ಲ.
B.B. Patil or what?
Sorry, B.B. Patil.
He said trap has no statutory flavor. Then how are you doing it? Where's your power and jurisdiction to do it? Which means all my 60 cases here where you've done trap, which has no statutory flavor, should fall.
No,
and my arrest.
No, trap has no statutory flavor, so don't entertain the petition.
Not my what my learned friend meant was, what my learned colleague meant was, does not have statutory flavor. ಮತ್ತೆ ಅದರಲ್ಲಿ ನೀವು 16ರಲ್ಲಿಲ್ಲ 17ರಲ್ಲಿಲ್ಲ 3ರಲ್ಲಿಲ್ಲ 7ರಲ್ಲಿಲ್ಲ ಅದಕ್ಕೆ ನೀವು ಟ್ರಾಪ್ ಇಲ್ಲಿಗಲ್ 482 ಕ್ವಾಶ್ ಮಾಡಿ ಟ್ರಾಪ್ ಮಾಡಿದಾರೆ ಕ್ವಾಶ್ ಮಾಡಿ ಅಂತ ಆತರ ಹೇಳ್ಬೇಡಿ ಅಂತ. Trap is not there under PCA.
Specifically.
Trap is not.
That is what my learned friend.
Trap is not defined under the act.
That
is all. When he said
but
like how cognizance is not
defined. So to say no statutory flavor is very dangerous for them, my lord. Then power and jurisdiction it goes to.
He did not mean that.
That is not what my learned friend.
And my lords, the next aspect is case of reverse trap. My lords wanted to know reverse trap only. Reverse trap basic ingredient is demand acceptance. Basic ingredient. Without that, only then return comes, my lords. So now we can't have a presumption that it is done on the basis of a demand and acceptance. It can't be there. That's a foundational fact. They should show there was a demand, acceptance, returning. So it again flows back to the very first ingredient, my lords, in a reverse trap. My lords wanted to know, can it not be presumed, inferred? No, my lords, it can't be done because it's the foundational fact. Then lastly, my lords, who's the last reverse trap?
Don't say last but not the least.
I think, my lords, with that, I have done a note, my lords. If it's required, I can pass on the note, my lords. On the basis of the reply itself, I've done it, my lords.
Anybody else? Bhagwat sir, day after tomorrow, same time, 5 to 5:30.
My lords, I'll provide that list also. We'll just prepare it, which case.
Prasanna Kumar sir, nimdu yavralli fit agutte nodkondu nimdu kodi. All this 7 issues and he has projected. In your wherever you are appearing, if all the 7 issues are there.
Illa, all 7 issues iralla, my lords.
Madam,
all 7 issues one case alli iralla.
Alla, all 7 issues one case alli illa. Neevu appear agtiro case galalli all 7 issues idre adu helbidi. ಇಲ್ಲರೆ ಭಾಗವತ್ ಸರ್ದು ಇರುತ್ತೆ, ಇಲ್ಲ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಸರ್ದು ಇರುತ್ತೆ. ಅವ್ರದ್ದು ಏನಿದೆ ಅದ್ ನೋಡ್ಬಿಟ್ಟು ನಂಬರ್ಸ್ ಕೊಡಿ ಸರ್.
Please. Oblige.
Yes. Day after tomorrow, ಭಾಗವತ್ 5 o'clock. ನೀವು ಮುಗಿಸ್ತೀರಾ? Day after tomorrow ಹಾಕ್ಬೋದಲ್ಲ.
My lords, one submission.
ಹಾಕ್ಬಿಡಿ. Yes.
Submission, my lords. Morning ಒಂದು ಮೆಮೊ ಮಾಡಿದ್ದೆ. ಮ್ಯಾಟ್ರಿಮೋನಿಯಲ್ ಡಿಸ್ಪ್ಯೂಟ್, my lords.
6:30 ಚೇಂಬರ್ಗೆ ಬರ್ಬೋದು.
ಸೆಟಲ್ಮೆಂಟಿಗೆ.
ಸೆಟಲ್ಮೆಂಟ್?
ಸೆಟಲ್ಮೆಂಟಿಗೆ. ನಾಳೆಗೆ ಸರ್. It was given for tomorrow, but ಅಲ್ಲಿ ಮೆಮೊ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ.
ನಾಳೆ
ಪೆಂಡಿಂಗ್ ನಲ್ಲಿ we couldn't find the memo.
ನಾಳೆ. Don't move at 5:30, sir.
ಮೇಡಮ್, ಒಂದೇ ಒಂದು ಅರ್ಜೆಂಟ್ ಮೇಡಮ್, 37 ನನ್ನ ಹೆಸರು ಡಬಲ್